Actually aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will
relevant.
bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Oh, getting commentary on the case. Dahil mihi Anglican police service Latino.
That's literally not true.
I didn't ask you to interrupt me.
Is that correct?
Oh, front seat.
Good morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. Good to have you here this morning. Happy Friday! Sorry, that's a little hot. It's a little loud. Try to save our ears for later in the day so we can listen then too. How's everybody doing this morning? Good morning. Good morning. Let's see, watching for any late ad birthdays because we are not singing for nobody today. Okay. We need birthdays. We need birthdays. All right, I'll turn on the chat switch. Thank you very much, Greeners, for that. I just need to fix this so that command works, so you can actually turn chat on and off. It's one of those days when we have no birthdays on the form. Well, we do have Anna's YouTube account, who is here first in chat, even though it was quiet, and you were able to type, "It's really quiet" with an emoji before anyone else said anything, which is impressive. Anna, you did absolutely great there. Congratulations for your promptness and punctuality. We're going to punish you with internet ownership. Everything IP-related worldwide is your responsibility. Good riddance. There we go. There we go. So happy Friday to you. Fran says, I stretched for nothing. Birthdays are accomplished. We're done. We did all the birthdays. We're done. Way to go. Well, this completes our test of birthdays today. So having sung to everyone and being complete, we will no longer be singing the birthday song in the morning. We're just going to start straight with court. Oh, Red Pen says, wait. There is someone. We have 4 people to sing to: Harmony, Kay, Leanne, and Tara, who is Yogi Kaz, whose birthdays are tomorrow. Happy birthday. And then we also have, what? Hang on. Then we also have tomorrow. Oh, Red Pen said no, not that one. No, that's Sunday. Okay, we'll sing to them on Monday. Does that work? Okay, that works. All right. Let's sing happy birthday to Harmony, Kay, Leanne, and Tara, and then we'll get our day started because we're going to be going to court in San Antonio, Texas, where the trial is on day 4 for us, I believe, and or part 4. Day 3, because we watched 2 parts in one day. But we're going to, we'll be down there in just a minute. So, let's see. Do I need to make the font? I'll let you mods fight it out in chat or in mod chat, whichever you prefer. But we have some singing to do, so wherever you are, if you're able and it's legal, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, and warm up with me if you will. La 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 la. That'll work. My mods are amazing, by the way. You're all incredible. Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, dear Harmony, Kay, Leanne, and Tara. That's Yogi Kaz. Happy birthday to you. Your birthday's tomorrow, but we're singing to you today. Harmony, Kay, Leanne, and Tara. I realize there are many wonderful days, but today of all days is your special day. And there are a million places you could have been and a million people you could have celebrated with, but you chose to be here with us. The privilege, pleasure, the honor, the joy, that is ours. Hopefully, we can return that joy back to you. Make your day just a little more special. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy's and Lum's House, Andy's Grill, Bob Evans, and Cracker Barrel. Sorry, I'm trying not to read the mod chat, which is hilarious. You guys are great. Happy Friday. Aren't we glad it's Friday? A nice laid-back day. Here's what I can promise. As long as there's no breaking news and no major events we have to cover, we're not going to have 51,000 people in chat like we did earlier this week. So it's not going to be the most difficult day of the week. And you won't have to read through 16,500 messages like you did on that day. So it's basically like the weekend's here already. Yeah, it's here already. Yeah, we had a busy day at the Corey Richins sentencing hearing, which was insane. It was insane. Thanks to all our regular OGs who are here and who knew the mods were dealing with a lot of people who hadn't been here before and didn't know the rules. You guys were phenomenal. Thank you very much for keeping it classy. We appreciate you. All right. This is our last verse, then we have a drum solo. Just for your information, over 25,000 watch hours that day alone. 5,700 consecutive viewers.
Remember in the beginning when we started 110 years ago?
At one time, not consecutive. So it was wild. Thank you. Sorry, I can't drum and do math at the same time. Apparently, I can't do either, but concurrent. There's the word I was looking for. Greeners, thanks for saving me. I was just going to move on and pretend I didn't say anything. We are about to go down to court for Judge Boyd, so let's see if we can find her. Judge Stephanie Boyd. There she is. And she's not ready yet, so we'll give her a minute. When it goes live, let me know if you see it. We'll pull it up here promptly. All right. Yeah, Greeners wasn't even here. Well, he scheduled his time off wisely. That's all I can say, Greeners. I tip my hat to you. Taking a day off on the busiest day of the year is that's a boss level move. So good job. Hope you had a great time with no internet. Let's see. You all deserve a raise. I'm going to double their pay. Not just a raise, doubling it. Triple. I'm generous. I'm feeling generous. Triple the pay. Congratulations, mods. Your pay's all been tripled. Yes. That's some math I can do. All right. Good morning. How was yesterday? We had the podcast yesterday. That's what we did. I was just refreshing my memory, my own recollection, and we had the Department of Labor would like a word. Is it about the hours? Because they can hang it in their ear. I said ear, not in their rear. Hang it in their ear, like the listening thing. Canada long weekend. We had the podcast last night. It was a lot of fun. I didn't come out like in these specific words and say it, but I thought I implied this, and I went to bed and realized that I owe you all the full. I need to verbalize this. I need to go ahead and clip this. It's all right. I know when I've been beat. And yesterday, Thomas's pizza was better. We had pickle pizza yesterday, which surprised the both of us with how delicious it is, and it's something the both of us are going to do again. Thomas made the better pizza. It might have been the preparation. It could have been the fact that he was proofing the dough like 48 hours ago or something. His was homemade. Yes, it was. I mean, he dreamt up his own recipe. A little of this, a little of that. Touch of seasoning, everything. It was. I went to J. Little's down the store, which is the name of. It's right next to my house. It's a little pizza / Chinese / Japanese / American / all you can eat buffet / sub shop. That looks like it was built in maybe, I don't know, the 60s. And it still has that, that little black letterboard where you have to press each letter onto it. That's their menu system. I mean, they don't even show pizzas on there. But their sign outside says pizzas. They haven't updated their sign in ever. There's like 8.5 by 11 taped up, crooked, wrinkled pieces of paper advertising. We now have nachos and things like that. They just added things to the menu. And they made my pizza, and it was so good. It was so good, but it was not as good as Thomas's. So, Thomas, If there was a prize, I would be handing it over to you right now. You are, in fact, the winner. I've preserved Thomas's Pizza for the Recovery Addict Cookbook for 2026. That is awesome. I can't wait. It might actually be like a cover item. I mean, that might be the image of our cookbook on the cover. Thomas, arms folded, chef's hat. We can add the chef's hat and everything, or the centerfold. Yes, you're right, Greeners. We do have options for where we can put that. All right, we're gonna miss. We're going to miss Judge Boyd if we're not careful. Where are we? We expect this morning that the state is going to rest their case, and we should hear everything that defense has for us. And this is actually, although it started sort of as a sleeper trial, this is a manslaughter trial involving a car crash with a driver who may have been drunk, but that testimony was not allowed in, at least not that specific testimony that would have really convinced the jury that was the case. The jury might conclude that anyway. We'll see how that goes down. But we have a situation where the driver may have been shot at and fleeing said shots at 88 miles per hour in a 35 zone. Yeah, we've got a lot of interesting things. We've got some spicy attorneys as well, especially on the defense side. It's starting to, even though Judge Boyd yesterday, and I love Judge Boyd, but I'm sorry, she was somewhere else. She was not in court yesterday. I mean, physically she was, mentally she was not. We might have to impose the no phones in court rule for judges, because I think she was on her phone all day. Anyway, today we have court, and we expect it to get spicy, and I don't know which way this is going to go. I don't know if the jury's going to side with the driver or not. Clearly, I mean, this is a tragedy. We have a pedestrian who was struck down and killed. The pedestrian was super drunk at the time, but not his fault. He was, in fact, on the sidewalk, is our understanding. He wasn't in the street. Cars should be on the street, pedestrians on the sidewalk. That part we know, but the car left the street over the sidewalk and struck the pedestrian. That's the tragedy. The question is it manslaughter or not? And we'll have to probably listen very closely to the judge defining the elements of manslaughter before we get an indication of which way the jury might go here in Texas. All right. Red Pen says, I think the jury will not side with the driver in spite of the great efforts of his attorney. The investigator messed this whole thing up. He did. And it was not the CSI investigator's fault. She took 3,000 pictures of everything. She did full investigation. But the investigator didn't even read his own police officer's reports at the scene. The bike officers. So we'll see if the defense actually manages to subpoena them for today and gets them in as well, because they've sort of hinted at that they were going to do some last-minute subpoenas and add to the witness list. Sometimes the judges don't like that, mid-trial, just tacking on new witnesses. But the judge has said, we will get through all of the defense witnesses today. Probably because she told the jury we would be done by the end of today. All right, it's 10:03, which by my clock means we should have started 3 minutes ago. The judge appears to not be live just yet. If you see differently, please let me know, and I'll refresh my screen here. But I've been clicking 100 times, just not seeing it. When I have vacation reservation that's already paid, now it says that the remaining balance is 240 euros. Negative 240? Does that mean the place owes me money? Drinks on the house, I guess, Dennis. I don't know. You overpaid. Oh, travel credits. You have unused travel credits. Congratulations, Dennis. You're about to get a lifetime of phone calls trying to get you to spend them. Let's see. Yes, it says negative 240. Call them up and ask them how you can pay that. Like, should they pay that straight to your PayPal or something else? Dwayne can help you with that. Dwayne has news. Dwayne has news. Do I have news for you? I got an email this morning. No, it wasn't Dwayne. It was actually me, Scott. Got an email this morning from none other than Pucky Puppy, letting me know that once again, my affiliate status has been restored with the company. I did not ask for this. As a matter of fact, I told them that if anyone did come to me asking to buy a Pucky Puppy bike, I would do everything I could to tell them to buy something other than a Pucky Puppy bike. But in spite of that, in spite of me threatening to tell them all the truth about the problems I've had with the bike and what I don't like about it, they have restored my affiliate status. And the bike store is back in business. We are selling bikes again. Oh, time for you to rename Pucky Puppy. Oh. I'm tempted to give my bike a paint job just to get rid of the label. But I don't know why. I don't know why there's, after all these months, they just decided it was like, hey, let's make this guy an affiliate really quick. That's what happened last time. They made me an affiliate, and then days later, they added me as a distributor and literally published my name and home address on the internet as a place you can go to test ride a Pucky Puppy bike. They did that. Yeah. Anyway. Good times. I do actually like my bike. It's just I won't buy another one. That's all. Not that brand. Okay, is there... Still not seen anything from Judge Boyd. Which is okay. She runs late a lot. I think cake topped with milk should be your new business venture. Pickles on pizza. Pickles on pizza is a good one. Got to make the Alfredo sauce pickle pizza this weekend. Thomas didn't do Alfredo. What was his white sauce? I forget what he used, but it was sparingly. I know he had provolone in there, but what do you guys want to talk about for an hour? Let's on another subject. I'm an hour early. I'm expecting Judge Boyd to start, and she's in Central Time Zone. I could have been sleeping in right now, is what you're saying. Well, good thing it's Friday. We've got some courts that we can jump to. Most of them are traffic courts, so let's do a quick one here with this one right here. See what's up what's up in the world of true crime, various and sundry places. Yeah, it's 9 o'clock. I even checked the time. We could read the Murdaugh ruling. Where do you have that? I'd love to do that. But Murdaugh sounds fascinating. Middleton is live, yes, but it's landlord-tenant cases today. Is it the pinned document in Mod Chat? Can't see it apparently. Everyone's wondering why I was starting so early. Sorry, Fran. An hour early. We just are really excited about this case. It was a sleeper, and then it woke up yesterday and just got crazy. Birdie B says, let's talk about how I've been in the hospital 2 weeks, but survived, and I'm back. Birdie B, that is wonderful. Wonderful that not that wonderful that you were in the hospital, but wonderful that you're back and that you survived. It's wonderful to have you here. Just posted the link in Mod Chat. Thank you very much. Sure. Greeners? Oh, but by just, was it like earlier this week, or? I'm not seeing it. Okay, my Mod Chat's acting up. I don't think it's loading properly. Hang on. Okay. Oh, 3 new messages. There it is. Okay, it's fixed it. Got it. All right. Supreme Court of Georgia. This is going to be some good reading here. How many pages is it? Let's go to... You guys hearing that beep? How did I fix the beep last time?
You are banished from the state of Georgia.
I think I fixed it like this. That wasn't it. That's it. That's how I fix it. All right. South Carolina. That's where we're going. Let's go to the MacBook here.
Hello.
Hey, at least they're neighbors, right? I think they're practically touching each other, if not actually. South Carolina. Come on, come on. Trying to get the page set up so you can all view it as well with me as we read. That did not work. It went smaller. Actual size. Actual size is tiny. I can't even read that. Hang on, Greeners. Is this like a file or is it a website? It's a PDF. Hold, please. We're trying to get this set up so you can read it. Tammy Lee just gifted 10 memberships. Tammy Lee, thanks for your generosity this morning. That is just awesome. Let's see. Let's open in Safari. Let's try that. Which will then give me the option to possibly download or share that through AirDrop. Okay, now we've got it. To open it with preview, that will save us. All right, we've solved the technical issue. I've learned how to use a computer at a basic level. And give me just a minute, we'll have it up on screen for you. Continue to scroll. There we go. All right, now we're cooking with fire. Here we go. Tammy Lee, thank you for your generosity there. That's amazing. I'll be the first one back to my grandparents' hometown in 100 years. Wow. That's really cool. Packing for Italy. We'll be back in about 2 weeks. I'll miss you all. Tammy, take some pictures. By the way, 20 months. Oh, gee. Sorry, I choked up on that one. But Italy's amazing. All right. All right, we're good. We're good. Got everything. Let's go ahead and start reading, shall we? In the state of South Carolina, in the Supreme Court, the state who's the respondent versus Richard Alexander Murdaugh, who's the appellant. The case number from 2023-2024. Appeal from Colton County. Clifton Newman was the judge. Jean Hofer Toll was the circuit court judge. This is the part in bold is the important part. How long is this? Holy smokes. Reversed and remanded. That means it's going back. That right there tells us that he gets a new trial. And it's got all the names of all the people, the players that we know and saw. Creighton Waters is in there. You can see him, a bunch of others, Mark Reynolds, Attorney General, and everything. Per curiam. For 6 weeks in early 2023, the eyes of the nation focused on Colton County, where the state prosecuted notorious former attorney Richard Alexander Murdaugh for the murders of his wife Maggie and son Paul. Both the state and Murdaugh's defense skillfully presented their cases to the jury as the trial court deftly presided over this complicated and high-profile matter. However, their efforts were in vain because Colton County Clerk and Rebecca Hill placed her fingers on the scales of justice, thereby denying Murdaugh his right to a fair trial by an impartial jury. Our justice system provides, indeed demands, that every person is entitled to a fair trial, which includes an impartial jury untainted by external forces bent on influencing the jury toward a biased verdict. Although we are aware of the time, money, and effort expended for this lengthy trial, we have no choice but to reverse the denial of Murdaugh's motion for the new trial due to Hill's improper external influences on the jury and remand for a new trial. This went to the highest level it possibly could before it got reversed. He lost and then won. Because we order a new trial on this basis, it is not necessary that we review every evidentiary issue Murdaugh raises on appeal from his conviction. However, we address the admissibility of Murdaugh's financial crimes to offer guidance on this thorny issue to the trial court on remand. Factual and procedural background. On March 2nd, 2023, Murdaugh was convicted of the murders of his wife, Margaret Murdaugh, and his son, Paul Murdaugh, as well as 2 counts of possession of a weapon during the commission of a violent crime. The trial court, Judge Newman, sorry, I just needed a moment of silence for his loss. We lost him as a judge. It's terrible. He's not going to be the judge next time. Sentenced him to life in prison. While his direct appeal of these convictions was pending at the Court of Appeals, Murdaugh filed a motion to hold the appeal in abeyance to allow him to file a motion for a new trial. The Court of Appeals granted this motion. On October 27, 2023, Murdaugh moved for a new trial, asserting Hill tampered with the jury by advising it not to believe Murdaugh's testimony and other defense evidence, pressuring it to reach a quick guilty verdict, and 3, representing the information to the trial court in an attempt to have the court remove a juror she believed to favor the defense. He attached affidavits from several jurors to support his motion. Chief Justice Beatty appointed former Justice Toll, post-trial court, to preside over this motion. We watched that together, as the trial court judge had recused himself. The post-trial court conducted a hearing of this motion on January 26th and 29th. During the hearing, the post-trial court asked each juror, 1, if the guilty verdict was an accurate statement about their verdict at the time, and 2, whether their verdict was based entirely on testimony, evidence, and law presented in the case, and 3, whether they heard Hill make any comment about the case before the verdict, and 4, whether their verdict was influenced in any way by any communications by Hill. Juror X, we're going to call him Juror X, not 10. Juror X, who testified on the first day of the hearing, acknowledged hearing Hill say before Murdaugh's testimony, "Looks like the defendant's going to testify. This is an important day," or "This is an epic day," and that it was rare for a defendant to testify. Juror X said these statements did not impact the verdict. Juror Z, who submitted one of the affidavits Murdaugh attached to his motion for a new trial, was the first juror to testify on the second hearing date. When asked whether she heard Hill make any comments about the case, Juror Z responded that Hill said to watch his actions and to watch him closely. Juror Z added that Hill said more, but she could not remember anything else. Juror Z explained Hill's statements influenced her finding Murdaugh guilty because, to me, it felt like she made it seem like he was already guilty. At the state's request, the post-trial court questioned Juror Z about her affidavit, addressing each paragraph in turn, and Juror Z's affidavit gave more detailed recitation of Hill's comments. And here it says, here's the excerpt. Toward the end of the trial, after President's Day break, before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean that Mr. Murdaugh would lie when he testifies. She also instructed the jury to watch him closely immediately before he testified, including to look at his actions and look at his movements, which I understood to mean he was guilty. Juror Z testified that when the jury began deliberations, Hill told the jury, "This shouldn't take us long." In addition to referencing Hill's statements, Juror Z averred in her affidavit, I've never seen that word before. Averred. In her affidavit, "I have questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors." After reviewing the affidavit, the post-trial court questioned Juror Z. said, I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes, in light of what you said in the affidavit, which is, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read more accurate statement of how you felt? Juror Z answered affirmatively. Averred means claimed. Thank you very much, Lisa. The post-trial court then asked if she stood by the affidavit, and she said yes. Juror Z subsequently submitted an affidavit to clarify her testimony, in which she explained that she felt influenced to find Murdaugh guilty by Hill's remarks before she entered the jury room, and once deliberations began, she felt additional pressure from other jurors to reach the guilty verdict. Although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of the record before this court. Juror P testified that on the day Murdaugh was to take the stand, who came up with these letters? Just randomly assigned letters? On the day that Murdaugh was to take the stand, Hill made a comment to watch his body language. He denied Hill's comments influenced him in any way. The remaining jurors testified that they did not hear Hill make any comments about the case, and they were not influenced by any comments Hill made. Following the jurors' testimony, the state called Hill as a witness. Although Hill denied making most of the comments the jurors related, she admitted that on the day Murdaugh testified, and within earshot of some jurors, she spoke to the bailiff about Murdaugh's decision to testify. She also stated that she gave the jurors a little talk, instructing them to pay attention and that the day was a big day. She denied attempting to influence the jury. Okay, how about it? Huddle around, everybody, for Becky's pep talk. This is what we do in these trials. In discussing her book, Behind the Doors of Justice, The Murdaugh Murders, Hill claimed literary license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of her trial, the trial did not matter to her, but she acknowledged as true a passage in, you have to scroll down, in which she stated she believed Murdaugh was guilty, but was concerned he would be acquitted because of the family's goodwill in the community. Couple footnotes. Following Juror Z's testimony, the post-trial court informed the parties that the other jurors who were waiting for their turn to testify had tuned in to the proceeding on court TV. Remember that? The jurors either denied viewing the proceeding or, if they saw it, asserted it would not influence their testimony. And as her book title suggests, it turns out Hill was quite busy behind the doors of justice, thwarting the integrity of the justice system she was sworn to protect and uphold. The book was pulled from publication because Hill's plagiarized portions of it. The post-trial court also questioned Hill about the favors she granted the media. Hill denied allowing the press to view the exhibits, including the sealed exhibits. However, she subsequently pled guilty to perjury stemming from this denial, which means she did it. Although the post-trial court limited discussion of Juror 785, whom the trial court dismissed on the day deliberations began for allegedly discussing the case with third parties, it allowed Murdaugh to question Hill about bringing to the trial court's attention social media posts that Hill mistakenly believed were from Juror 785's ex-husband. Hill claimed that the juror was very talkative while Hill walked her to the trial court's chambers and volunteered that there were restraining orders on her ex-husband when they divorced. In response to the post-trial court's questioning, Hill continued to deny initiating or engaging the juror in discussion of these matters. In contrast to Hill's testimony, Juror 785 averred at the hearing before the trial court and in an affidavit Murdaugh attached to his motion for a new trial that Hill interrogated her about the social media posts and whether she had been in contact with her ex-husband. In the affidavit, Juror 785 related to that Hill, knowing the juror's fears about her ex-husband, informed her that law enforcement officers questioned the ex-husband about the posts, offered to reinstate restraining orders Juror 785 had against him, and speculated that the Murdaughs probably got the ex-husband when he called Juror 785 on the morning of the verdict. Juror 785 asserted Hill asked her whether she or other jurors were inclined to vote guilty or not, and told her that evening that Murdaugh said that everything Murdaugh said had been lies. Okay, this is some bold statements. She also stated that before Murdaugh testified, Hill told the jurors not to be fooled by the evidence Murdaugh's attorneys presented. Rhonda McKelveen, that's my final answer. Rhonda McKelveen, the Barnack County clerk of court who assisted Hill with the trial, testified that Hill repeatedly told her she wanted to write a book so she could buy a lake house, and a guilty verdict would be the best way to sell books. McKelveen testified that after hearing Hill had given a juror a ride home, Yes. Hill had given a juror a ride home. McKelvey counseled her that it was inappropriate, and while Hill admitted she gave the juror a ride, she claimed the bailiff was with them and they did not discuss the case. Although McKelvey did not hear Hill say anything inappropriate to the jurors, she stated that Hill made the comments to her, staff, and media members strikingly similar to those Jersey reported, such as advising them not to be fooled by Murdaugh's attorneys and to look at Murdaugh's actions and movements when he testified. Finally, McKelvey testified that Hill seated a writer with court personnel. This writer wrote the foreword for Hill's book. She put her ghostwriter in the courtroom. A couple footnotes: when the trial court dismissed juror 75, she said her belongings left in the jury room included a dozen eggs, which another juror had brought her. She then became known as the egg juror or the egg lady. McElveen, is that the way to say it? I'll try that one. Although the post-trial court did not allow juror 785 to testify, her affidavit is in the record for our consideration, as are her egg, not her eggs. I think she got her eggs back. Next, Murdaugh called to the alternate juror to testify. She describes the incident in which Hill made her comments before Murdaugh put up his case, stating that while the jurors were assembled in one of the two jury rooms or were standing in the hall, Hill stood at the doorway and told them, "They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off." The alternate juror also testified that Hill told the jurors not to be nervous, don't be afraid to show your emotions because that's what they want to see. The alternate juror related that she heard a court staff member say deliberations should not take long, but she could not remember who said it. In its order, the post-trial court declared a burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. It then found Hill made improper comments to the jurors on the day Murdaugh testified. For example, "This is an important day," or "This is an epic day," and that they should watch Murdaugh's body language. The post-trial court determined Hill's denial of making these statements was not credible, finding Hill wanted to write a book, which she believed a guilty verdict would help sell. She was attracted by the siren call of celebrity, and she allowed her desire for public attention of the moment to overcome her duty to her oath of office and her oath as a witness. Next, the post-trial court found that these comments did not affect any juror's verdict. It explained Juror Z's assertions that Hill's comments affected her verdict were ambivalent, self-contradictory, and not credible, emphasizing Juror Z had acknowledged her statement in her affidavit that she had voted guilty due to pressure from other jurors was the more accurate statement. The post-trial court further found that Hill's comments were limited in subject and not overt as to opinion, were only heard by, at most, 3 jurors, and were made in a case with overwhelming and compelling evidence, and that the trial court's extensive instructions cured any effect from these comments. The post-trial court concluded that while it found Murdaugh had failed to meet his burden to prove prejudice, any presumption of prejudice was overcome. It therefore denied Murdaugh's motion for a new trial. Murdaugh timely appealed to the Court of Appeals. This court certified the appeal of the denial of the motion for a new trial and subsequently consolidated it with the direct appeal. Footnote: at the hearing, Hill denied giving the juror the ride home. Law and analysis. Here's our case law. I'm hearing so many new words. I'm making them up as we go, Greeners. Remmer presumption of prejudice. Murdaugh argues that he was denied his constitutional right to a fair trial by an impartial jury free from outside influences. This is the same argument that Corey Richens, I'm sorry, I did it again. Corey Richens is going to include in her appeal, that she thinks her jury was not fair and impartial. I caught it that time before you did. $5 in the KR jar. He asserts that the following: Remmer v. United States, prejudice should be presumed from Hill's comments to the jury, and the presumption is irrebuttable. In the alternative, he contends the state failed to rebut the presumption of prejudice. The state argues the jury convicted Murdaugh because he was obviously guilty and not because the 3 jurors heard Hill's foolish and fleeting comments about his upcoming testimony. It contends that the post-trial court correctly declined to presume prejudice and any presumption of prejudice was rebuttable. We agree with Murdaugh, says the Supreme Court. Why do some people say his name with a K sound at the end? That's how he pronounces it. We agree with Murdaugh, says the Supreme Court. Prejudice is presumed from Hill's comments, and while the presumption is rebuttable, the state failed to overcome this presumption. Our federal and state constitutions guarantee a criminal defendant the right to a fair trial by impartial jury. No right touches more the heart of fairness in a trial than the right to an impartial jury. This right can be infringed when a third party makes improper contact with a jury, for the right is meaningful only if the jury remains free from outside influence, including exposure to evidence or information that has not been introduced during the trial. To protect the right to an impartial jury in such cases, the Supreme Court of the United States created a rebuttable presumption of prejudice, elucidating any private communication, contact, or tampering, directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, if not made in pursuance of known rules of the court and the instructions and directions of the court made during the trial with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily upon the government to establish after notice to and hearing of the defendant that such contact with the juror was harmless to the defendant. The United States Court of Appeals for the Fourth Circuit noted that in addition to the presumption of prejudice, Remmer established a separate but related requirement that the defendant be entitled to a hearing when the defendant presents credible allegation and communications or contact between a third party and a juror concerning the matter pending before the jury. The Fourth Circuit established a 3-step test for considering extrajudicial contacts with the jury. The party who is attacking the verdict bears the initial burden of introducing competent evidence that the extrajudicial communications or contacts were more than innocuous interventions. If this minimal standard is satisfied, the Remmer presumption is triggered automatically. The burden then shifts to the prevailing party to prove that there exists no reasonable possibility that the jury's verdict was influenced by an improper communication. What this means, this makes this basically just like an argument for self-defense. The defendant has the obligation to assert that self-defense right. It's an active defense. He has to testify and say, this was self-defense. I felt fear for my life. I took this action as a result. And then the burden shifts from the defendant to the state to prove that it was not self-defense. They're saying that's the same thing here. With this extrajudicial context of the jury, the defendant says, hey, that's a problem. This happened. And now the burden shifts to the state to prove that it didn't happen or didn't have the effect that they say it did. So it's a little burden shifting, but it's okay if we have that type. The Fourth Circuit further provided that in determining whether the extrajudicial contact was innocuous or whether it triggered the presumption, the court considers whether there was 1, any private communication, 2, any private contact, 3, any tampering, or 4, directly or indirectly with a juror during trial, and 5, about the matter before the jury. An unauthorized contact between a third party and a juror concerns the matter pending before the jury when it is of such a character as to reasonably draw into question the integrity of the verdict. Once the Remmer presumption is triggered, the state bears the hairy...
Beginning when we started 110 years ago?
Thank you, Laura. Once the Remmer presumption is triggered, the state bears the heavy burden of proving there is no reasonable possibility that the verdict is affected by the contact. The court must examine the entire picture, including the factual circumstances and the impact on the juror. In determining whether the state met its burden of rebutting the Remmer presumption, courts consider a variety of factors such as the extent of the improper communication, the extent to which the communication was discussed and considered by the jury, the type of information communicated, the timing of the exposure, and the strength of the state's case. The strength of the state's case is interesting in there because there was a lot of evidence against Murdaugh. All right. Here we go. Relevant factors to be considered in determining whether outside influences have affected the jury are the number of jurors exposed, the weight of the evidence properly before the jury, and the likelihood that curative measures were effective in reducing the prejudice. The extent of the communication is the most important factor. In Parker v. Gladden, the Supreme Court recognized the extreme prejudice inherent in statements concerning the matter at trial when made by an officer of the court, basically saying that because Becky was an officer of the court, instead of just like some passerby who's like, he's guilty, jury, vote guilty, that wouldn't have as much impact as an officer of the court saying he's guilty. Make sure you do the right thing. There, a bailiff who oversaw a sequestered jury during an 8-day trial stated to a juror in the presence of other jurors, "Oh, that wicked fellow, he's guilty." The bailiff also told another juror, if there is anything wrong in finding the petitioner guilty, the Supreme Court will correct it. At least one juror or alternate overheard the statements. In rejecting the state's argument that no prejudice was shown, the Supreme Court explained, this argument overlooks the fact that the official character of the bailiff, as an officer of the court as well as the state, beyond question carries great weight with the jury, which he had been shepherding for 8 days and nights. Crazy nights, I'm sure. Although the Supreme Court noted the 26-hour jury deliberations and one juror's testimony, she was prejudiced, also supported the trial court's finding of prejudice. It held that the unauthorized conduct of the bailiff involves such a probability that prejudice will result that it is deemed inherently lacking in due process. It further recognized that it would be blinking reality. Blinking reality not to recognize the extreme prejudice inherent in which statements had reached at least 3/4 of the jury and one alternate member. The Supreme Court did not apply the Remmer analysis. However, not all comments by officers of the court are prejudicial. In Green, a juror asked the bailiff what would happen if the event of a deadlock. And he responded that the judge would likely give them an Allen charge and asked if they could stay later. While the Court of Appeals held the state overcame the Remmer presumption, this court held the bailiff's comments did not trigger the presumption. We explained that our willingness to categorically apply Remmer presumption or of prejudice stems from our view that not every inappropriate comment by a bailiff or juror rises to the level of constitutional error. The best thing the bailiff and juror could do is just shut up. Don't say anything. Let the judge be the communicator. As the Fourth Circuit recognized, there is a split among the circuits regarding the issue of whether the Remmer presumption has survived intact following. The Supreme Court's decisions of Smith v. Phillips and United States v. Olano, United States v. Lawson, they're collecting cases and recognizing the split in the circuits. Okay, so there's division in the ranks. That's what I hear. Let's see. Let me know with a buffer sound or something, which I will have up, just for buffer and not for anything else, if Judge Boyd comes live, because we're going to jump to that. Let's see, where were we? Division in the ranks. In Phillips, the Supreme Court declined to impute bias to a juror who applied for a job in the prosecutor's office during Phillips' trial. In reversing the grant of a federal habeas relief, the Supreme Court declared that the remedy for allegations of juror partiality is in a hearing in which the defendant has the opportunity to prove actual bias. The court explained that due process does not require a new trial every time a juror has been placed in a potentially compromising situation. Instead, due process necessitates a jury capable and willing to decide the case solely on the evidence before it, and a trial judge ever watchful to prevent prejudicial occurrences and determine the effect of such occurrences when they happen. So you've got a sitting jury member applies to work in the prosecutor's office while they're deliberating or while they're in court. That's crazy. Couple little footnotes here. We had an Allen v. United States reference, as well as some more case law that said that the Supreme Court noted the case's procedural postures informed the outcomes. Some pretty heavy case logic here. Findings are presumptively correct. Applying the plain standard because Orlando did not object to alternate jurors' presence in the jury room. The Court of Appeals should correct a plain forfeited error affecting substantial rights if the error seriously affected the fairness, integrity, or public reputation of the judicial proceedings. Alteration in original. Okay, all right. In Olano, the Supreme Court considered whether the presence of an alternate juror's during jury deliberation was a plain error that the Court of Appeals was authorized to correct under the Federal Rule of Criminal Procedure. Noting the alternate juror's presence was not the type of error that affected the substantial rights independent of its prejudicial impact. The court found no reason to presume prejudice. There may be cases where an intrusion should be presumed prejudicial, but a presumption of prejudice as opposed to a specific analysis does not change the ultimate inquiry. Did the intrusion affect the jury's deliberations and thereby its verdict? It's interesting they would have an alternate just sitting there watching. Is that what they're saying? Seems like a weird case. The alternate's like, you don't get to talk, but you can go in and watch. You're the only ones that can. Water break is over. All right, let me sort of skip through some of this case law stuff because this is sort of the history of how they came to this conclusion. If you want to read it, you can. I'm going to jump down to the next parts. More case law, a lot of case law. And it's all these decisions have to do with the case law decisions, not with Murdaugh. Okay. Under this framework, we turn to the facts in hand. First, we must determine which comments Hill made to the jurors. The post-trial court referenced only a few of the comments the jurors testified she made. For example, this is an important day, or this is an epic day, and to watch Murdaugh's body language. The state argues the post-trial court implicitly rejected the other alleged comments as not being credible. We find this argument is without merit. The post-trial court gave no indication it found the other comments not credible, nor would the record support such a finding. Indeed, the post-trial court found Hill's denial of making any inappropriate comments lacked credibility. The post-trial court made no distinction regarding the comments it referenced in its order and remaining comments that are in the record. The post-trial court, in fact, found credible juror Z's affidavit statement concerning pressure from other jurors. This same affidavit included Juror Z's recollection of Hill's comments not to be fooled by the evidence presented by Murdaugh's attorneys and Hill's instructions to watch Murdaugh closely, look at his actions, and look at his movements. The state offers no rationale for finding part of the affidavit credible while rejecting the portions that are damaging to the state's case. Juror Z's recollection of Hill's comments was consistent with Juror 785's affidavit testimony that Hill told the jurors not to be fooled by the evidence Murdaugh's defense presented. Juror Z's recollection is also consistent with the alternate juror's testimony concerning Hill's comments. They're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. These comments were also strikingly similar to the comments Hill made to McElveen. Is that the way we want to say it? McElveen? Other staff members and the media went away from the jury. Furthermore, Hill's attempt to insert herself into the jury's deliberations through these comments was in line with her stated desire for a guilty verdict to sell more copies of the book she planned to write or plagiarize. Her meddling in events around Juror 785's dismissal and her self-aggrandizing conduct throughout and after the trial, from granting favors to media members, such as allowing them to view sealed exhibits, and sitting a writer with court staff in the courtroom to granting interviews. As the post-trial court found, Hill was attracted by the siren call of celebrity, allowed her desire for public attention for the moment to overcome her duty to her oath of office. A couple footnotes. Hill's lack of credibility during the hearing on Murdaugh's motion for the new trial is further evidenced by her recent guilty plea to perjury stemming from the hearing from her denial of allowing members of the press to view the sealed exhibits. It's rare to have perjury charges. I mean, we don't see those very often. This might be the only case of convicted perjury that I can recall since we've started following cases together. The post-trial court did not make a finding of the alternate juror's credibility. We have no reason to find Hill did not make all of the statements the jurors reported. Therefore, we hold Murdaugh's established Hill made comments that day Murdaugh testified was epic or important, and urged the jurors not to be fooled, confused, or thrown off or convicted by Murdaugh, and to watch Murdaugh's body language closely. So they basically say, we believe Becky did all those things. Next, we must decide whether these comments were more than innocuous interventions and of such a character as to reasonably draw into question the integrity of the verdict. Hill's statements were more comparable to those of the bailiff in Parker than those of the bailiff in Green. So now they're holding this up and contrasting it to all the case law, some of which we skipped. So it's not going to make a lot of sense. Just know that every time we read an italics word like Parker and Green, that's case law. That's the case we were hearing about before. And so they're comparing Hill's statements to the bailiff in the Parker case or the bailiff in the Green case. Like bailiff's statements in Parker, Hill's comments attacked the defendant's character and credibility, which certainly were matters before the jury. That's the wicked fellow guy. He's guilty. Hill became a character witness on behalf of the state, encouraging the jurors to question Murdaugh's credibility. Holding a plaintiff there's a case law here that either v. Fairfield Memorial Hospital with a big, let's see, it refers to character witness. In fact, let's see. Skip the doctor part. In fact, by urging the jurors not to be fooled or convinced by Murdaugh's defense, Hill essentially implored the jurors to find him guilty, the ultimate issue in the case. Even Hill's seemingly innocuous comments that the day Murdaugh testified was an epic or important day became nefarious when considered with her other comments, insinuating that there was something unusual and suspicious about his decision to testify. In contrast, the bailiff's statements in Green, the case law, though improper, did not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. So her comments were worse than the ones in the case law for Green. Therefore, we hold Murdaugh has met the minimal standard of showing of the extrajudicial communications or contacts were more than innocuous interventions. And the post-trial court erred as a matter of law in refusing to impose Remmer presumption. Our following consideration is whether the state met its heavy burden, proving there is no reasonable possibility that the verdict was affected by Hill's comments. As stated above, post-trial court analyzed the evidence there before it by erroneously imposing the burden of proof of prejudice on Murdaugh. Furthermore, as Murdaugh argues, the post-trial court erred in considering testimony from the jurors about whether Hill's comments affected their verdict because this testimony violated Rule 606B of the South Carolina Rules of Evidence. Rule 606B in South Carolina Rules of Evidence limits the testimony a juror may give on the issue of prejudice. And the rule says that upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or dissent from the verdict or indictment or concerning the juror's mental process in connection therewith, except that a juror may testify on the question whether the extraneous prejudicial information was improperly brought to the jury's attention or whether any outside influence was improperly brought to bear upon any juror. Nor may any juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. This is a lot of rules to basically say the court can't ask you why you decided the way you did. They can't dive into the deliberation process and ask you what everyone else was thinking and how things went in there. They can only ask you and say, did you get outside information? And did that influence you? All right. In interpreting the court rules, the court implies the same rules are construction used to interpret statutes. That thus, if a rule's language is plain, unambiguous, and conveys a clear meaning, interpretation is unnecessary, and the stated meaning should be enforced. We must consider not only the particular clause in which a word may be used, but the word and its meaning in conjunction with the purpose of the whole rule and the policy of the rule. In addition, when a South Carolina rule is substantially the same as a federal counterpart, we may consider federal cases in interpreting the rule. This is cool. A lot of states have laws that mirror federal laws. And so when the Supreme Court, say like in the state of North Carolina, is deciding an issue about North Carolina law that has a federal counterpart that's almost identical to it or is identical to it, they can say, we can look at the federal decisions to help us understand the state law and how we should interpret this. The United States Supreme Court explained Federal Rule of Evidence 606B the federal counterpart, is grounded in the common law rule against admission of jury testimony to impeach a verdict or the exception for juror testimony relating to extraneous influences. In Tanner, the Supreme Court examined the legislative history of Federal Rule 606B, setting forth the rationale for this rule, saying that public policy requires a finality to litigation, and common fairness requires an absolute privacy be preserved for jurors to engage in full and free debate necessary to the attainment of just verdicts. Jurors will not be able to function effectively if their deliberations are to be scrutinized in post-trial, meaning afterwards, litigation. In the interest of protecting the jury system and the citizens who make it work, Rule 606 should not permit any inquiry into the internal deliberations of the jurors. So they protect this. The Supreme Court noted its holdings require an evidentiary hearing where extrinsic influence and relationships have tainted the deliberations do not detract from, but rather harmonize with the weighty government interest in insulating the jury's deliberative process. Thus, while a probing factual inquiry is not only permissible but necessary, when a third party makes extrajudicial contact with a juror, the rule prohibits all inquiry into a juror's mental process in connection with the verdict. All right. Most courts preclude jurors from testifying as to the effect on their verdict or extraneous information or outside influence. So you really can't pry into what happened in the jury room. You can only ask if they got bad information or information outside of the evidentiary portion of the trial. The Fourth Circuit noted that by asking a juror whether he had listened to and considered all the evidence, the government was delving into a juror's mental process about the sufficiency of the evidence in reaching his personal verdict. Such an inquiry exceeded the strict limits imposed by Rule 606B. It further held that the district court erred by relying on the juror's mental processes in connection with the verdict when formulating its findings of fact. Holding a juror's affidavit was inadmissible to the extent that it recounts how another juror's disclosure affected the thinking of voting of individual jurors and the deliberations of the jury as a whole, including the tally of votes. To the extent the district court used testimony barred by Rule 606B to make the findings of its fact, the court abused its discretion. That's a slap. That's a slap in the face. When the Supreme Court says the court abused its discretion, they said, no, you shouldn't have done that. We find the plain language of Rule 606B authorizes jurors to testify about improper extraneous comments by a third party, but not on the comment's effects on the juror's deliberative process. While as the Fourth Circuit recognized, Rule 606B at times makes it more difficult to determine whether a new trial is warranted, sound policy supports the rule and outweighs any inconvenience or difficulty the rule imposes. So basically, they shouldn't have asked the jurors if they heard anything, and if they did, if that had an effect on them. They can ask if they heard anything, but it should have stopped there. That would have made it very difficult for the state to prove that there wasn't a problem when the burden shifts to them. But the Supreme Court says, yeah, it sucks, state. It makes it really difficult for you to win that one. And yeah, it's going to be expensive to have a new trial, but this is the way it has to be. We just can't dive into the deliberations of the jurors. All right. The state must meet its burden of rebutting the Remmer presumption without exceeding the limits of the rule. There's case law from Elbaz. We therefore hold that the post-trial court erred in questioning the jurors about whether Hill's comments influenced their verdicts, and in relying on the jurors' answers in its prejudice analysis. The state contends Murdaugh cannot complain about the post-trial court questioning. That's what the state says. Juror Z regarding her... that's one sentence. There's no period there. The state contends Murdaugh cannot complain about the post-trial court questioning Juror Z regarding of her affidavit because Murdaugh submitted the affidavit to the post-trial court with his motion for a new trial. Appellant cannot now complain of an error which his own conduct induced. That was overruled. And the Supreme Court says, we disagree. The purpose of Rule 606B is to preserve the sanctity of the jury room, protecting the jury system and the citizens who make it work. We do we do not allow the parties or the public to impeach that verdict with evidence of what occurred between the jurors in the sanctity of that jury deliberation room. This right was not Murdaugh's to waive. Thus, the portion of Juror Z's affidavit which she disclosed her mental process in reaching a verdict was inadmissible. The post-trial court erred in questioning her about that portion of the affidavit, and the post-trial court should not have considered that portion in ruling upon the new trial motion. So, footnote: we recognize that in either this court, the case either, I guess is the name of the case law, this court held the affidavits and testimony from jurors describing whether another juror's premature deliberations affected their votes were admissible because premature deliberations may affect the fundamental fairness of the trial. We hereby overrule either to the extent that this case condoned the use of testimony about the jury's mental process in reaching their verdict. Wow, so they also overruled. So in this decision, the Supreme Court overruled a prior standing decision. Let me go back to that. Where's either? It's way back there. Okay, United States. No, that's Elvez. So they just changed the law. That's rare. You don't get to see that very often. Trial court erred. Okay, we got that part. We also hold the post-trial court erred in finding a lack of prejudice because Hill's comments were limited in subject and not overt as to opinion, were only heard by, at most, 3 jurors, and were made in the case with overwhelming, compelling evidence. We reiterate the burden is on the state to rebut the presumption of prejudice. First, the post-trial court erred in finding Hill's comments were limited in subject and not overt as to opinion. Hill clearly advised the jurors to find Murdaugh and the evidence he presented not credible, and essentially urged them to render a guilty verdict. Hill's position as the Colton County Clerk of Court, an officer of the court who managed the trial and was the primary caretaker of the jury, amplified the impact Hill's comments had on the jury. Let's see. The office of the Clerk of Court is an elected one. Hill was elected by the very people who make up the Colton County jury pool. Next, the limited number of jurors who acknowledged hearing Hill's improper comments did not reduce their prejudicial effect. As the Supreme Court explained, a criminal defendant is entitled to be tried by 12, not 9 or even 10, impartial and unprejudiced jurors. In addition, in the context of jury tainted by external influences, the strength of the state's case does not necessarily warrant a finding that the state met its burden of providing the lack of prejudice. This state certainly produced a considerable evidence here, and arguably, reasonable minds may debate whether the evidence here was overwhelming. In the situation before us, notwithstanding the strength of the prosecution's case, the state is unable to overcome the presumption of prejudice. The state's case rested largely on circumstantial evidence, and Murdaugh's credibility was a key component of his defense. Hill's repeated comments challenging Murdaugh's credibility directly undermined that defense. Hill's egregious, improper jury interference went to the heart of the case and unquestionably was intended to push the jury to a guilty verdict. We are not convinced that the strength of the state's case against the Barn... Oh, that's case law. I'm not going to read that part. The breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina. That should be highlighted right here. That is crazy. This statement. It's, well, now I can't highlight it very well. The breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina, to our knowledge. Finally, we hold the state has not met its burden of proving the trial court's instructions to this jury cured any prejudice arising from Hill's comments. This is part 5. Remember, there were 5 parts of this. The last one was that the court could issue an instruction saying, please disregard anything you heard from somebody else. But wow. Finally, we hold the state has not met the burden proving the trial court's instructions to the jury cured any prejudice arising from Hill's comments. Generally, an instruction to disregard incompetent evidence is deemed to have cured the error. Moreover, jurors are presumed to follow the law as instructed to them. Here, the trial court gave the standard instructions and admonishments to the jury, none of which provided guidance on what to do when the Colton County Clerk of Court, an officer of the court, made comments disparaging Murdaugh's credibility and urging the jury to reject his defense. The trial court never had the opportunity even to attempt to cure the prejudicial effect of Hill's comments because they did not come to the light until months after the trial. If we were to accept the proposition that standard charges could cure such prejudice, then no defendant would be entitled to relief when improper extrajudicial information reaches the jury's ears, regardless of its content or context. Our federal and state constitutions simply cannot countenance such an assault on the right to a fair and impartial jury. If you remember on jury instructions, jurors are told all the evidence you are to consider will come to you here in this courtroom from this witness table. You hear something like that, right? And for the state to say, hey, they were told not to consider anything else, that should be fine. If they heard something else, they shouldn't consider it. The Supreme Court says, no, that's baloney. You can't just cover everything with and be good, everybody, and expect that to just hold over everything else. In summation, Murdaugh met his initial burden of establishing Hill's comments to the jury were more than innocuous interventions, triggering the Rammer presumption of prejudice and shifted the burden to the state. The state simply was unable to meet this heavy burden of proving that there exists no reasonable possibility that the jury's verdict was influenced by these improper comments. Accordingly, we hold Murdaugh's right to a fair trial by an impartial jury was violated, and the post-trial court erred in denying his motion for a new trial. Now, we have this Part B, and this is important. Evidence of Murdaugh's financial crimes. Why? Because we spent 12 days talking about them in court. Because we order a new trial on the basis of Hill's improper influence on the jury appeal from the order denying Murdaugh's motion for a new trial, it is not necessary that we address the evidentiary issues. They don't have to look at all the evidence that Murdaugh raises on appeal from his convictions and sentences. We elect, meaning we choose, however, to offer the trial court on remand the following guidance regarding the admissibility of evidence of Murdaugh's financial crimes. This is important because they're basically saying, hey, you have to do the trial over again because of Becky. And we don't have to say anything else. We could stop right there. But if you're doing the trial over again, just know that if you do the same thing you did last time with the financial stuff, we're going to kick it back again. We would, the appeal would be granted again. So they say, at the time of the trial, Murdaugh had been accused of and indicted for numerous financial crimes. Remember, like 100 of them. During his testimony before the jury, Murdaugh admitted he committed the financial crimes, although he had not at the time been convicted of anything. After trial, he pled guilty to the financial crimes in both state and federal court. He was sentenced to a concurrent 27 years in state prison and 40 years in federal prison. The state sought to admit evidence of these financial crimes during Murdaugh's murder trial for the purpose of showing his motive for committing the murders. The state filed a pretrial motion in which it argued the evidence demonstrated Murdaugh accrued substantial debts over a period of years, and to cover those debts, he began engaging in illicit financial crimes involving the theft and misappropriation of money from his clients and his own firm. The state emphasized that several series of events unfolding in the weeks and days leading up to the murders threatened to expose Murdaugh's financial crimes. The state wrote in its motion, all of these factors start to converge on June 7th, 2021, the date of the murders. The state explained its motive theory. The Murdaughs served as Murdaugh's means to shift the focus away from himself and buy himself some additional time and try to prevent his financial crimes from being uncovered. The state also stressed Murdaugh's attempts to cover his financial misdeeds after the murders to support its theory of motive. Murdaugh filed a memorandum arguing the financial crimes evidence should be excluded under Rules 402, 403, and 404B. Remember that whole prejudicial thing? They're too prejudicial, more than probative. The trial court concluded a lengthy pretrial hearing but declined to rule on the admissibility of the financial crimes evidence at that time. So, footnote, in addition to Murdaugh's challenge to the trial court's decision to admit evidence of his financial crimes, Murdaugh appealed the trial court's decision to allow the state to question a witness on redirect examination about the witness's knowledge of Murdaugh's financial situation. to admit evidence of a firearm and tool mark analysis expert testimony. Okay, this is something that some states do not allow anymore. Fire mark and tool mark. Okay, they say it's junk science. To admit evidence of 4 firearms seized from Moselle. Admit evidence of a blue raincoat collected from the house of Murdaugh's mother and gunshot residue expert testimony related to that raincoat. Allow the state to question Murdaugh on cross-examination as to the reasons he did not reveal until trial his presence at the kennels on the night of the murders, and admit evidence of an iPhone demonstration during the state's rebuttal case. Remember the iPhone demonstration where the guy was, I went back to my hotel and I threw my phone around a little bit, and this is what happened? Yeah, it's in the appeal. During various breaks in the course of the trial, the state presented the testimony of 8 witnesses regarding Murdaugh's financial crimes outside the presence of the jury. After hearing this testimony and the arguments of both sides, the trial court found all evidence of financial crimes that may likely have led to a motive or lend itself to a motive for the crime committed was admissible. The trial court stated the jury was entitled to consider whether the apparent desperation of Mr. Murdaugh, because of his dire financial situation, threat of being exposed for committing the crimes which he was later charged with, resulted in the commission of alleged crimes. The trial court also found, Judge Boyd's going to be live in just a minute, so we've got to wrap up here quickly. This evidence of other crimes is admissible, and its non-propensity, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these crimes will not lure the jury into declaring guilt on a different ground than the specific charge. They said it's not going to prejudice the jury, all these 100 other crimes. The trial court found the evidence had sufficient probative value and was not substantially outweighed by any danger of unfair prejudice. The trial court issued a written order setting forth the ruling. The state then presented testimony to the jury from 8 witnesses who testified earlier, along with 2 additional witnesses. And through these witnesses, the state proved Murdaugh committed wide-ranging financial crimes over numerous years in several general categories, including stole money from his clients by billing personal expenses to them under the guise of those expenses being associated with their cases.
Alex stole it.
Murdaugh stole money from his law firm by instructing the law firm employees to make checks payable to Palmetto State Bank, whose then Chief Executive Officer Russell Lafayette enabled Murdaugh to convert the funds for his own personal use. Murdaugh stole money from his clients and his law firm by instructing law firm employees to make checks payable to Forge, a fake account Murdaugh created to imitate the legitimate Forge consulting firm that Murdaugh had then deposited and used for his personal expenses.
Alex stole it as well.
Murdaugh stole money from Tony Satterfield by filing an insurance claim in relation to his mother, Gloria Satterfield's death, and collecting the insurance proceeds for personal use instead of providing proceeds to Tony and Gloria's other son.
Alex stole it as well.
Yeah, so we remember all that. The state also presented evidence to the jury that Murdaugh's years of stealing money in these ways was about to be exposed. For example, the law firm employees testified that they asked Murdaugh on at least 2 occasions in the weeks leading up to the Murdaughs about discrepancies in his financial disbursement documents in individual cases. Jenny Seckinger, the firm's chief financial officer, testified she confronted Murdaugh on the morning of the murder, stating, "I have reason to believe you received attorney's fees in a certain case directly to you, and you need to prove to me that you did not." Other evidence indicated Seckinger was referring to $792,000 in missing attorney's fees the firm was supposed to receive from Murdaugh's co-counsel, Chris Wilson. The state also presented evidence that Mark Tinsley, the attorney representing the family of the young man who died in the boat wreck, had scheduled a motion hearing for 3 days after the murders in which Tinsley sought to compel Murdaugh to disclose his detailed financial records. Remember Tinsley? Amazing witness that we got to see only in voir dire. Didn't actually get called during the trial, if I remember correctly. So Murdaugh challenges all this based on 401, 402, 403, 404B. We agree that the evidence of Murdaugh's financial crimes made the state's theory of motive more probable. We find the trial court acted within its discretion in finding the financial crimes evidence was relevant under 401 and admissible under 402. The more difficult question is whether the trial court should have excluded all or some of the financial crimes evidence pursuant to 404B or 403. We address this question in 2 distinct categories of issues. The first of these categories, whether the trial court should have excluded all financial crimes evidence, is a point which not all members of this court would have ruled the same way had we been the trial court. So the Supreme Court's torn on that. We each agree, however, this was a decision within the discretion of the trial court under the facts and circumstances that existed in Murdaugh's murder trial. As to the second category, we will address whether the trial should have just restricted the extent to which the state was allowed to present this evidence. That is, whether the trial court should have excluded some of the evidence. We unanimously hold the trial court allowed the state to go far too long and far too deep into aspects of Murdaugh's financial crimes that were not probative of the state's theory of motive, which gave rise to considerable danger and unfair prejudice, and therefore should have been excluded. So what this means is the next trial will have much less financial testimony in it. How much less? We don't know. But we'd have to look at 403 and 404. Let's see. This is good stuff, but we have to go to court here. We emphasize, however, the trial court should have limited the state's presentation of this evidence. We illustrate this point with the example of direct examination of Tony Satterfield. They allowed stuff that was only prejudicial and not probative to portray Murdaugh as someone who preys on vulnerable victims. Remember that with that testimony with the brother. Conclusion. As the Fourth Circuit declared, the Remmer presumption is alive and well. It serves to protect the right of the fair trial by an impartial jury for all defendants. Here, Hill, the Colton County Clerk of Court, egregiously attacked Murdaugh's credibility and his defense, thus triggering the presumption of prejudice, which the state was unable to rebut. As noted at the outset, Hill's shocking jury interference was accomplished outside the presence and knowledge of the outstanding trial judge and superbly competent and professional counsel of the state and the defense. We are accordingly constrained to reverse the post-trial court's denial of Murdaugh's motion and remand for a new trial consistent with this opinion. And so a new trial he will get. All right, let's see if we can find Judge Boyd now. The new trial, I think, will be awesome. I really do. And it's not
Remember in the beginning when we started 110 years ago?
All right, Judge Stephanie Boyd, where are you at? Still not live. We successfully wasted an hour, and she's still not ready. Go figure. All right. It'll be totally different this time around. I think so, but remember how the state incorporated like Brandy Churchwell's charts into their case? They have all that information now at the onset, and I think they can present it differently and better than they did initially, with even better conclusions. So it's going to be awesome. Can they use Murdaugh's testimony against him? My understanding of that, CDJ, is yes, they can. It was testimony provided, a sworn statement in court. So I think his prior testimony can be used against him for sure. Would be a streamlined trial. I would be surprised if it went 3 weeks. I don't know, 3 weeks probably is about the right number. 3 or 4. How long was the first one? Like a month? Favorite retrial, Mark Jensen. Can we get Tinsley on the stand too? I don't like Mark Jensen. There were too many pictures in that one, Greeners. Too many drawings. Hardest part will be getting impartial jurors. Yes, because it will still be in Colton County, which last time I checked was not like extremely. I mean, what's the population there? How many people now won't know anything about that trial? We want Mark Tinsley, as an opening witness, please. That was a great trial. I think that the second one will be better. It's one of those rare situations where the sequel is better than the original. Anyway, good stuff. Thanks for having us read that. I appreciate that as we're waiting for Judge Boyd to start day 4 of this trial. Just do a quick little check. She often starts at 10:30 on Fridays. She told the jury to be here early and that we were going to go as long as it took to get all of defense's witnesses in. How far away is Colton County from me? Colleton County is a 4-hour drive. 4 hours, 41 minutes. So I could probably make it a 3. No, just kidding. 320 miles. That's some good math. 319 exactly by my count. But I could get there and not even have to go to Georgia. Steve N says, Murdaugh Part 2, now R is making sequels? Please don't tell us you're selling out to Disney. There will be no floppy-eared Jar Jar Binks in the sequel.
You are banished from the state of Georgia.
Let's see. Yeah, the new spicy maple bourbon pickles are harder to find. New labels, smaller jars, same price, but they taste the same. By the way, Steve N, OG, 31 months. Thank you, my friend. Good to have you here. I'm excited. I'm really excited for Murdaugh. Not excited for Letitia Stout. I was terribly disappointed that comes back. But Murdaugh would be a fascinating one because it is circumstantial. I mean, we've got little bits of cell phone video evidence. Unfortunately, yes, Letitia Stout's going to get a new trial as well. Last I heard, I listened to Creighton Waters and the Attorney General yesterday, I think it was, down in South Carolina, talking about what their plans are for the trial part 2, the redo of this. They're aware of the instruction, the guidance the Supreme Court gave on the financial side. They've also said that part 2, it's a different trial. When they started part 1, they didn't know what was going to happen. With the financial stuff. It was still a question mark. Now that financial stuff has all been decided. So this will be a different trial on that front. Everyone's getting retrials. Will Buster be front row? Good math on a lead foot. 4 hours isn't bad. I can do a 4-hour drive early in the morning. Lisa, member for 29 months, says Murdaugh was how I found Brandy and then RA. Still here. LOL, yay. I'd love to have Brandy back on that one. That would be amazing. Not just the podcast. She did great on those, but actually have her back on YouTube for it. That would be great. We need Zach Anderson to get a new trial. That's one I also feel should be a new trial. I don't know where his appeal's at right now. I have not heard. I was approached and asked if I would provide testimony if needed for that. I don't think it will come to that, but I don't know where they're at. Zach Anderson definitely needs a new one. That was another corrupt one. I'm on the boat where I say I think he needs a new trial, but I don't disagree with the outcome. I believe the process was flawed, and my conviction is that you can't have a good result from a bad process and call it good. It's the same thing that, you know, two wrongs don't make a right. Brandy's doing podcasts and doing really well at that. And she's also done some major collaborations. I mean, she's been on a commentator, I think, on Law and Crime. She's been invited on. She's just amazing. And she's married now, and obviously life has changed and is busy for her. But she still loves true crime. She's back on YouTube. Did she move permanently to the other channel? She's back in covering the Alec retrial. Awesome. Awesome. She has so much information there. So much to offer. Amber's mom, thanks for the gold coin. Appreciate that. Saw a new brand of pickles to try called Hot Girl Pickles. I think they're just blatantly selling pickles with sex now. That's a bit of a stretch. She was live last night and missed it. I've got to catch up with her. She's so much fun. I'm hoping, like fingers crossed, that actually I had the opportunity to send some information, very specific information to YouTube today, and I'm hoping that we get granted the ability to do something that only a few select channels have right now. So I'm really hoping it's technology that would enable us to do some really cool things. Which would make the watching process just so much more fun for y'all. Anyway, hold our breath for that one. Virginia Little, member for 25 months. OG says, hello friends, been off watching another trial, but I miss my friends. Welcome back. Good to have you here. SMB Pickles, gifted a membership. Thank you very much. I like the name. What was your old name? What was your old name? Hank Dwayne Matre, a big hello from the Netherlands, best channel on YouTube. Thank you very much. Is that an organ? Is that a pipe organ? Like pipe organs. Letitia was the first trial I watched too. It was brutal. That was a tough one. If you sat through that one, that was really difficult. Everyone should get a trophy or a badge or something in Gannon's honor on that. Denise Feldman Ersland, she will stream Murda live, announced it Wednesday night. You're still in her outro. That's great. Wonderful. That's going to be great. That's going to be awesome. Is she still on 13th Juror? Or I know she was using another channel through a collaboration before. What's Brandy been? Brandy has been excelling in the podcast world, just absolutely just rocking it. So my first comment on RA's stream was during Letitia, May 2nd, 2023. And look where you are now, Greeners. She was doing Crime Junkie Jury. Okay. Rob's taking a little break. He does hope to be back soon. Rob just needs to decide if he wants to be a YouTuber or a lawyer, because his full-time lawyering job really makes it hard to be a YouTuber. So I hope we get more of Rob, because he's a lot of fun, and teaming up with Ian is just like, that's a great tag team. All right, we are done with the readings. Let me go ahead and clear out this pinned message. Still checking for Judge Boyd. If anyone sees Judge Boyd go live, give us a shout, because we're going to be jumping to that court here in a minute for day 4. And not here yet. It's practically lunchtime. It is. Yeah. Yeah, he's okay. Rob's doing great. Just all that mischief to handle. Not even 9:30 yet. Well, soon. All right. Anything else? Let's see if there's any other courts we need to pop in or can pop in on this morning. Life Minecraft court was active this morning. They're not now. Okay, we do have Judge Simpson, his landlord-tenant stuff. He's in a break right now. We'll give him a minute. Minecraft Court is live. Let's go check out that one. See what's happening down here. We call this Minecraft Court because the jury portion, which is the bottom left-hand corner of the screen, is pixelated like Minecraft, the game.
Thank you, Your Honor. We are present this morning in the matter of State of Ohio versus Majidatia. This is case number 19 CR 1073. Present open court this morning is the defendant with his attorney. We are present on a motion for judicial release. This is actually the second motion for judicial release filed in this case and a request for a hearing. The state did receive the motion and did file a response not objecting to this. The victim's family is also here and was informed of this prior to the state's response, and the state is prepared to proceed today.
All right, Mr. Perez.
Thank you, Your Honor. Your Honor, we submitted a motion on this case that is pretty extensive on behalf of Mr. Attia. His name is Majid, but he goes by Max to everybody who knows him. He's been incarcerated for about 5 years, 8 months. He made a bad decision a long time ago, 8 years, about 6 years ago. He regrets that decision. He's done, tried to apologize, and I think he's written a letter to the family, the Manukans that have been hurt by this whole situation, where the victims here. He's very remorseful. He's done everything he can while he's been incarcerated to prove to the court and the community that he's a worthwhile candidate to be a full-time citizen. He obtained a college degree while he was incarcerated. The court might recall before this event occurred, he was attending Cleveland State and would have had an engineering degree in a couple of quarters had he remained out. He has done more incarcerated than any client I've ever had. I've submitted numerous exhibits of all his accomplishments. He's attended basically every program that is available. He's had glowing remarks from prison personnel, the wardens, from the guards, the teachers he's had while he was in there. He has tutored other inmates in addition to everything else he's done. I think the court can be assured that if he is released and put on probation, that he will comply with any of the rules of probation, that he will not harm anybody in the community. He's not a risk to anybody. So there's so much I could say about him. I mean, I've submitted an extensive motion with all his accomplishments, all his certifications, all the support he has in the community. His family and other community members are here in support of him. I'm very impressed with him, with what he's done since this incident. I'm impressed with how remorseful he is, how well he understands what he did was wrong. And he is genuinely remorseful. He's not just saying that. So I would ask the court to consider everything we've already filed rather than rehashing it all in front of the court at this time. I've attached, numerous exhibits to the motion that outline everything he's done, support from members of the community, and we would ask the court to grant him judicial release. I don't think he needs any transitional control because of the fact he's taken every course that would be offered at NeoCap or anywhere else. He's tutored other individuals in those same areas while incarcerated. He's a low risk before he went in. He's a low risk at this point based on the prison guidelines. So I would ask the court to consider granting him shot probation without transitional control. He has a job waiting for him. His family, he'll be living with his family here in Menor. In Willoughby Hills, right?
It's Menor.
In Menor. He's living with his family in Menor, and I have every confidence that he'll be a great candidate for a probation judge.
Thank you. Mr. Attia, what do you want to tell me in support of this motion for judicial release?
Well, honestly, Your Honor, I applied myself, man. I try to better myself each and every day. While I was in prison, I did everything I can. I took advantage of all the resources that were available to me. I completed all the programs that I could. I'm sorry for what I did that day. I'm not a bad person. I just made a bad mistake. And I apologize. I understand the seriousness of my offense. I understand the ripple effect behind it. I didn't just affect my family and the Finucane family. I affected the whole community. And I have a lot of love for this community, so I regret it. And I'm honestly embarrassed by what I did. And I apologize to you guys. I hope you guys can forgive me. If not today, maybe sometime down the line. You guys didn't deserve that. So.
Wow, usually the judge doesn't let him address the victims like that.
Your Honor, the victim's family is here, and I think I want to give them an opportunity just to make a brief statement.
All right, just state your name for me, please.
Joe Finucane. Your Honor, our family trusts the court in this regard. Whatever decision the court makes, we'll be okay with.
All right, thank you.
Wow.
Go ahead.
Your Honor, in reviewing this motion for judicial release, I had extensive discussions with the victim's family, the police, and our response in this case was not taken lightly, given everything about this case. But ultimately, I think what Mr. Finucane just stated is exactly how the court feels, or exactly how the state feels as well, which is if this court determines that judicial release is appropriate, the state doesn't want to stand in the way of that and trust the decision of the court. We noted that in our response, not objecting, and so we defer to the court, obviously, on this.
All right, thank you. Okay, I've gone back and reviewed the pre-sentence report and the victim impact statement. The docket in this case, and I remember the trial well, it was in 2020, I believe, the fall of 2020. And what struck me during the course of that trial is how somebody who's so intelligent can do something so stupid. And you managed to manipulate this other fellow, I forget his name, it escapes me at the moment, into doing what you did. Mr. Downing had mentioned when we were in chambers about, in reviewing Mr. Perez's motion with the attachments, what was accomplished while you were away. And quite a bit was accomplished while you were away. And by comparison, most individuals who go to prison accomplish drug usage while they're away, and that's about all they do. So that I've taken that into great consideration. I've reviewed in this motion. I know you filed a motion previously last fall that I denied but I went back and reviewed all the information that was, the exhibits in that motion, and reviewed this motion as well. So, how old are you right now, Max?
I'm 27 years old.
Okay. And when this all happened, I think you were 20 or 21, on your way to a engineering degree, right?
Correct.
All right. What else? What do you? I let you out. What are you going to do?
Go work for my family's business. I'm going to take care of my family, start my own family. I'm thinking about going back for my chemical engineering degree too.
How much did you have left in order to get that?
I have 1 year left. Franklin University also offered me to take a master's program online, so I was thinking about that as well for the business.
All right. Well, in consideration of the entire record, I'm going to grant your motion for judicial release. I'm going to place you on community control for 5 years.
Wow.
You're to not utilize drugs in any manner, including marijuana, which in Ohio may be legal, but you're not to use it. You're to have no contact with the victims, at least at this point. I'm not sure if your license is still valid or not, but you're to get a valid license. You're to maintain full employment or full-time schooling, or a combination that equates to of both that equates to full-time. And you're going to complete 200 hours of community service. Ms. Warren, any other terms you think are applicable? Okay. You understand the terms?
Yes, sir.
Okay, if you don't comply with the terms, the state will file a motion to terminate your community control, and if it finds you violated, there's another 2.5 years or thereabouts left, up to another 4 after that. So when I sentenced you back in 2020, 5.5 years ago, and I looked at your record, you had no record. Okay? And I gave you the definite minimum I gave you of 8 up to an indefinite 12 was the most you can get as an indefinite minimum, and I did that for a reason. Okay. So here's your opportunity to avoid any more of that stuff.
Thank you.
Anything else, Mr. Downing?
Just ask for an additional condition of no contact with the co-defendant, Dewan Lewis.
No contact with Lewis either. Mr. Perez, anything further?
No, Your Honor.
All right, we're adjourned.
All rise.
Wow. You don't see that much. It sounds like, I don't know what it was. I don't know the charges, but it sounds like obviously this is not something where someone lost their life. It's most likely going to be more along the lines of a financial type loss or something like that. But he did serve most of his sentence, 5 of the 8 years that he could have served, and put all those 5 years to good use. He filed the same motion back in the fall of last year, and it was denied. But the judge has looked at it again and said, okay, now I'm with you. I can do that. That's pretty cool to see. The reason why I say that is because justice doesn't always mean locking someone up forever. Justice means that in the interest of safety for the victims and in the safety of society, and there has to be a punishment aspect of that as well. Justice can be served with a short sentence where change occurs. If you go to prison and, like the judge says, all you do is learn how to use drugs better or more or hide it better, that doesn't serve anybody. When you get out, we're going to have more problems. This defendant went to prison and literally changed his life from that one stupid decision, the one blemish on his perfect record that put him there. It sounds like he's not going to be going back there, and we rarely get to see it like that. The victim's family not opposing help. The state not opposing helped as well. Both of them saying, Judge, it's up to you. You know, we're not going to stand in the way in the family. I mean, that's huge for the family to say, you know, the person that hurt us, whatever way that was, you know, we're not going to stand in the way of them getting another chance. So, really awesome to see. All right. Let's see. It is now just past the time we expect Judge Boyd to be live. And yet, she is not. The jury was supposed to be in at what she said, 10 o'clock. I thought it was 9 o'clock. But we also know that the judge had an appearance to make at an elementary school today around lunchtime, I thought, where she was going to go and be a special guest or a visitor to a school. And she said, I'm going to keep my word to them. And it sounded like that was the last thing we heard from her yesterday. So it sounds like she may be double booked today. So we'll have to just basically play it by ear and see if we get a case here or not today, or if that's going to be delayed till next week or later this afternoon. It sort of got conflicting messages because she also told us that defense will have all their witnesses done today. So I don't know how she's going to accomplish everything and keep a jury longer than she told them they'd be here. All right, where else do you want to go? Let's see. Judge Simpson is doing his landlord-tenant pre-case spiel with the PowerPoint presentation. It's terrible audio, but we can jump up here to. Oops, that's the wrong one.
In St. Joseph
Judge
County
Middleton.
Circuit Court on May 24th of 2000, of the felony offense of possession of methamphetamine. Do you acknowledge that?
What year was that?
Would you repeat the year, Your Honor?
May 24th, 2019, 45th Circuit Court, possession of methamphetamine.
Yes, sir. Yes, Your Honor.
And September 12th of 2016, 45th Circuit Court, once again, possession of methamphetamine. Do you acknowledge that was a conviction and that was?
Yeah, yes, sir.
Are there any probation or parole consequences to this plea?
No, there are not.
We need some foliage, Greeners.
All right. I think we've covered the fact that there will be no later claim of outside off-the-record promises or coercion. Once again, Mr. Yoder, was there anything that anybody said to you outside of the purview of this hearing which would have threatened you or induced you to enter this plea other than what was placed on the record here because of the plea agreement?
No.
Yeah, we can jump into Simpsons.
All right. You seem very clear-headed here this morning. I find that this plea is voluntarily and knowingly made, and I will accept the plea to that charge of assault with intent to commit great bodily harm by strangulation as a no contest plea. The next thing we need to do is schedule the matter for sentencing. We had worked on that point, and the matter has been scheduled in front of me live here in this courtroom. I have a notice here. got so many notices. I believe we picked June 19th. Let me look at that date.
That's correct, Judge.
That is correct, Your Honor.
June 19th at 11 a.m.
Thank you, Your Honor.
Mr. Yoder, I will be the judge handling the plea in this matter. Normally, I would ask if you would have any objection of being assigned to another judge. We do have other judges that are fulfilling our circuit court obligations, but I'll be handling this one. And this is an assaultive offense. I'm going to cancel the bond.
Sounds like he's got a court
There's
date.
no sense to leave it open.
We're going to jump to Judge Simpson's here in just 1 second. Let's do that now.
At the time of sentence,
there we go. Quick jump as he just kicks off his landlord-tenant day. This happened just a little bit ago. Haven't pre-watched any of this.
The 14A District Court, County of Washtenaw, State of Michigan, is now in session. All those having business before the court draw near. The Honorable Judge J. Cedric Simpson presiding.
And good morning. Court calls the case of Jack Sophia versus Kathy McMurray, excuse me.
Yeah, good morning. Tom Piotrowski on behalf of the plaintiff. It's not the way you wanted to start your day, I'm assuming?
It's always a pleasure seeing you.
This is for possession, Your Honor.
All right. McMurray here?
I did not see her.
All right. She is not here. If you'd like to take a default, I see the second is paid for. Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Your Honor. Thank you.
Go ahead.
Your Honor, all the documents, this is a case for possession only. All the documents have properly been prepared and served upon the defendant. Her not being here, she has not responded to the best of my knowledge. Everything has been properly handled.
Yes, in court's review of the file, everything is in order. Defendant having failed to appear, judgment to the plaintiff. That is by default for possession, no redemption amount, writ issue in 10 days. All right. Thank you,
Your Honor. Have a good weekend.
You do the same.
Thank you, sir.
120 Ypsilanti Group, LLC versus Deja Cargill.
Thank you. Good morning, Your Honor. William McInnes, P80757, appearing on behalf of plaintiff.
Good morning. And Ms. Cargill, good morning.
Good morning.
All right, this is non-payment of rent case. What is the plaintiff's claim?
This is for possession only. Rent due and owing is $2,615 plus court costs of $168 for a total amount to retain possession of $2,783.
All right. Ms. Cargill, how are you intending on trying to get this paid?
Okay, I just started working like within April the 18th, and I told them I will make payment this Friday coming up. So I just received court papers within the last 2 days. So I was
all right.
Payment this Friday.
Are you going to be seeking assistance of any type?
Yeah.
Okay. So if you seek assistance, there's a form that came in your packet called a rental assistance form. You'll need to fill that out and get that to the court. You have to file that with the court by next Wednesday.
Okay.
Is there anything that you can pay between now and next Friday?
Now and next Friday. I can pay like $5.
Say that again. You keep turning away from your microphone.
I can pay $500. I have earplugs on.
Okay, you can pay $500. Can you pay that by the 21st?
Yes.
All right, pay $500 by the 21st.
All right.
I would encourage you to contact plaintiff's counsel and see if something can be worked out prior to the next court date, okay?
Okay.
We're jumping to 14B.
All right.
After you were released from the Washtenaw County Jail on February 11th. So, Attorney Van Blauer, come.
Yes, Your Honor. At this time, we would request a personal recognizance bond for Ms. Shiner, or in the alternative, a low cash bond. She was incarcerated in the Wayne County Jail for court dates that had occurred in March or that were to occur in March. She had been incarcerated in Alpena County following her last court date here until February. She's currently homeless and juggling a few different cases, so she got her dates mixed up with the community corrections. And again, if you're not inclined for a personal recognizance bond, we would request a low cash bond so she can get some credit for time served, because I do see that she may have some other cases she's going to be seeing on this afternoon that may hold her in the county.
All right.
The defendant is holding very still, but I can see there people are walking in the door right at the top of the screen above her. So she's not frozen. She's just chilling. We're just waiting here, Judge, for your decision on the bond. She might be looking at the other cases as well that might be holding her.
All right. Okay. So at this time, the court will set a hearing on the bond violation as well as a pretrial conference date. That will be June 30th, 2026. That will be at 9 in the morning in front of Judge Washington. The bond conditions in both of these cases are continued, so you've been ordered to go to testing in both of these cases. Basically, none of the conditions are changing. All right. At this time, I am continuing the bond in both of these matters. So for the matter ending in 0010, That's a $10,000, 10% bond. In the matter ending in 445, that's a $5,000, 10% bond. I have made notes in both of these that these may convert to personal recognizance bonds if you are given personal recognizance bonds in your other matters. Okay.
Thank you.
You're welcome. So, Attorney Van Blarkum, did you have anything you wanted to add?
No, that was everything from us. Thank you, Your Honor.
Okay, thank
I
you.
appreciate you.
Then, yep, if you don't have any questions, you're free to go.
Thank you, thank you.
Good morning.
Good morning, Mr. Johnson. Give me just a moment, please.
This is in the same court building, I believe, as
Sorry, give me
Judge Simpson.
just a moment.
So it's just down the hall or upstairs or something. Judge Webster's back. Sweet. Take a peek at that one.
All right, sorry about that.
That's okay.
I'm looking for Judge Webster. And it's not coming up on my feed. Hang on. What's the name of her court? Kansas.
Now calling case number 26T00079. This is Ypsilanti Township versus Joe Nathan Johnson. Names for the record, please.
Joe Nathan Johnson.
Good morning, Your Honor. Assistant Public Defender Nicole Van Blarkum with and on behalf of Mr. Joe Nathan Johnson. At this time, Your Honor, we would just reserve our bond argument for when it is appropriate.
Okay, thank you. And what I am seeing is that on May 12th, we received a community corrections bond violation alleging that you had not reported to community corrections for testing as ordered. I had given you until the close of business on May 8th. The court is in receipt of a note from the University of Michigan Emergency Department that you had been in the ER on the 7th.
Yeah.
Okay.
I got hit in the head with a 2x4. I'm 2x6.
Whoa.
Helping the guy do some work, and he 2x6 slipped out of his hand and hit me in the. I got 4 stitches in the top of my head.
Oh wow. Okay.
Not stitches, staples.
Oh geez.
I thought it was an
That's
assault
what
at
happened.
first.
That's why I couldn't make it.
Okay. All right, and I do see what. When did you get out of the hospital?
The same day, but they gave me bed rest.
Okay. All right. And when this happened, did you call your public defender?
I called there. They're supposed to let them know Well, this
Yep,
happened.
he did speak with our office, Your Honor. We just hadn't received the doctor's note until this morning.
Ah, okay, thank you. Attorney Van Blargum, do you see in your notes, like, when was your office notified?
Let me check my email because I just spoke with them this morning.
This is really exciting, but he
Like,
was
I
in the
understand that you just
hospital,
got
got
the
hit in the
doctor's
head.
note today, but
Let's
if you
check
have
with
a-
Judge
I've been
Wiggins.
notified him since, I notified him Monday, really.
Okay. That would, yeah, that's what I have in the email here. They had been waiting on the email, and then I was able to reach his daughter this morning, and she was able to just take a picture and text it to me, and then we were able to add it to his file. That's when I sent that over to the court as well.
Correct. Judge Wiggins, here we come.
Thomas is bond in this matter. It's my understanding that Ms. Strong turned herself in. It's my understanding that she is an on and off lifelong resident of the area. She's been at her current residence. She reports for about 8 years now. She lives with her 81-year-old mother, and she is the only child to her mother who is still living, and she is a primary caretaker. In that home, she also lives with her husband of 15 years and her 2 children who both attend school in the area. All of these things indicate a very strong tie to the community and low risk of flight. As for public safety, minimal criminal history, and I would emphasize this is a nonviolent accusation. And while it is certainly a serious allegation, as all are, her praxis score was 2 to 3 range. All of those factors would indicate a personal recognizance, and that's what we would request.
Thank you. Ms. Lawrence, on behalf of the people.
Thank you, Your Honor. At this time, the people would just request a no contact order with the Buckley General Store. I will leave bond to the discretion of the court.
All right, thank you. The court does not consider Ms. Strong as a flight risk, as indicated by Ms. Prevento. She turned herself in. She is a resident of the area. I do see she is currently employed. So I am going to authorize a personal recognizance bond. Ms. Strong, that's your promise to come back to court with a few conditions. One is that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not have any contact with the Buckley General Store. No contact means no contact at all. You can't call them, you can't be in the store, you can't be on the premises.
And stay out of
I
Woolworths.
think they have a gas station there, if I recall correctly as well. You can't be at that gas station either, nor can anybody acting on your behalf. If you are found to be in violation of your bond conditions, you could be arrested without a warrant and brought back to jail and have your bond revoked. Do you understand that?
Yes, Your Honor.
Okay. So, Ms. Strong, at some point, you're going to be released from the jail today. You're going to have your next court date with you upon your release, so make sure that you keep track of that. And then probably, I'm going to say by probably mid next week, you should be hearing from the public defender's office. If you don't, you're going to want to reach out to them to see who's been appointed to your case. All right?
Yes.
All right. Do you have any questions for me at all?
No.
All right. Thank you, Ms. Strong, and thank you, Wexford.
Thank you, Your Honor.
Thank you.
Or you can leave.
All right, court next calls the people of the state of Michigan versus Megan Jean Salisbury. This is a Missaukee County case. All right, Ms. Salisbury, are you able to see and hear me?
Yeah.
All right. I'm Judge Wiggins in the 84th District Court in Wexford County, sitting by assignment today for the 28th Circuit Court to handle today's arraignment. Ms. Salisbury, you are brought before the court today on a alleged probation violation. It is alleged that you violated the terms of your probation in count number 1 of condition number 3, that report to your probation officer as directed, that on or about July 15th, 2025, you failed to report to your probation officer as directed and your whereabouts were unknown. Count number 2, it's alleged that you violated condition number 4.16, that you must obey all court orders. That on or about August 8th, 2025, you failed to appear for a request and summons for a probation violation. If you are found to be in violation of your probation, you could be sentenced to what you could have been sentenced to under the original charge, which was count number 2 in this case. Let me get the information here. Of prisoners bringing contraband into a correctional facility which is a 5-year felony and or a fine of $1,000. So you could be sentenced to up to 5 years. You understand that?
How'd she do that?
You do have the right to have a contested hearing in this regard, in which the prosecution would have to prove to the court that you did in fact violate the terms of your probation, or you could enter a guilty plea to that violation.
Almost
you also
like
have the right to be
payphone.
represented by an attorney at all phases throughout this process, and if you could not afford one would be appointed to represent you, but you may be required to repay a portion of that expense. My first question to you, ma'am, is today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
Request the appointment of one.
All right, the court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea to the probation violation, and we'll set that matter for a contested hearing. You also have the right to be considered for bond. Your bond is based upon the probability of you appearing for future appointments, the seriousness of the offense charged. Ms. Odell, what can you tell me about Ms. Salisbury? Obviously, it looks like she's been gone since July of last year. Is that accurate?
That's accurate, Your Honor. She's been absconded for many months. I also would note that the bench warrant will likely be amended, and Ms. Salisbury is aware of that. When she came into the jail, she tested positive for several controlled substances. So based on the absconding and the positive test, I would recommend she be held without bond at this time.
All right. What were her original guideline range?
She actually has 2 dockets, Your Honor. The bringing contraband into prisons guidelines were 2 to 17. And she has a docket 24, 34, 34, possession of meth. Guidelines 0 to 17 on that one.
All right, thank you for that. I missed that we were here on 2 dockets. I apologize. So, Ms. Salisbury, I want to make sure that I arraign you properly on this. So you're also here on case number 243494FH, which is a possession of controlled substance methamphetamine, violation of your probation in that case as well. The allegations are the same in both files, but if you are found to be in violation of your probation in that file, again, you could have been sentenced to what you could have been sentenced to under the original conviction of the controlled possession of methamphetamine, so up to 10 years on that file. Do you understand that as well?
Yes, sir.
And on that file, are you still wishing for the appointment of an attorney?
Yes, sir.
All right, the court again will make a referral to the public defender's office for the appointment of an attorney in that file. Given the allegations that the defendant has absconded from probation since July of last year, and that there's likely to be an amended violation request for testing positive, the court is going to remand the defendant to the custody of the Missaukee County Jail until a contested hearing is held in this matter. Ms. Odell, is there anything else for the record?
No, thank you, Your Honor.
All right, thank you. Madam Clerk, were you able to get all that? Okay. All right.
Yes, sir.
Thank you. So we are adjourned in this matter, and we'll get it set on Judge Elmore's docket. All right, thank you.
Thank you.
And he's done. Just saw a Arkansas pit maneuver. Where the car flips and the kid crawled out just fine, uninjured. Driver, however, was in worse shape. Was able to crawl out, but probably needs some medical attention.
When are we going to break for lunch, Judge?
I just looked at the docket, and Judge Boyd has, for today, the 15th, this case starting at 9 a.m. That was filed on the 2:06 p.m. yesterday. So sometime after 2:06 p.m. yesterday, she decided to do something different with this case as far as her start time. So it is what it is.
I'm about to catch a whooping.
Looks like it's going to be an afternoon start. She started at 1:30 p.m. other days on afternoon starts.
Have them send someone with more experience.
See if there's any documents. How do you get documents through Bexar County? So I'd love to be able to pull the body cam and the video that we were supposed to see from the Tesla. Haven't seen any of that yet. Thurston County's live. Let's see if we can get some foliage going here.
To really participate in and take seriously is mediation.
Oh, yes.
Now, the Dispute Resolution Center mediators are here because they are very skilled, very experienced in bringing people together to resolve their conflicts peacefully and in a way that works for both parties. Okay. So they're here to help you come to that mutual agreement that you can come to. And then when you go away from here, having resolved your case, you can live with the result. Now, you may not get everything that you want. You may not get everything that you wrote down on the paper when you filed the case, but you can get something that you can live with.
Yeah, this is small claims court.
And
this is our best
something that's
shot
fair,
at getting some trees or foliage
and
or
if you're here to
shrubbery or
defend against the
lawns
case, and you know the reason you're here is because you can't afford to pay. You know you may owe some money for something, but you don't have all that money up front. Well, when you resolve a case in mediation, you can come to agreements that say things like you're going to pay over time. You're going to pay a little bit each month, pay it off. Or, you know, if it's something to do with damage to property, you can come to an agreement where you're going to fix it or do something like that to help take care of the damage. And these are important because the court can't order those things, right? If I hear your case, I can't order somebody to make payments or to accept payments. Okay, that isn't part of this. Keep in mind, it's a judgment. One party owes the other party a sum of money. It's a piece of paper that says just that, and that's all. You can be as creative as you want to be when you resolve your own case, and the mediators can help you to do that. And I know you probably have tried to resolve your case with the other party, and that, you know, that's great. But you're here anyway. The mediators are really skilled at getting people to sort of focus on the important parts of the conflict, the things that once they're acknowledged and brought out can bring the conflict to a peaceful, mutually acceptable resolution. They're good at that. That's why they're here. They're going to help you do that. So I'm going to turn the courtroom over to the administrator or to the mediators, and they're going to go through the mediation with you. And I'm going to ask you, when you do that, to go into it with an open mind and with an earnest desire to really come to a reasonable and fair and acceptable resolution to your case. And I think you can probably do that. The mediators ask that when you're in mediation with them, that it's just the parties and not any witnesses or support people or anything like that, just the parties themselves who have authority to settle your case, okay? And no other distractions, all right? So when the mediators are finished with you, I'll come back to the courtroom and I'll deal with any cases that only have one party present. And then if any cases remain unresolved by you, then we'll go ahead with them. Keep in mind that we have a lot of cases this morning. We've got till noon. Any case that is not heard by noon is going to be reset. And Jace, how far out are we resetting cases?
It's going to be mid-August.
So you're looking at mid-August minimum. Okay.
They are pushing
so if that
so
makes any
hard
difference
for
to you,
mediation.
then, maybe there's an additional incentive to really dig in with the mediators and do something that works for you. Okay. All right. So I'm going to ask you, please give your attention to the mediators and good luck in your mediation. You have a question?
The judge hates this.
All right, please give your attention to mediators.
Good morning. My name is Sue, and I'm here with Denise and
Hi,
Joanne.
Denise.
We are, as the judge noted, volunteers from the Dispute Resolution Center. Someone from the Dispute Resolution Center has been appearing in small claims court for many years. We don't work for the court. We don't give legal advice or financial advice. Our job is for us to assist you in coming to a settlement that works for both parties.
Hey, Joanne, welcome.
So what I'm going to keep it really brief because there's so many cases we need to get started.
Segundo,
Your mediator
Alfonso,
will
he
go
just
through
left
in a
for this
little
part.
more detail about how we will proceed with your case. But in general, please, what we ask of you is to be willing to share pertinent information with the other party, be willing to listen to the other party, and try to come up with some solutions that might work for both of you, even if either of you don't get everything you want. Please be respectful to each other. That's really important. The mediation is confidential, so whatever you say in the breakout room is not part of the court proceedings, and it's not part of the streaming YouTube or anything like that. If you do reach a settlement, we have a form which we will fill out with your language. Once that is done, you are free to go. You don't have to wait around for the judge. We just let the clerk know that you've reached agreement, and you'll be getting a copy of that digitally to sign later in the day. Joanne and Denise, did I miss anything that needs to be covered?
Nope. Thumbs up from Denise.
So the clerk is going, thank you. Denise, are you there? There you are. The clerk is going to put you in a breakout room. For those of you who are in the courtroom, you'll have to the clerk will let you know how they want to handle that. If you do end up in a breakout room without a mediator,
Denise is wearing
feel
flannel.
free to start discussing the case if you feel comfortable doing that. If you'd rather wait for a mediator to join you, that's fine also.
All right, here we go. Everyone's going to get shut off to different directions. Once they're all gone, judge can come back, address the issues as needed. We have an imposter.
Right. Sue, I did want to ask you real quick. Oh, did I lose her? Okay. One of the other mediators, either Denise or Joanne, I have a bunch of people here in person in the courtroom, and I only have one laptop available for them. So for one of the cases that both parties are present in person, if I put them in the same room, would one of you be able to be willing to mediate with them? So if one of you's, so you would be online, but the other two parties would be in person.
That's like having a boxing match with a virtual ref.
That's something.
That's terrible.
I think it's a little more. I think it's a little more awkward to do it that way. I understand the efficiency aspect of it, but if you've got two parties that are, and you've got somebody on the TV squawking, right?
Mm-hmm. Okay. Yeah, that's fine. We'll revisit that. We'll figure something out. All right, so I'll add you to the room here.
Okay.
All right, grab some parties. Grab some parties, see if you can sort it out. Remember, if you don't sort it out right now, the side that wants to get paid won't have a chance of getting paid until about August. It's not a legal term, but they're not legal professionals, nor are they giving legal advice. They're just here to listen and then repeat what they heard minus the expletives to the other side, and vice versa. Joanne's like, okay, which one do I want? I'll take that one. I'm going to take this person right here. Let's see if the judge comes back. I'm hoping. I've got my fingers crossed that there's some foliage or foliage, as the case may be, today. Denise is back already, waving the pen around. Grab some people, Denise. Go mediate. It'd be funny if Frog showed up. Josh says, I'll give 10 memberships if we have a tree or fence dispute. We've got to get to it in the next, by noon, Washington time. So we're on a time crunch. Oh, and then the court kills the feed. See if they fix it. Nope, everyone's frozen. See if they have to restart a new one. Showing they're live. Maybe they're just still having the internet issues up there. Nope. Still having our issues.
Getting our text message reminders.
Yeah.
Okay. And let's see, address, we've had mail come back. So what's your good mailing address?
It is 123 Sesame Street in Anywhereville, USA. That gets to me. 123 Sesame Street.
By Briar Lane.
No, Sesame Street.
76.
123 Sesame Street.
Either one of those work or not?
There's a Sesame
you could use
one.
it.
Okay, 1027.
No, 123. Judge, we've been over this.
98.
Nope.
Sound right?
Sounds right.
985.
No. This is so hard.
985.
Hey, just stop saying it.
That zip is all wrong.
I think 985.
90210. Try that one.
So we need to fix that zip code. All right. So now I want to be sure you and I are clear as to what's expected. So by that September 10th date, you got that substance use eval done, you've got your jail done, all that proof into the court, not just you talking, but you got proof into district court. You can talk to probation. They'll help you as well if you need it, but let's get it done. Earlier, we allowed you to do that as 1 day in custody or 15 days on EHM. So either way, but you got to have it done by September 10th. All right?
Okay.
Okay. And then stay clean and sober, stay law abiding, get to court. Don't drive unless you have a good license and proof insurance, everything that DOL requires, including the ignition or lock device if they require that. And until you are in treatment, I want you to show 2 sober support meetings per week. And I wanted that to start no later than Monday. So start finding a place you like. You could go tonight, but no later. Your first one's Monday, which is the 18th.
Okay.
All right, and then you show that proof to probation, and they're going to be looking for it. They need to get it. All right.
Okay.
Okay. So I think that's going to support you as you get yourself going in treatment.
Yeah.
All right. Any questions right now?
I don't think so.
Okay. So I look forward to seeing you in September with everything on board in treatment, jail time done, and that we've seen 2 sober support meetings per week.
Okay.
All right. Good. All right.
Thank you.
Anything else, Ms. Myers?
Nothing further. Your Honor.
Okay. Well, have a good rest of the day, and you're welcome.
You too.
Let me finish up all this order here.
Waiting for court 3 to start again with the civil stuff. Give it a minute. The small claims calendar is usually a lot of fun up here in Thurston. They get some wild ones. Let's jump to another Thurston court.
And today, I believe that there's a plea of guilty form in the judge's folder.
Hey, and good morning, Ms. Gonzalez. I see you on Zoom there.
Good morning.
She's just going to plead guilty. Let's go back to our favorite defense attorney then out of Thurston. Let's see. Oh, she's right here. Still no Judge Boyd. Waiting. Might be after lunch. Do you want to take a lunch and we'll come back, or? Least favorite attorney. She wins a lot for being a defense attorney. Court 3 is not back up yet. Just waiting for the civil.
Right. Where am I headed now, Ms. Rowe or Ms. Clark?
Let's go, Ms. Rowe.
I have 2 matters I can address.
Oh, Ms.
Okay.
On the 9:30 calendar, numbers 8, 9, and 10, I have Mr. Mackenzie White, who is present in the courtroom.
And Mr. White, why don't you join us? Morning, sir.
Good morning.
And Ms. Clark?
Your Honor, just recently, the state and I have talked about a resolution. So there is one on the table, but one of the affirmatives that Mr. White has to complete, he needs to find one that will accept his insurance. So I've submitted a speedy trial waiver for all 3 cause numbers. We're asking for 30 days.
All right. So to cancel May 15, well, that's today, excuse me, May 27, 28. You know, trying to see where a sensible place would be to put this. All right, so cancel all of the dates on these, set a new, what? Maybe we'll just set a,
I believe that we'll need a COPUS hearing.
okay, we'll do that. So, Mr. White, that's the idea, is we cancel all the future court dates. We'll just give you one today. You don't come in the 27th and 28th. We're going to cancel that. All right. And then you sign this thing called you agreed to a speedy trial waiver, and that allows you more time and allows the state more time. And you're good with that?
No, you're fine.
Okay. All right. So we're just going to set, let's see, we've got, what are we doing in 30 days or so? Let's see. And then we've got your mail coming back. Or do you have a good address now?
It's not their
It's
address.
not coming back. We just had general delivery. Is that still good?
It should be. It keeps coming back there.
Oh, it was sent to Skokomish Way, so that's probably why. And now we have general delivery in Olympia, 985.
8675309, 123 Sesame Street.
Post office nearby.
Oh, okay, that's the one on
By the library.
Oh, by the library on Jefferson.
Yep.
Yeah, so that's not 98. I bet it's not 981.
Different zip
yeah.
code.
You need to fix his zip code when you're ready. He doesn't know it, but it's not. It's on Jefferson Street, which is not 98516, as far as I remember. I think it's 01 or 07 on Jefferson. Yeah. So we need to fix that. All right, so we'll get that fixed. And then cell phone, such that we can send you a text message reminder.
867 5309
78.
Okay, it's not in the docket. That's why I'm asking. All right, great. And so you got the text message reminder for today?
Y'all seen it already?
Yeah, why don't you look and make sure it's working.
Just take a quick peek.
June 17. What time you like? 10. Okay.
No, I ain't getting nothing yet.
Huh. You didn't get it. And you're sure that number? Getting it.
Give me the right number.
Huh. 783.
867 5309. That's the number.
That's good. Yeah, that one right here. All right, Ms. Clark.
Yes, Your Honor. Next, I can call Mr. Shiloh Davis. He is number 4 on the 9:30 calendar and present in the courtroom.
Mr. Davis, why don't you come on up? Morning, sir. Okay, so back to you, Ms. Clark.
Yes, Your Honor. We've done a public records request from the DOL has not yet come back, so we're asking to strike the current jury trial dates and set another hearing. I have filed a speedy trial waiver in the judge's folder. We're asking for the amount of time allotted, as well as another pretrial check-in.
Well, I'm not going to send another pretrial, but I will. So it's really trying to deal with DOL and trying to unwind what's really happened so you can have proof for court. All right. Any issue there from the state?
The state has no objection.
Okay. So if we've got expiration out all the way to August 13, I can set a trial date all the way out to, why aren't we setting trials? No Lacey trials. Okay. We can set as late as the 10th of August or the 12th of August. Do we have anything set? Do we care? We start at jury there and then back up to confirmation. An opinion Monday or Wednesday? Okay, August 10 and 11, and then confirmation, where would we put that? Late July. July 31st. All right, so we'll hand you notice today. We're getting your mail back from the Wickham Street, but we've got 173rd in Rochester for mailing.
Yes,
That's good.
Yes,
Those
ma'am.
173rd in Rochester.
Yes.
Okay, good. All right, we'll keep doing that. Text message reminder. Did you get it for today?
Yes, sir.
Good. We'll keep doing that. We're going to hand you a notice today for those new dates. Don't come in May 27 and 28. Those are canceled. And we'll just see you next July 31st. And we'll reserve some trial dates in August. So you got lots of time to work with your attorney. Okay, you're welcome. Hang on just a second while we get that to you.
Well, I think it might be lunchtime then. It's 12:30.
Defer to other council.
Okay, Ms. Rowe.
Yes, Your Honor. If we could call the Kathleen Gibbons matter. Miss Gibbons is present on Zoom.
All right, Ms. Gibbons, where did you go? I don't see her there.
Did she pop off accident?
Yeah, I don't know where she is.
She had logged back on. All we're doing, Your Honor, is proceeding to the next court date on July 10.
Okay, so waive her appearance under 3-4 and keep court dates.
Yes.
All right, and your next client?
Your Honor, I see that there is I believe I've gotten notice that Mr. Gutierrez is in the courtroom.
Hi, Mr. Gutierrez, come on up. Let's see what time. There we are, 9:30.
Your Honor,
Morning,
in
sir.
this, oh yes, Mr. Gutierrez.
So you're aware,
is our number 5 and 6.
You're aware there's a motion from the state?
I am, Your Honor, and we are not objecting to that motion. The state has moved to continue that. We also need a little more time on our case, so we're simply asking the court to set a future court date, and we have no objection to the motion to continue.
Okay, so Mr. Gutierrez, the state's attorney on this case has got a pre-planned vacation, won't be there. It's a good reason to continue. If Ms. Rowe had the same thing, I'd be giving you a continuance. So we're going to do that. We're going to cancel May 27 and 28. Don't come in. We'll give you new court dates today. And then let's see. Did you get our text message reminder for court today? Good. And still Bellevue Way in Bellevue?
Mm-hmm.
All right, good. Then we'll also mail you notice and send you a text. But let's see. Ms. Rowe, how far out for confirmation?
Your Honor, just anytime after the state's return.
Okay.
So a normal
We're
30-day would be fine.
Could grant a continuance for Tammy Silks to represent the company on a later date.
Okay. Well, I will not allow counsel to represent Belong. However, since you're here, you do have settlement authority. You can attempt to mediate and resolve the case. If you're unable to do that, the case can be reset for a later trial date.
I agree with that, Your Honor. I'm more than hopeful that we can resolve the case today, and otherwise, Tammy Silks would be more than happy to appear to try the case in a later date.
Okay. So, Mr. Corpali, does that make sense to you?
Yes, sounds good. I have one more question. There is also one more employee called Sandra Torres related to the case. Why is she not here if Tammy couldn't make it?
Well, let's not go down that road.
Okay, sounds good. Sorry.
Right. Sometimes that happens with a corporate defendant in a case that's set on for short notice. And what I want you to focus on is trying to resolve your case. And if you can't, then we'll reset it so that they can come back to court with a person who's allowed to represent them in small claims.
Sounds good, Your Honor. Thank you.
Okay. All right. Good luck to you.
Thank you, Your Honor.
Number 4 on our calendar, Diaz and Fernandez versus Carrot Self-Storage. The self-storage is asking for continuance.
Are they here?
Secure Self-Storage has
Okay.
two people
All
here.
right, then I will next call Diaz and Hernandez versus Secure Self-Storage, number 39502. And Mr. Olivares for Secure Self-Storage, the clerk told me that you were going to request that the matter be continued.
You're muted.
Yes, Your Honor. This is Paul Gingery, also with Secure Self-Storage. We do not have authorized personnel here today to represent us. And furthermore, a registered agent was not served per RCW 23.95.450. The corporate office received a certified mailing. The mailing included only a 2-page letter asking for money with reference to a court claim and a date for a hearing. As well, the service of process less than 10 days per RCW 12.40.040. The defendant emailed the court clerk asking about the claim number referenced. An email from the clerk's office was received on May 8th, 2026, with confirmation on the validity of the claim number and the court date on May 15th. Therefore, and also we do not have an authorized personnel person available today. We're respectfully requesting a continuance.
Okay. All right. So Ms. Diaz and Mr. Hernandez, I have the only evidence of service I have here is a return from the Spokane County Sheriff's Office, which is a declaration that they were not able to serve the defendants. I don't have any documentation that corresponds to what Mr. Gingery just told me, but I'll accept what he just told me. Do you have any position on the request that he's made to continue the case?
Yes, there was successful proof of service made. That's under Exhibit J. Let me see. I sent it out by certified mail with return receipt on April 20th, and it was received on April 22nd at the registered business address by the same person who accepted the demand letter as well.
Okay. I'm not going to accept this mailing with return receipt.
Why is that?
It's just signed by an individual. The signature is not legible, and one of the requirements of service, if you're going to do it that way, is that it be a legible signature of a proper party to serve, and none of that is present here. So that's the reason for it. But let me ask you about your request for your response to their request for a continuance.
I guess I'm having trouble understanding because my understanding was that the sheriffs made 2 attempts to serve at the registered business address. And I didn't really understand why it was considered unsuccessful by the sheriff in the first place.
Ms. Diaz, we've moved beyond the service issue, and the issue we're deciding now is whether to give the defendants the continuance that they're requesting.
Oh, I would prefer to just discuss it today.
Okay. And Mr. Gingery, can you confirm for me? I think I heard you say, but now I'm not sure, that you don't have a person present with settlement authority for negotiations.
That is correct, Your Honor.
Okay. I'm going to grant the request for a continuance. Jace, let's have another date.
Yeah, it's going to be August 14th again.
Okay, the next date will be August 14th, and I'll note in the court record, and the court clerk will record that there's no further need for service since the parties are present here now. So Ms. Diaz, you do not need to serve the other party. They are considered to be on notice of the new court date on August 14th.
Okay.
All right, we'll see everybody back here in August.
Thank you, Your Honor. Do you have a case that's ready for trial as well?
Which one is that? Okay. Are they in the?
They should be in the.
Jose Olivares needs to work on cable management.
All right. Is Marissa McCall present?
Here, Your Honor.
There we go. Okay, thank you. And is Prime Locations present?
Present, Your Honor.
Miss DeAndrea?
DeAndre.
Ms. DeAndre. All right, this will be case 39366 for trial. All right, so we weren't able to get anywhere in mediation.
That was mostly just because Miss Bethany doesn't unfortunately have the ability to negotiate.
Then how can she have deciding power
I'm
now?
just opening up my court file here. Bear with me. Okay, I have your claim here, Ms. McCall. All right, I'll get started on the trial of your case. I'm going to explain to you, and this will apply to everybody if their case goes to trial today, that this is how it works. I'll swear the parties in, and then the plaintiff will go first and present their claim. By that, I mean you'll tell me what your claim is about through your testimony. You can refer to any exhibits that were properly filed. And if there are any witnesses that you brought with you who you believe that I need to hear from, I'll swear them in and hear their testimony. So I'll hear from you, the witnesses, if there are any, and any exhibits that were properly filed. And then after the plaintiffs had their chance to present their case, it'll be the defendant's turn. Same process. I'll hear your testimony, any witnesses who you may have brought with you, and then any exhibits that were properly filed. After I've heard from each party, then I'll make a decision, and I'll let you know the basis for the decision so that you know that I'm following the law. I'm going to ask you during the time the other party is presenting their case or presenting their defense that you let them, that you do not interrupt them, that you address your comments to me, to the court, not to each other. And then keep in mind, if the other party says something that you don't agree with, if you don't think it's true, keep in mind that you either will get a chance to tell me your side of the story in a few minutes, or you've already told me your side of the story, so I know. I may need to ask you questions occasionally. I may jump in and interrupt just to make sure that I understand the nature of your claim or the nature of your defense, or just to keep the case focused on the facts and the issues that are going to help me to decide the case. All right, so with that in mind, I'm going to ask you both, please raise your right hand. And do you each swear that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, Ms. McCall, you're the plaintiff. You get to go first.
Okay. All right.
Please be about trees.
So I brought this claim, I believe, for the amount total of $44.50. I'm not entirely sure if that's what I have written on there. It's been a while. The reason I have that amount is crime locations had sent me, I believe wrongfully, to collections for $42.50. After I had lived with them for 6 years, I moved out in October of 2024. With that, like I said, being there 6 years, I did my best to clean it. I also included a move out or a letter from my mother who helped me clean it. I was trying to refer to the exhibit numbers. I do apologize.
My
with there
mom
being
told
so
me it
many
was clean
exhibits
enough.
on my part.
Is that what I'm hearing?
So toward the end of my tenancy in 2024, around June-ish, I had a housing, and I was a housing authority under non-elderly disabled Section 8 type voucher. And around June, I had a housing authority yearly inspection. The unit failed for, as I included the unit exhibit as well, just for the stairs were damaged at the tops and the bottom and fraying in the very center of the room. At that time, I had talked to, at the current on-site manager at the time was Stephanie Zirkin, which was Kayla Norris's mother, which Kayla Norris nor Stephanie Zirkin are no longer on-site managers. So it is
So
now
who?
Bethany.
Okay,
It
so
is now
but let
Bethany
me
is
make
now the
sure
on-site.
I have the right understanding here. The actual party though is Prime Locations. That's who you filed the claim against.
Yes, Prime Location owns the property that I rented from.
Okay.
Yes.
Okay, thank you. All right, go ahead.
Yeah, so at that point, I had gone up to the on-site manager at the time, and she informed me that when I moved in, the carpet was already about 3 to 4 years old moving in 2018. Meaning around this time, it was around 9 years old. When I moved out, it was around 10 years old. I ended up being billed around $681 for the carpet repairs, which I did pay back in June. And
What's the squeaky noises, sir?
upon moving out, I did, cleaning up, patching the walls, any like small nail holes, making sure everything was cleaned out, tubs clean, just very clean. There were a few small, like little dirt spots on the wall or like wax things. But, at my point, I thought, oh, they're going to have to fully paint this unit anyway, since it's been over 6 years. So, I wasn't too worried about all that. I wiped off as much as I could, made sure it just looked good. The blinds, sure, a few of them, had some small damages and stuff, but nothing, they were all still there and everything after all these years. A lot of my photos and videos you can see to include. But yeah, I included a timeline as well, just to kind of show, going over toward the last part of my tenancy, that I started receiving a ton of notices, and just, it almost was like harassment. At that point, when I moved out, I received a move out letter saying I owed $42.50. And at first I was blown away by the amount. I mean, I'll be honest, I was maybe expecting a little bit of charges, but nowhere near $42.50. And anything that I was maybe expecting a charge for wasn't on there. It was things that I knew were good, like the walls, being charged $2,000 for paint. But all the proof that they included was for other units, and they all have other unit numbers. They were all from different timelines before I even moved out. And they all say for reference, but none of the bills are from my actual unit. So personally, I would like to see the bills that equated from my actual unit on move out. If I am going to be responsible for this. I did try arguing it out with Prime. They wouldn't even look at my photos. They just sent it immediately to collection, and now it is affecting my credit, and I'm trying to buy a house. And even other renters, it's they see you owe a past renter and it looks horrible. I'm not on Section 8 anymore, and I'm trying to just improve my life, and now they're holding me back. I also included where other tenant that I knew and close friends with moved out, and her move out charges, nothing close to mine. And not only that, they then used housing authority rent to cover her move out damages, but that's between housing authority and them, not,
All right,
to
Ms.
this.
McCall,
So.
I'm going to need to ask you some questions, okay?
Yeah.
We're going to narrow this down. Okay.
Yeah.
I see your claim here. It says it's for $52.50, and some of the basis for it is, it sounds like because that there is an amount they are charging you. But I want to set all that aside.
What?
Okay, let's go directly to the amount you're claiming. But what have you actually paid them, or what have you actually lost as a result of them withholding your deposit?
The 200 from withholding my deposit, as well as 691 that I believe was wrongfully billed, due
Did
to,
you pay
yes, that was
600?
paid. Yes.
And what was that for?
They said it was for repair of carpets,
Okay.
but then they're asking for that money again in the current
Were
bill.
there any other amounts that you paid them or that they withheld from you?
just the 4250 that they have, put into my credit.
Yeah. Well, it doesn't sound like you've paid them 4250. They say that they want 4250 from you.
And they've sent it to collections, but
Okay. But they're just claiming that. That isn't something that you've actually paid them. Okay,
right.
So the amount of money that you've paid them, according to you, and that this is between the amount of money they withheld in a deposit and a payment that you made to them based on a repair for carpet, is $891. Is there any other money that has gone from you to them?
Not currently, no.
So the maximum amount of your claim would be $891, not $5,250, right?
Yeah, I guess, I was hoping that you would review their charges and, also,
Well, they
say,
can,
hey, this.
But if you haven't given them anything, you can't get anything back from them, right?
My thing is it's hurting my credit, and it will make it so I can't buy a house because I've tried fighting it in all ways I can. I need, a judge to say, no, this isn't valid.
Yeah, well, that's not what this hearing is for. I can't tell them that they can't pursue collection actions against you. That isn't this lawsuit. That might be a different lawsuit, but it isn't this one. Okay, so if we've narrowed this down to $891, is there any other amount? I mean, other than your filing fee and service fee, is there any other amount that I've missed?
No.
Okay. And then do you think that any part of that $200 deposit withholding and $691 bill for the carpet, do you think any of that is legitimate, or is all of it a wrongful charge against you?
I think that technically, because the move-in checklist was not adequately filled out and signed, that they did not have the right to withhold a deposit under the Landlord-Tenant Law Act. So
it's legitimate.
I believe that also equates to being doubled the deposit as well, since they didn't have the right to, withhold it in the first place. They have a signed copy of this move-in thing, but it's, I don't, the one I have is not signed, and I never remember signing that. So.
And you were in there for 6 years total?
Yeah.
Okay. All right. Now, Ms. McCall, I think I've got my arms around your claim. Okay. Now, before I turn to Ms. Deandra, I want to make sure I haven't made it so you can't tell me something that you think I need to know. I'm going to hear from her and make a decision. So if there's anything you left out, let me know.
Only other thing I could think of is back in there was around, problem is, I don't know how to provide. They had brought a wrongful eviction on me that I had to hire an attorney to help me out with. That was like 150, but I didn't provide the proof. So no, it's okay with just what I provided.
Okay, then I'm going to turn over to Prime Locations here, their side of this, and I'll make a decision for you. Okay. All right, Ms. Deandra.
Hello. Good morning. I wasn't employed with Prime Locations at this point. What I see is just the pictures of the condition of what the apartment was left in. I did look through the files in the carpet that she says she replaced the $600 she had put down. When Kayla did her walkthrough, she took pictures of the highly soiled carpet, and that's why we're asking for money for that carpet back was.
That was the $691.
To replace the carpet was $779.06 that we charged her.
Mm-hmm.
Because it was damaged.
I see that line item here on the itemized damage claim.
Right. So we are asking for the 425040 for damages, and the unit wasn't returned as unit ready. She did provide us a letter as she moved out. She wanted to thank Kayla for her service. And she did state, although I was not able to deep clean the apartment as deep as I wanted to, I felt I left it in very fair, clean condition. So she did admit that she didn't deep clean it as she should have.
Okay.
I believe
now these amounts that you're referring to, again, I'm interrupting you, I know that, but these amounts that you're referring to are amounts that you've referred to collections, right?
Yes, sir. Yes.
Yeah,
Sir.
these aren't before the court in the form of a lawsuit.
Okay. No.
Okay, gotcha. I wanted to make sure I didn't miss something there.
Yes.
Okay. Okay, go right ahead.
Okay, so we're just asking, we believe that the 425040 is accurate, and we would like you to make your judgment.
Okay, all right, thank you.
Thank you, Your
I'm going
Honor.
to take a little bit of a look here. You've both submitted a lot of material, and I do want to take a quick look at some of the documents here that relate to the carpet. So just bear with me while I do that. Okay. All right. It looks to me like the parties have generally complied with the Landlord Tenant Act as it relates to documenting the condition of the property at the time the tenant takes possession and at the time the tenant vacates. And it also looks like prime locations generally complied with the statute to make their demand for any amounts that they were withholding on the basis of any damages or non-compliance with the tenant's duties. The question is really whether the withholdings were justified by the condition of the apartment. Now, generally, when I see evidence of the condition of a rental property, the pictures that are submitted are not particularly helpful because they just aren't clear enough, or they aren't, they're not in context to where I can really make anything out on them. But I'm going to note here that in these exhibits, and even though there's black and white copies of photographs, they're still very clear and demonstrative as to the condition of the carpet. And that's not usually the case. So I appreciate that I'm able to get a look here that I can actually come to some kind of a conclusion based on. All right, so Ms. McCall, you have claimed that the prime locations wrongfully withheld your deposit and that the amount of money that you paid them for carpet damages was not justified. And looking at the totality of the evidence submitted by you and by prime locations, I'm finding that it was proper for the prime locations to withhold the deposit to the extent of the $200 they did withhold, and that the payment for the $691 in damage to the carpet is also easily justified by the condition of this carpet compared to the condition of the carpet at the end of the tenancy. And how the rest of that claim that prime locations has for the collections amounts, that is not before the court, and I'm not making any decision on that. What I am deciding is that Ms. McCall, you have not proved your claim. I'm entering judgment in favor of prime locations. And there will be no award of any damages.
May I point something out, Your Honor?
Keep in mind, I've already made my decision, and I know you may disagree with it, but I'm not gonna
I'm aware.
revisit it.
I'm just, you're looking at the wrong thing, but that's all.
What?
All right, judgment in favor of the defendant. You can both get a copy of that judgment from the court clerk at any time.
I will, but you read the
All
wrong
right.
information, but okay.
Thank you both.
Yeah. Are you
I
right?
think it's not paid for you.
Mhm.
So number 7 on the calendar, the Holly versus
Mhm.
Belong. They
You read the wrong
mediation again.
information.
Sounds like they did not reach that.
So they need
Appeal. Yes, appeal.
Okay.
You want to
All
stay
right,
back
so
here?
let's go back to Corpali versus Belong so that I can
Don't
get you a
leave,
new
Otto.
date.
Don't leave,
So
says
the
Brandy.
continuance is granted for purposes of getting a non-attorney representative for the defendant, and we'll assign a new date for trial.
It's going to be August 14th again.
Okay, that date will be August 14th at 8:30.
Brandy tells the person in the robe,
Thank
don't
you.
leave.
Sounds
They
good.
might need
Thank
help.
you, Your Honor.
All right, thank you.
Number 2 on our calendar, Ayden versus someone is ready for trial.
Mhm.
May we leave this court now?
Yes, you're good to go until August 14th.
Thank you.
Thank you.
You need a little bit of direction.
Number 8.
Trinity Townsend
We only have
taking us on a little tour.
DRC will not.
Yeah.
That makes sense. I didn't know.
So they're still waiting for an opportunity to mediate.
So we only have one
Yeah.
available, and we don't have a second one. DRC will mediate. The mediators will send the vote.
Oh, I see. Yeah.
They can't mediate.
So they may need a reset date. Okay. All right. Let's go to Reinhardt and Tollefson. Okay. All right. Since you're both here in court and we don't have a mediator here in court this session and they're all remote, I'm going to have to reset you to a time you can be here.
This is wrong.
And a mediator be here at the same time. Or if you choose to come in on Zoom, then you can mediate like the rest of the folks on Zoom. Okay. All right. Make sense?
Yeah, I prefer not to have a mediator.
Okay. Well, that's part of the requirements of our court rules is mandatory mediation. So, all right. I'll get the new date for you from the court clerk.
It would be August 14th.
Okay. August 14th, again at 8:30. And since you're both here and you've previously been served, it won't be necessary for you to serve the other party again. All right. August 14th at 8:30.
Thank you, Your Honor.
All right. All right. Any other updates?
Your Honor, I have
That's
a
it.
question. Your Honor,
Who's asking?
Brandy Mackey.
Brandy Mackey. Yes.
Where is the breakout? I still have a message up here. It says host has open breakout rooms. Please wait to be assigned.
Yes, for that case,
Host?
Yeah.
Again, I just have the one laptop.
Yeah.
Cycling through, I just don't have the.
Okay. Yeah. Just stand by, Miss Mackey. They'll get to you.
Okay. All right. Thank you. I was just curious. Thank you.
Just curious why nobody's done anything.
All right, and then I understand that
should have been able-
Elizabeth
yes.
Iselin and Trinity
The easy solution
Townsend
right there.
and Connor Klein are ready.
Correct, Your Honor.
Okay, and you are Elizabeth.
That's correct,
All
sir.
right, would you mind having a seat up here at the table then?
Do you have a preference, sir? Which table?
That one's fine, right in front of that
You
microphone.
can just sit at the
there.
winner's table or the loser's table. It's
Okay,
your
and
choice.
then Trinity Townsend, I see you're still logged in there.
Yes, I'm still here.
And then Connor Klein, I see he's logged in separately.
Correct.
Okay, this will be case 39441. Just bear with me as I open up the court file. So Miss Iceland, make sure I'm saying that right.
You're pretty close, sir. Iceland.
Iceland.
You're pretty close.
Okay.
Please have a tree involved. There must.
Okay. This is your claim for, it looks like $10,000, and it's based on rent, damages, and utilities.
No trees.
Okay. Then before we get started, I'll swear you both in, or all three of you in. Raise your right hands, please. Okay. And do each of you swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes, Your Honor.
Yes.
All right, thank you. All right, and same procedure as the last case. So
Connor's
Ms.
just going out for a
Iceland,
quick run during the trial.
You're the plaintiff in this case.
Little jog.
You get to go first.
This case was continued from March 13th. All the documents were filed per court protocol and our evidence in your file. We just met with a mediator, and while I definitely want the judgment to be filed, I do believe that Trinity would like to make an effort, but she doesn't want to have the full responsibility. Knowing what the law is, that they're wholly and severally liable because they were both my tenants. I want the judgment to go through. I don't want to make some kind of a deal, especially with Connor, because he works under the table. Couldn't even clean up his dog poop. That was, I mean, my unit is destroyed. So I don't trust anything that he says.
Okay, if there's no, it's okay. If you're not, if you were not able to mediate a result, that's okay. And I don't have to hear about your mediation. That's
Works under the table because he doesn't clean up dog poop.
Come into the trial of the case.
May I ask a question, Your Honor?
Why not?
Is it possible, something that was discussed, but is it possible that if you were to agree that this judgment were to be entered into the court record, that separately I could work something out with Trinity if she paid a certain amount of it? I'm trying to make it so that she isn't 100% responsible, knowing that Connor will probably pay nothing. Is there a way to enter this into the record, the judgment? And then at some point, if I come to an agreement with Trinity, I know that I could like vacate the order, or because I know there's not really a way to separate it out since they're wholly and severally liable.
Well, you have the option of you could proceed separately against Trinity if that's how you want to do it. You could try to structure something like that in your settlement, but I won't be able to enter a judgment until I hear the case.
I understand, Your Honor.
Yeah.
Okay. So this case was continued from March 13th. Documents were filed, proper service was given to both parties. Because this is small claims and I chose not to go to Superior Court, I'm in the process of dealing with extensive damage in my rental. While the dog belonged to both parties, Connor was the person that was choosing to leave the dog unattended for days at a time.
I see you've got a favorite.
I chose to do the small claims action, even though it didn't cover what the damage is to my rental.
Because it's cheaper without a lawyer.
Both parties have taken responsibility in this proceeding. As far as Connor and Trinity go, I had a large amount of non-paid rent and then extensive damage to my rental unit. I did a modification as per the court rulings to include the approximate $550 water garbage bill, to include a little bit of the damage, but not even all the damage. I'm not seeking full amount of the damage since I'm at the maximum for the 10,000. As of yesterday, there were no documents that were filed by the defendants. So I didn't have anything to respond to as far as that goes. And while I believe the parties are wholly and severally liable, I do feel for Ms. Townsend in this situation, since her former partner does work under the table, so it's a sticky situation in regards to that. But I do request to file and hopefully have the judgment ruled in my favor in regards to this small claims action.
Okay. Have you told us anything about the case?
I take it you're relying on the documents and photographs that you filed in support of your claim mostly here?
Correct. And there were other documents, sir, like the service record to the individuals. You know, because the maximum was 10,000, I did not put in for like the ozone the machine that I bought to try to remove the smells from the unit, and a lot of other things, money that I've paid to people to try to clean up this unit and to try to deal with this property.
Can you tell me how long they were in the unit?
2.5 years. Approximately 3 years.
Excuse me. It looks like a significant part of your claim is based on late or partial rent payments.
Yeah, that was done in the beginning because I did not have a possession of the unit at the time that was filed. I was still trying to I couldn't have access to the unit, so I didn't even understand the full damage. Mm-hmm. So unfortunately, there's probably more than equal amount of damage to my unit. But when this case initially opened, it was a lot of it was rent, and there's been a lot more damage that I didn't even attach because the maximum is 10,000.
Okay, so I'm just looking at your accounting here, and I see, you know, the rent amount, and I see late fee, rent amount, late fee, and then in the credits part for the same dates, it looks like there were some partial payments made, maybe.
Correct.
I'm interpreting that correctly.
Correct.
I see. Okay. Just want to make sure I understand it. Okay. Is there anything else I need to know before I hear from Ms. Townsend and Mr. Klein?
Just that once I gained access after our March 15th court hearing where the case was continued, I was able to have access, which I got access at the end of March, I believe, and then I was able to see how much extensive damage there was. And so I'm just trying to recoup part of my loss. Mm-hmm. And I still haven't finished the unit is not ready at this point. There's still more flooring to be done and a lot of other damage to be fixed, excuse me.
All right, then I'll hear from the defendants then. Can I start with you, Ms. Townsend?
Yeah, that's fine. So we had signed a lease with Elizabeth back in, I think, 2022. Mm-hmm. I believe it was in April. And we had signed a second agreement after that lease was up. And then we had signed our last agreement, and that was supposed to, from my understanding, which I don't have the last agreement because I never received it. My ex, we split up and I moved out due to domestic violence on his part. So I had to leave because I'm a single mom with a kid and I had to get out of there, which is, I guess, I understand, irrelevant to the situation for civil, whatever, but I left for a good reason in November of 2024. The last rental agreement, she gave me copies of the first two. I did not get the copy of the last one, which he had in the rental. So I don't have access to that. But apparently in that agreement, it supposedly stated that after the year was up, that it would move to a month-to-month, which I was unaware of. And then I understand that, like, I obviously signed it, but I do not recall that being a situation. But I had discussed with her on the 17th of November how I said, I'm sorry that I hadn't responded or gotten a hold of her in a bit, but I had to leave due to this issue that we were having. And I had to do what was best for me and my kid. And we moved into the Deschutes Cove Apartments in Tumwater to get out of this domestic situation for our safety.
And that
And
happened in November of 2024?
yes, and I have agreements, lease agreements, which I did not file. My manager here at the place is hard to get a hold of, and she's said she was going to send them to me, but I haven't received the copies of my agreement here. But I have been living at Deschutes Cove since November of 2024. On my end, I don't feel that I should be responsible for this based on the fact that I have not lived there since November of 2024. But I do understand that, like, the issue, like, I had messaged her and said, like, you can take my deposit. The deposit was mine. I paid for it. I paid for everything to get us into this place. I paid the majority of the rent for a long time. And then when things got bad, like, we split up, and that's when she kept notifying me, like, hey, you're still on this lease. It's month to month. And I said, well, I don't want to be on this lease with him. I already live somewhere else, but if in the future, like, you get rid of him, I did mention to her, like, hey, I'd be willing to move in and sign a new lease with you because I, of course, didn't want to live in an apartment with my son. And so we had these discussions back and forth. She knew the whole time I didn't live there, and but just wouldn't remove me from the lease because she said that Connor had not signed a new lease. He had just continued a month-to-month lease, which I didn't realize at the time, not having rented. This is like my first rental that I'd ever done before. I didn't understand that once that year was up, that a month-to-month meant that we were both still on the lease. And so I didn't understand that I was still responsible after that year ended. I thought him month to month was just him on the lease. And he told me that he was fully responsible for everything. And at the end of the day, when she contacted me and said that he's not paying rent and that I was to owe all this, I just was like shocked. And I understand the circumstance, like, on her end as a landlord. Like, I'm a very respectable person, and I understand, like, that's her income and everything, and I don't want her to go without having her income. As a single mom, like, I had to get out, but I just I don't want all this to fall on me because of a situation that I didn't understand fully. And we had a really bad situation where me and my son had to leave, and we've been gone from there since November of 2024, and I don't understand. I mean, I understand the logistics of it and everything, but I don't want to be held fully responsible because I'm already struggling as it is. And I haven't been living there the whole time. That whole time from November of 2024, I've been living here in the apartment that I'm staying in right now. And he kept the dog. The dog destroyed the place. I told him I would take the dog when I moved out. Like, I would have never left my dog. It was our dog that we got together. I would have never left that dog in a situation where he neglected and abused and held a dog in a room like that, where he destroyed property for somebody. Like, that is horrible and disgusting, and I don't agree with it, and I feel for her on that end. But I wasn't living there, and the whole situation, it's like, I'm not trying to do a sympathy, whatever, but it's really, I don't know what we can do. Like, I told her I was willing to come to an agreement on the end of, like, I feel for her as a landlord, and I don't want the full amount to be owed on me because, like we had discussed in mediation, he doesn't have a job on the books. He's always been under the table. He's irresponsible, and
Ms.
I'm
Townsend,
responsible, but I don't want to be held accountable as a single mom for everything that he did.
I understand that, but I'm kind of jumping in on you here, Ms. Townsend, because
it's okay.
yes, I do understand that, but keep in mind that even if Ms. Island gets a judgment, she gets to choose how she proceeds to collect it, and if the two of you are able to come to some kind of a resolution post judgment, then she could pursue remedies against Mr. Klein separately. to enforce the judgment. So it's not like, if a judgment's entered here today, you have no ability to discuss how it goes from there with Miss Iceland. The two of you are still able to do that.
Okay.
It actually happens quite frequently, but I understand the reluctance to be the person who's on the hook for an entire judgment when there's another party involved. That makes complete sense to me.
Especially since I wasn't living there.
It just doesn't really figure into how I decide the case in terms of who's liable. Okay.
I understand.
I don't know if that makes sense to you, but I know I can tell that part of it's pretty upsetting to you.
Yeah, no, I understand it. And then it is upsetting because I just feel like at the end of the day, like I shouldn't have been held responsible for this because he was irresponsible and negligent in the taking care of a property that he should have, the whole situation just, I can't fathom somebody just disrespecting somebody's property like that and then not paying their rent. And then for me to be held responsible, it just sucks.
Yeah, well, I tell you what, I'll hear from Mr. Klein and see what he would like to contribute to the defense here, and then I'll make a decision for you. All right.
Okay.
So, Mr. Klein, are you still with us?
Yes, sir.
Okay. So, Mr. Klein, you go ahead and tell me your side of it.
I don't really have an argument, to be honest with you. Once the judgment's, if that's what ends up happening, then I'm just gonna start paying towards Elizabeth and get it handled. I don't really have an argument.
Okay, so you don't want to contest any of Miss Iceland's evidence here?
No, I was late on rent, and I wasn't paying rent. And then the bedroom got messed up with flooring.
All right, I understand. All right, then I'm. I see the
guilty, bro.
Damages here that have been documented by Miss Iceland, and they are extensive. I mean, there's no question that she, the total amount of the damages that she's able to establish far exceed the jurisdiction of small claims court. But she's made a decision that this is where she wants to pursue her case, and that's certainly her right to do.
Yes, sir.
The full jurisdictional amount would be justified here. It appears just in the unpaid rent portion of this before you ever even consider the damages portion of this. And Ms. Iceland's entitled to that. So, she's adequately proved that rent was not paid fully over the entire course of the time the property was occupied. She's also very fully and extensively documented just what I would consider to be shocking amounts of damage to the property.
Trinity's
I
upset,
don't have
but I don't
any
think she
idea
should
how
be.
much that would be in a dollar amount, but it would certainly also exceed the jurisdictional amount of the court.
Okay.
So based on the evidence that's been presented to the court today,
You are, in fact, a slob.
I'm going to enter judgment in favor of Miss Iceland. And that's going to be for the principal amount of $10,000. That's the jurisdictional amount. I'm going to also award the filing fee, which is, $50. I did that wrong. And then, Ms. Iceland, you're also entitled to recover your service fee. So whatever you had to pay to get this served.
There was the initial 2 services, which was $50 each, and then because of the modified claim, that was additional. So it would be another, $100, and that would include the certified registered mail.
Well, I think it's reasonable to award $100 for service then.
Okay.
So that would be a total amount, principal plus allowable costs of $10,150.
The judge explained to Trinity, I don't think she understands, the landlord can pursue collections only from Connor if she chooses.
All right, Ms. Townsend, I know this is a lot of money, but from what I heard here in the beginning, it sounds like Ms. Iceland has some sympathy for you, and she's probably going to be willing to work with you on this judgment. I certainly hope that you're able to do that. And I know this has got a dimension to it that's really tragic as well, but this is the judgment of the court. I'm filing it with the clerk, and you'll both be able to get copies of it anytime.
Thank you, Your Honor.
Thank you.
Sure.
You keep mentioning something about properly filed paperwork for evidence.
Mhm.
I was unaware of that. To reschedule or
I don't know. We'll deal with that when we get to your case. You can file it with the clerk's office.
What sucks is that Trinity
Well, you can do it now. You
was gone
could
for
have
all
done
of
it
this.
anytime after you filed your case, but yeah, the clerk's office is the place where you file your documents. Mhm. Thank you, ma'am. All right, any updates for me, Chase?
No, so 2 cases, one of them is mediated, the other also mediation is the laptop.
Am I good to go?
Mr. Klein, yes, sir, you are.
All right, have a good day.
Okay. It looks like some people are coming back.
Man, what a great
Okay.
way to read somebody's character.
So, Your Honor, these folks, number 39506, they'd like to have a trial.
Okay, and that's Welsh and Nachman and Urban Olympia.
Are there any more cases waiting to be negotiated?
There is one more case.
Apparently there's one more, and Chase is working on it.
Okay, thank you.
Okay, so Sarah Welsh, all right, and Christopher Nachman.
Yeah, it's just me today.
Oh, okay, I'll make a note of that. And then who's here for Urban Olympia?
Terry Haglund, designated broker, Donald Carlson, broker.
Okay, would you folks mind taking one of the tables here?
You may have a better chair.
All right, Ms. Welsh, it looks like this is your claim versus Urban Olympia for $780 for withholding of a residential security deposit. Is that right?
Yes, that's correct.
All right, just like the other cases then, we will start by swearing the parties in. So can I ask each of you to raise your right hand, please? And do you each swear that the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes.
All right. And Ms. Welsh is the plaintiff. You get to go first. So go right ahead.
Thank you. Good morning, Your Honor. Yeah, my name is Sarah Welsh, and I'm here regarding the wrongful withholding of our residential security deposit by Urban Olympia LLC. And this case primarily centers on 2 disputed deductions totaling $780. The first of which is an agreement that we just discussed in mediation, that management had incorrectly or had agreed to reduce the wall repair and painting charge by $100, but had never returned that $100 to us. The second of which is that they charged us $680 for alleged general cleaning for unit turnover, plus additional sweeping, vacuuming, and mopping of floors due to excessive pet hair. The photos that I included, the state of the condition of the apartment, which I spent 20 hours cleaning, bought a lot of new equipment, including a mop and a new mop and broom. I cleaned the entire apartment and felt that it was in turnover condition and was still charged 17 hours of cleaning by Urban Olympia, which we could not reduce in mediation, though I did want to discuss that option. I submitted ahead of time kind of our documentation of the cleaning process, and so I just am hoping to get some relief at $680.
So, Ms. Welsh, I want to ask you a specific question about that, because sometimes, I don't know if it's true in your case, but sometimes it is true. A lease agreement will have a specific provision in it regarding cleaning. Does yours have one of those?
It does, but the notification I got ahead of moving out was, I mean, we could do our own cleaning, and it provided a checklist of what we needed to do, and I followed that checklist and went well above and beyond.
Okay, so can you point me to the provision in your lease that addresses cleaning?
I do not have the lease included. I would think that the defendant would be more familiar with that clause, but it does not require professional cleaning.
Okay. And the pictures that you submitted here to the court are pictures of after you, or at the time you moved out of the apartment?
Yes.
Okay.
And it's every single room is in those photos.
Yeah, I see. All right. And your claim is that that Urban Olympia charged you, is it $680 for cleaning, and you don't think they should have?
Yes.
Okay.
All right.
That is pretty straightforward.
Urban Olympia.
All right. Let me hear from Urban Olympia.
Good morning. I have, per the notice here, I have a lot of paperwork to give you that you haven't received yet. Could I approach events and give it to you?
No.
Or do you not want to see it?
Well, why don't, maybe, probably, but why don't you start like this? Just, tell me the reason that you decided that it was appropriate to withhold that $780 from the deposit.
Okay. So they lived in the unit just shy of 2 years. Mm-hmm. Our lease is in compliance with the city of Olympia, stating it's fully refundable if it's returned to move-in condition. They, again, lived there less than 2 years. I do have record and statement of a full paint job prior to them moving in, less than 40 days prior to their move-in. So it was completely turned over. This building was built in 2022 and a half, 23. So it's less than 3.5 years old right now.
Okay. So there was fresh paint before they moved in.
Yes, and fully cleaned.
Okay.
And so then we had our painters and cleaning company that came in, and they are definitely under market in their price point, and I can get you that information. But it is a large 3-story, 3-bedroom, 3.5 baths, and it took 2 people 8 hours apiece. So we have that cleaning expense for $680. We had partial painting for $328.90, and Ms. Welsh continued to tell us that we weren't in compliance with the law. To appease her, on February 1st, we did give her a credit statement for $100, and I see today that we failed to actually apply that credit to her balance. So I did do that, and I do have record to show you of that as well. So that would take this down by $100 from my move out form.
Mm-hmm.
I believe at the time our cleaners were at $35 an hour. They have increased a month ago to $45 an hour, but our cleaning company is under market.
Okay. All right. I do have a question about that. I mean, if you pay a cleaning company to come in and clean a place, they're going to do it, right? They're going to take your money. What evidence is there of the condition of the place prior to the cleaners coming in and doing it?
Thank you. Yeah. So prior to the cleaners, we have all of that online, and this is all from the day the cleaners went in to assess if they needed to clean, and inclusive with their estimate to us at
And those
first.
aren't already in the court file, right?
No, that's what I'm
pictures you're
saying.
holding now, you can bring those right up.
Okay.
And I'll take a look at those.
I've also, would you like to see the lease, but only the pages that are pertinent to right now?
Give me a second. This is a lot of pictures.
It is.
I won't be able to.
It's 114 or something like that, I do believe, but we definitely cover ourselves in for such a case as this.
Okay, and then there's a provision of the lease that specifically addresses cleaning.
Yes.
Right? Can I see that?
Absolutely.
I think I get the message here.
First page of the lease talks about monies, second page talks about the deposit, and this page is their requirement to give us a walkthrough showing the condition it move in. Let's see if anything bleeds over. The move out notice is here too, that speaks on it, just in case that's or something else. Your Honor, we do also have the mold addendum that's required by law that also talks about how to clean. I don't think you need to see that, but that does include cleaning requirements.
Documents are coming in, so no Judge Boyd yet. It might be in about an hour. That's when she started previously on other days. So I'm looking at some upcoming cases to see what we can follow here in the near future.
We also have electronically the notice that we give people when they give us a notice, reminding them of the condition at move out and the required condition at move in.
May I add something when it's a good time?
I've heard your side of the case, so I'm going to hear the rest of their side of the case and make a decision for you, okay?
I give up on what? We're still here. Went missing. Oh, I'm looking for, I'm always looking for new cases.
All right.
Sarah Grace
Is there
Patrick in August.
anything else from
maybe?
Urban Olympia?
I am
Austin
wondering
Drummond.
if you would like to see that I confirmed the $100
Tennessee.
Refund that we negotiated prior to
Falls on the
her
phone. Falls on the phone. One
lawsuit.
second. Hold, please.
From
Thal, I'm live on the air. Are you cool with that?
Oh, I gotta behave.
A long time no hear, no see. How you doing, my friend?
No, I'm pretty good. I'm working with AI to reproduce 40K videos and lore and stories and all that good stuff.
Awesome. So you've got your hands
full. I'm back in my cave doing creative stuff. But no, I heard about the Murdaugh trial. Did you hear about that?
Yeah. We're thinking they're trying to get this in before the end of the year for the retrial. It's going to have much less financial information involved, so it's going to be a lot more interesting, and it also makes the outcome a little less certain. I'm definitely going to be covering that one.
Yeah, it's crazy though, because I was sitting there like, she did what? The county clerk did what?
We actually watched the hearing where they had the jurors. They were weighing the options then before it went to the Supreme Court. And it was wild. It was crazy.
Yeah, because after I heard what she did, I was just sitting there going, "Oh my God, man!" First we had the one dude on the trial with the girl where the lead investigator screwed everything up, and now we got this.
Yeah,
I can't remember her name, Karen. So I don't know, Karen something or whatever her name was.
It's not Richens, I can tell you that. It's Reed, Karen Reed.
yeah, there we go. Yeah, Karen Reed trial. Yeah. The whole thing, we had that and now we have this, and I'm like, what is going on? And just for a Monday, and just to save the crowd, I love you all. I see you all typing. I love you all. But I gotta let Scott talk at some point in the conversation. It is his show.
I just wanted to, we probably should talk off there sometime, but I just wanted to bring you on as like proof of life, because people ask about you and I'm like, well, I don't know. We might have missed the obituary somewhere.
No. So, I'm still alive, but I did have something else I wanted to tell you about real quick while I look at my fridge.
Yeah.
Grillo's pickle spears.
Yes.
Really good. Like amazingingly good. Now they're not buttered pickles. They're not buttered. I'm sorry.
Right.
Okay. I know that's your preference.
Spicy maple
they're
bourbon,
not bad.
particularly spicy maple bourbon pickles is
here we go with the pickle bourbon again. Will you stop with the spicy?
Grillo's is doing a lot of brand integrations. You can like in my hometown, there's a Smoothie King place where you can get a pickle smoothie, and it's Grillo's pickle spear smoothie.
Really?
So
there you go.
I have not tried them yet, but I have seen them at the store, so I might have to give them a try. Are they crisp spears, or are they like rubbery? Because I don't do the rubber.
Oh, here's the thing. This is where Grillo's falls down a flight of stairs.
Mm-hmm.
The flavor's really good, okay, but texture as far as the crisp goes, like that snap, you got to sit them in the fridge for a long time. Otherwise, you don't get the pop.
You have to freeze
them.
You
don't have to freeze them, but they won't break. They got kind of a soft interior, and sometimes the rind outside the peel is a little bit tough.
Yeah.
So texture-wise, I would put them at about a 6 on the texture. Flavor is like an 8 or a 9, but the texture they need to work on.
Yeah.
So
let's see. I'm sorry, I'm trying to fix my camera focus while we're talking here.
See, you've got all this cool stuff on your studio, right? Because you make like a gazillion dollars a month, right? I'm over here making pennies, screaming at AI all the time using 2 screens.
my new addition is all this over here. All this box over here, that's a mobile streaming rig, 4K mobile streaming rig. I can do 20 cameras at the same time and stream.
Okay. How did what you said make what I said better?
So it's not that I can do 20 of your channels at the same time. I can basically, that box could produce an NBA basketball game. Not very well, because it doesn't have the audio.
Oh my God!
But for the camera side, it can do it. Anyway, so we're gonna be using that more in the future. But
also, what I was thinking of too is that if I ever get seriously bored with my life. I was thinking of because I'm retired. So what I was thinking of is that if we ever find a federal trial, I'm thinking what did he? The guy who used to work for CNN, black fella, what's his name?
Lemon.
Yeah, Lemon. The Lemon trial, because it's a federal trial, as far as I know. It won't be televised. It's federal court. But if I can get in there, I was thinking of going down there and just periodically giving you updates on what the Lemon trial's going through, because that's an interesting one.
There are a few good ones. I'm not sure if you could steer clear of politics on all of them. But
yeah, see, and that's the problem, is that that's see, and that's what I was going to ask you about, because the Lemon one, while fascinating, it's legally fascinating. I think we're too close. I think it's too close to the sun on the political thing. I think there's no way to avoid the politics of it. You know what I mean? So I don't think it's appropriate.
It's on the spectrum, as we like to say.
Yeah,
so,
yeah.
But
it's gonna be yeah. And I don't want to bring that nonsense around you, so I'm kind of like, no.
No, but there are some great cases out there. We keep hoping and praying and offering YouTube sacrifices to the powers that be, hoping that we can get in federal courts at some point. But
I don't. Well, here's the thing: can anybody get into federal court? I don't think anybody
basically
can.
No,
Can they?
Unless the federal court decides on their own. It's like, hey, I've got an idea. We're going to let cameras in on this one. That, and basically it's when they're just doing their own little celebration of us. That's basically all we get to see.
Okay, hold on. I got an idea, everybody.
Oh, man.
What if we bribe the federal judge? Okay. Or no, not bribe, gifted.
Yeah.
Them with
Wait. Before you finish this felony offer of yours. Hypothetically, if somebody, not us or anyone we knew, now go on. What were you saying?
Well, okay, I was going to say we give the judge Pickles to allow RA cameras inside.
I'd be willing to go more than that, but Pickles is a good start, just to grease the wheels. No,
I'm
obviously
just saying, you never know. They might be a pickle enthusiast like the rest of us. Okay, you never know. Okay, and sir, I take umbrage with every thought I have being quote unquote a potential felony. It's not that you're wrong, okay? It's just that I'm taking.
It wasn't even a good idea, Thal. It wasn't a good idea.
Yeah, this is true. This is true.
The legislature has the power on that one. We're hoping that they do something to make it better. But until then, there are some great cases coming up. We were just talking about Austin Drummond that's coming up. That's a quadruple murder / child kidnapping case where he killed 4 people in the family, stole the young baby, and drove her 40 miles and then just left the car seat on the side of the road. So the baby was found fine, unharmed, but they didn't find the murders until they were doing the searches for they were trying to find where's mom for the baby, and that's how they found the murders. And he wants to be pro se. Yeah, so there's that one, which I don't think Tennessee will allow. They have a law sort of saying when it's a death penalty case, which his is, you need death penalty certified lawyers, and he's saying, I have the right to defend myself. It could be a complete show, if you know what I mean. There's that one. There's a Sarah Grace Patrick. We've got one down in Florida coming up with co-defendants. The state's witness is no longer a state's witness. We've got just a couple of really big cases. So until the federal courts get their act together and let cameras in, we'll stay busy. As opposed to today, where we're waiting for court to start still. It's 1:52. Court was supposed to start at 9 o'clock Texas time, and nothing.
Gotcha. And just so everybody knows, the new channel I'm launching is going to be called Cullivar. So it's Kull. It's my old last name that I used to use all the time.
Awesome. So you're when you said you were redoing the 40K, the Warhammer stuff.
And it's going to be a Warhammer 40K / sci-fi original stories I write channel. So
you're remaking them, or you're not you're not taking the old video and trying to make it 4K, or are you recreating the old video? Which one were you doing?
Yeah, I'm recreating the old videos because they used art styles that basically the only thing you could do was use art styles that you could find already done pictures on the internet, and then you really couldn't do very much with them.
Yeah.
But since AI came out and did a bunch of stuff for making pictures and letting you do shorthand little short short films, I'm trying to monopolize on that. Now, the short films are taking a long time to learn how to get around, because it's not so much. So basically what I'm doing is, and you'll understand this, because or anybody out there that works with animation will understand exactly what I'm doing. I'm taking the short, a picture, and then I'm saying, cool, get the second picture. And the second picture is just one, like 3, 4, 5 frames away from the first picture. And then I'm saying, cool.
Stop action photography.
Right. And I'm telling AI to fill in the gap for motion. And so I'm treating it like an animation.
That AI is really good at that now. There are some great tools to, I've got a dropped frame, fix it. And it's like, oh, here's the frame you're missing. It's really good at that.
Yep.
That's awesome.
Well, and that's the thing, is that if I try to tell it what to do, as far as, cause I told it I need a silver orb coming past Mars with a excuse me, with a small satellite, in orbit of Mars. And I need the orb coming past, Mars and the satellite, and the orb's supposed to be made out of liquid metal. I got like 15,000 different interpretations of those words. And I was like, okay. So I went to ChatGPT and I said, make me a drawing of this. And I kind of did a hand drawing and said, this is where I want placement to be. And then I said, and then I need a picture of this. And I did another picture of the same thing, pretty much, just a little time lapsed. So the second picture was just a little bit later. And then I fed that into the AI that does the videos, and then it could do it. But before then, I was like, oh, God, this is a mess. So, yeah, the production line is going to be long.
Yeah. Quality takes work, though. It sounds great. I can't wait to see what happens. So, it's great to catch you, and find that you're alive and well.
Yeah.
So.
And tell the wifey I say hi. I'll get murdered if I don't say that to her, because she's responsible for your existence and us still getting to talk to you. So,
on the topic that you brought up earlier, I would blame the chicken instead. So it was the
well, there you go.
All right, Thal, good talking to you, my friend.
You too, sir. You too. Love you all out there.
All right, bye-bye.
Right, bye.
All right, that was fun. That was really fun. Hadn't heard from Thal in quite a while, so good to know he's doing well. Meanwhile, Thurston County, they're done. They stopped their cases. They finished them. Let's see. We have a couple others we can look at. I'm sort of trying to stall and see if the Judge Boyd comes around. See this one.
To bring a trademark claim, if in fact it's Harold's Enterprises trademark claim, which I think kind of structurally it is. So you're going to talk about that.
Sure, I will.
And then
trademark
even more so, the irreparable harm.
Yes, sir.
Because if I agreed with everything you put forth in your motion and in the 5th amended complaint, it sure seems like in the end, Ms. Robinson and Mr. Pym could stroke a check, and Ms. Rutherford would get her share of whatever had happened. But you're shaking your head, and so that's why we're here. So you can educate me as to why the sky falls if Harold's Chicken and Ice Bar continues to operate under that name, not Harold's Ice Bar, at 349 Edgewood.
Well, I'll start off by saying that, and I think you read it right, Your Honor. I do believe that the defendant accelerated the opening process before the hearing because of bad faith, right? There's all the conversations that I had with Robert Kenner. He never once told me that his clients were preparing to open, would have appreciated a heads up about them trying to open the restaurant, especially days before the preliminary injunction hearing. And it shows that this was intentional infringement, Your Honor. And even the defendants admitted in their response motion that make sure I say this right, that the status quo has been altered, right? They're saying, well, we have this TRO that we have this TRO that's pending, that we're open, that we have balloons, we have ribbons, that the status quo has altered. But Your Honor, they're wrong. And here's the reason why they're wrong, is because Georgia law says so. In the case of
Your Honor,
Inkaholics Luxury Tattoos, Georgia, LLC versus Pardon, which is 324 Georgia App 769, 2013, the parties were fighting over a trade name. While in litigation, the defendants argued that the use of the alleged infringed name altered the status quo. The Court of Appeals rejected this argument. The court held that in a trademark infringement case, the status quo to be preserved by an interlocutory injunction is not the situation of contested rights, but that the last peaceable non-contested status of the parties. So what does this mean? The court does not treat the defendant's ongoing use of the allegedly infringing trademark during the lawsuit as a normal situation that deserves protection. Instead, the court looks back to what was the situation before the junior user began using the mark.
So two questions about the applicability of that case. One, what does junior user mean? And how would that apply here? Because I think we've got 50-50. So there's not a junior, there's a equal, which I think would make your client's claim stronger because there's not a, wasn't a lesser partner. But two, you're going to need to weave into all of your responses in the trademark area. Didn't she abandon it?
Okay.
And your response to that, because I heard the testimony, I've read the affidavits, and I think that I'm not sure how you demonstrate a strong likelihood of success on the merits that there was a point at which Ms. Rutherford said, forget it, we've driven this into a ditch, it's not working, I'm not interested in going further, I'm out of here.
Yes, sir. Well, that's not what happened. All right, so the first question was, I'm sorry, what was the first question?
So the case you were citing, yes, Inkaholics, talked about the status quo isn't the junior person using it, and Ms. Robinson is not a junior user. She would be a co-equal. So it wouldn't be the case that Ms. Rutherford was a 70% owner of the trademark, and Ms. Robinson was 30. They were, at the time, if there was no abandonment, 50-50.
Your Honor.
Or they were neither because, of course, it's Harold's Enterprise.
Your Honor, well, it's not just Bobby Robinson. It's Cameron Pym. Cameron Pym wasn't a party to the agreement with Harold's Chicken Shack, right? He didn't have an agreement with Christian Pierce. Taryn Rutherford, Bobby Robinson did. He didn't. That's the problem. They created a new company to use this trademark that she owns 50% of.
Why do you use the past tense?
She owns it.
Okay.
Yeah, she hasn't relinquished it. She hasn't abandoned it. What happened is, yes, she got frustrated and she said, hey man, like this is just too much for me. But then she told them, well, no, it's not. She rescinded whatever offer she made. She rescinded it, and she has every right to do so because she saw that there was conspiracy, there was fraud, and she rescinded that offer. So she never abandoned it. And also, Your Honor, the interesting thing about this, and something that I read in defendant's motion, was that they're saying that this right belonged to Harold's Enterprise, right? But a fact that Mr. Kenner failed to mention is that Bobby Robinson terminated the company. She dissolved the company. So what happens when a company is dissolved? The assets are distributed to the shareholders equally. So what does that mean? That means that Bobby Robinson owns a half of the trademark. Taryn Rutherford owns a half of the trademark. So Bobby Robinson cannot open a restaurant under the name Harold's Chicken and Ice Bar at the 349 Edgewood Avenue without the consent of Taryn Rutherford. And Taryn Rutherford cannot open Harold's Chicken and Ice Bar at 349 Edgewood Avenue without the consent of Bobby Robinson. That was the agreement. And so the argument that Mr. Kenner is making is a fatal argument. She owns that trademark. She has every right to that trademark.
Well, she co-owns it.
You're right, Your Honor. She co-owns.
So she has some rights to it, but
Yes,
she
sir.
doesn't have exclusive rights, which is what your argument is about Ms. Robinson, that Ms. Robinson shouldn't be able to do something, I guess, without Ms. Rutherford's sign off.
She can't do the same thing, Your Honor. It's like they can't have it both ways here. Like, she can't do it, Ms. Robinson can't do it. And Your Honor, as we told Mr. Kenner, they can open a restaurant. It just can't be named Harold's Chicken and Ice Bar because she have interest in that trademark. Now you ask me, well, Mr. Edge, I'm having trouble understanding the irreparable harm piece.
Right. Before you shift gears on that,
he's prepared this speech. The judge keeps.
How are you? Good. How are you? I'm well. I need your driver's license because that's how I see. Yep. Look at that. You live in Atlanta. So if you give it to Sarge, she'll get it to me. Then I can sign this. All right. So, Mr. Edge, you were about to get to the irreparable harm part.
He's busy getting the driver's license. Apparently, we don't have a bailiff here.
Oh, so I forgot. Well, client pointed something out, Your Honor.
Thank you. You guys confer for a second. I can check this out.
This is one way to get somebody's number. I need to see your driver's license. It's for legal reasons. No. Judge McBurney. His mic is overmodulated. He has fixed it a little bit. It's better than it used to be, but he's still a firm believer of just yelling into the mic, talking as close as you can to it, and that's unfortunately not how any mic works.
What are you going to be studying at Morehouse? Like to get an MD? Congratulations.
Oh, doctor.
It's a long road, but you'll make it. You will make it.
This is a reverend lawyer. I do feel like I'm being preached to. Like at the end, they're going to pass around the plate and tell me to repent. So, let's see. Let's see how this. It's just 105 in Texas. I know it might start at 1:30. See if he's able to pick up, if the lawyer's able to pick up the passion in his argument from the get-go here.
Okay. All right. Irreparable harm.
Before that, Your Honor, there are some facts that I want to weave in that I think that we didn't cover. And I'm sure you remember this. Remember, they told Ms. Rutherford that they were closing the business, right? So at that point, she threw her hands up and said, listen, let me try to sell, right? But then she discovered that there was conspiracy and there was fraud. And she was like, no, I'm not about to give you this company. I'm not going to do that. And then also, another thing is that we have this affidavit from Ms. Kristen Diane Pierce, who has since passed away, who said that she never authorized, she never agreed to them opening up this restaurant under this name. And I know that's not really our point to make, but I just want to add that color.
But which name? I thought your whole point was
Chicken and Ice Bar at the 349, because she said that.
But what if we go back 4 years and Ms. Rutherford and Ms. Robinson are still talking and they're running a business at 349 Edgewood, was it not called Harold's Chicken and Ice Bar?
Yes, sir. It was called Harold's Chicken and Ice Bar.
Right. It was called this. So but you just told me that the franchisor never, in her affidavit, said, I never let them open a restaurant with this name.
Bobby Robinson and Cameron Pym. She never agreed to them opening up this restaurant at this location because, Your Honor, this is the flagship restaurant. I mean, this is the known restaurant on Edgewood Avenue. And everyone knows that.
Well, it had been till it closed.
Till it closed.
And it was closed. And now it's reopening under the same name.
Under the same name. Same menu,
same food,
same drinks, same hookah, same everything, same sign on the door. Right?
Chicken and hookah.
And so when we talk about irreparable harm, the defendants have accelerated and compounded consumer confusion. Like we just said, same sign on the door, same menu, same service model, this lounge service model, and the same advertising methods. As I mentioned earlier, Your Honor, they're still using the Instagram account that Taryn Rutherford helped build. They're advertising the reopening of Harold's Chicken and Ice Bar to the customers that Taryn Rutherford helped generate. These are people that know Taryn Rutherford. These are people that know Bobby Robinson. These are people that read the Rolling Out magazine, where Bobby Robinson is saying that Taryn Rutherford and I created this name, that we were college friends, and we created this service model. This is something new. We are on Edgewood. This is the place where you should be, right?
I'm guessing it's
and so the
chicken.
defendants have caused immediate injury to Ms. Rutherford's reputation, her goodwill, the brand control that cannot be easily quantified. What if there's bad food quality? What if there's bad service? What if the restaurant isn't clean? What if the pricing is too high? What if the customer experience is not good? That's associated with Miss Rutherford's brand. I tell you this, Judge, this weekend I'll be celebrating my 10-year college reunion. I graduated from Morehouse in 2016. This is my 10-year anniversary. And when I was a student at Morehouse, if you were to ask where I would be on a Friday night, around 7 o'clock, I would be at Harold's Chicken and Ice Bar on Edgewood. And I would be there with my friends, right? So let's say...
You're going to go this weekend?
I won't, because I have 2 hearings next week. I will not, unfortunately. But what I will say is, think about this weekend, Your Honor. It's been 10 years since I've been to Harold's Chicken and Ice Bar. And I walk in, same sign on the door, same menu, same waitresses, same bartenders, same tables, same fryers. We talked about fryers last time. But everything is the same. But when I get there, the food doesn't taste the same. The drinks doesn't taste the same. Nothing is the same. And I say to myself, what in the world has happened here? This is not the same place that I went to, that I used to go to 10 years.
We've got to go. I'm sorry. We're back with Judge Boyd. We waited all morning for this. The trial started. It was supposed to start at 9. It's now 1:30 Texas time, or 1:10. I want to know what happens with the chicken. We got a cat raid. Thank you very much. Appreciate it. Welcome, cats. We have a...
So, Your Honor, yesterday after Detective Pabelik testified, it became apparent
that we needed new witnesses.
That he had not, in conducting his investigation, reviewed any of the video from the patrol officers or the bike officers that were investigating this Tesla accident on the night of, or the early morning of March 25th, 2023.
This is defense arguing for why they should be able to subpoena new witnesses today.
We received from the state a video, which I'm going to mark. Is this one there? Purple? This is the black one. We'll mark as Defense Exhibit 7. That is the body-worn camera from patrol officer, wherein he interviews 2 witnesses to the accident, both of which say they heard gunshots and then a crash. This is key evidence that goes to the circumstances under which Mr. Castillo was operating his vehicle at the time. which is one of the elements of the manslaughter charge that he has against him.
All right, so here's the court's question. This, your exhibit that you're offering, when did you receive that information?
I received the body-worn camera in question. Judge, I'd have to go back and look, but I want to say it was during the initial discovery that we received in this case.
And so approximately when would that have been?
I want to say it's probably somewhere around October of 24.
Okay.
Thereabouts.
All right.
So we've got this video. On the video, the officer, it does not appear, gets the information from the two witnesses that are telling him they heard gunshots and saw the crash. We don't receive any information regarding these witnesses in discovery from the state at all.
All right, state.
I got more. I'm sorry, Judge. So subsequent to this, in July of 25, we receive an upload in discovery, and this is something we obtained fairly recently, but it's uploaded, it looks like it's somewhere around July of 25, a homemade video that's made by these two witnesses that were on the officer's body cam. It gets produced to the DA's office, and they upload it into discovery where we're able to obtain the video. But again, the state does not update its witness list with the names or addresses of who these witnesses are. I mean, the last witness list we got from the state was when they first filed it, and that was May 14th of 2025.
State, do you have the names of those witnesses?
Judge, I don't. So the body-worn camera where the officers failed to get the names of the witnesses was uploaded to Discovery on April 8th of 2023, and then the video defense exhibit that he's referencing was uploaded in July 22. On July 22nd of 2025, I don't have the name of those witnesses. I've never spoken with them. I don't know who they are.
And Judge, I think that that's a problem because the state has a duty to seek out exculpatory evidence.
Mm-hmm.
And they have a duty to reveal that exculpatory evidence to the defense.
Didn't they reveal it to you by giving you the video that had the statements?
I'm sorry, I didn't mean to interrupt you.
No. So you didn't receive the video with the statements from these witnesses?
I did receive the video. However, I did not receive their information, which they are key witnesses that we should have been able to subpoena to come in and prove up this video that they provided to us.
All right, but this is what I'm trying to understand. Number one, state, do you have the name of those witnesses? All right, so defense, you're telling the court that you were aware of the video, you viewed the video sometime in 2025.
Actually, Your Honor, I don't think we reviewed it until probably about maybe 3 months ago.
All right, so it's been reviewed 3 months ago. So the state does have a duty to turn over evidence to you, and they're saying that they turned the video over to you and that you received it, and you're stating that you received it.
That's correct, Judge. However, we did not receive the information about the witnesses. I know they're saying they don't have it, but that begs the question of how did they get the video? They got the video from the person who made the video. Somebody did. That person, that witness who's on that video from the body-worn camera gave that to somebody from the state. And at that point, their information should have been gathered to be disclosed to the defense. This is definitely exculpatory evidence.
Well, but I mean, the question becomes whether or not you were handed over the exculpatory evidence, and you stated that you actually received the DVD, the video, and that you've had that DVD, that video for over 3 months.
Okay, Judge, but I don't have any of the information about the witnesses. And the witnesses' testimony may be a lot more than what's just on that video, and it's definitely exculpatory. Their testimony is exculpatory. I don't have their testimony, and that's the problem.
Well, when you say you don't have their testimony, their statement is in the video. Is that correct?
That is not correct. They have some statements in the video. However, being able to call them and have them testify here before this jury is important. It would definitely provide exculpatory evidence to this jury.
How did you just
All
find
right.
out about it now?
So what are you requesting?
Your Honor, at this time, I've conferred with the state about this.
So what are you requesting?
There's 3 options that I can see, Judge.
No. What specifically are you requesting?
I'm requesting that the video be admitted into evidence before this jury.
All right. So, state, are you objecting to the video being admitted?
Can't really.
I need.
Okay, sure.
This is spicy. This is spicy. All right, what we have here for those that are just joining us as we're waiting, Judge Boyd has been handling this little trial out of Texas. It is a manslaughter trial where the driver of a Tesla drove at 88 miles per hour in a 35 mile per hour zone, failed to negotiate a turn properly, a gentle curve, not a 90-degree turn, left the roadway, crossed the sidewalk, struck a pedestrian on the sidewalk, killed that pedestrian, and then fled the scene along with his passenger. The passenger has already testified, and I did not find the passenger credible. Now, the reason I say that is because we know for a fact that the pedestrian's body was basically stuck under the car on the passenger side, and that the passenger had difficulty opening the door because the body was in the way, and it took him some time and effort to get the door open. The camera in the Teslas, which we were not able to see because this court obscures the TV screen, we're told it shows video of him staring down in that area for 4 seconds before he then leaves the scene, calls his dad 12 times, who he's never, ever in his life called more than 3 times, apparently by his phone records, in a single day, before eventually coming and speaking to police, making a 911 call.
So I don't know how parties are coming to court announcing ready. If they're then saying, basically essentially what he's saying now is that he's not ready.
Judge, we're not saying that we're not ready. What we're saying is the state hasn't complied with 3914 providing the witness information. That's what we're saying. And they had a duty to do that. The court ruled on at least 3 motions. One, a Brady motion, a discovery motion, and then a motion to reveal exculpatory information to the defense. The court granted all 3 of those motions. The state hasn't done it. Somebody gave that video to the state, and the state should have known who those witnesses were and gotten that information to the defense. They didn't do it.
All right, Deputy Laura, if you'll line up the jurors, please.
The judge just, all right, moving forward. It seems like a too little too late motion saying, hey, we didn't turn this over. We're mid-trial, and now you're saying, hey, you didn't tell us who made this video. You've had the video for 3 months. 3 months. You can't just...
And state, who is your next witness? All right, if you'll have them on the stand, please.
All right, we're looking at the witness stand right now. The judge, yet again, appears to be distracted today by something.
And state, while that is happening, if you'll have your advocate or whoever it is, see if they can discover who these parties are on some video.
Ooh.
Yes, Judge. I guess at this point, I don't mind stipulating to the video. However, I just think it needs to be made clear to the jury in the stipulation that the state provided these videos.
All right.
So the state provided the video. If they don't know who it is, they're going to look and see if they can find them. If they can find them, it sounds like the judge has at least paved the way for defense to be able to subpoena or attempt to reach these people. But we're on the last day of the trial here.
Okay, you want her to remain standing?
Oh, she can sit.
She's got a little baggie with her, with the card.
All right, we can bring the jury in. Yes.
All right, to the jury.
Perfect. Looks great. Here's the jury. Here's the judge. And we're ready to go. This is day 4. Day 4 on this trial. It's been a quick one because the judge has been working other dockets. We have put on the thumbnail an image of each purse the judge has brought to court throughout this trial, and now she has brought what I can only see.
All right, everyone, please be seated. State, call your next witness.
The state calls Christine Desalius.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so that the jurors can hear, okay? Thank you. Yes, thank you. All right, state, you may proceed.
Ms. Christine, can you hear me okay?
Yes, I can. Thank you.
Thank you. Can you please state your full name for the jury?
Christine Gonzalez,
And how old are you currently?
67 years old.
What state do you live in currently?
I currently live in Newburgh, North Carolina. I moved in January of 2023 there.
Just half an hour for me.
Prior to that, I lived in Springfield, Missouri for 5 years. And prior to that, I lived in San Antonio, Texas for 30 years.
You know an individual by the name of Eric Michael Moody?
Yes, I do.
And how did you know Eric Michael Moody?
He is my son.
Did you have any other children other than Eric?
He's my only child.
And what is Michael's father, or Eric Michael Moody's father's name?
His name is Michael Moody.
And did you and Mr. Moody decide to raise Eric here in Bear County?
Yes. Michael and I divorced when Eric was 2 years old. And we made a commitment to each other that we were going to co-parent Eric, even though our marriage didn't survive. So Mike was working as an electrical engineer here in San Antonio. And there were times when either he or I could move out of San Antonio, but either one of us wanted to do that because we both wanted to be involved in Eric's life. And so we were very, very committed to co-parenting Eric.
Thank you. Can you please describe to the jury the nature of your relationship with Eric? Did you have a close-knit relationship with him, or how would you describe that?
I had an incredible relationship with him. He was everything to me. He was such an easy child to raise. There was nothing more than I wanted than to be a mother. And when he was born, he changed my life completely. I was just so committed to him.
And did Eric attend school here in San Antonio, Texas?
Yes, he was in the Northeast ISD school district. So he attended elementary school, middle school, and high school in Northeast ISD.
And when it became time for his post-secondary education, did he attend university here in San Antonio, Texas?
He attended Trinity University and graduated with a history degree from there. Went to China and taught English there, and then came back and worked full-time at the Sylvan Learning Center as a tutor, and went part-time to UTSA to get a computer software engineering degree.
Now I want to ask you about the week of March 25th of 2023. Did you receive news regarding your son Eric Michael?
Yes.
And what news is that?
So with this Saturday evening, and it was late at night, and Eric's father called me. I was asleep. And he said, Christine, I have some horrible news to give you. And initially I thought he was going to tell me about his mother because his mother had been in the nursing home. And so I listened, and he said, Christine, Eric was killed in a car crash. And so I said, he was driving? And he said, no, he was walking and he got hit and was left. And then I became physically ill. My partner, Howard, woke up and asked what was wrong and tried to explain to him. And neither one of us, needless to say, slept for the rest of the night. Howard got online and started making airplane reservations for us to fly out the next morning to San Antonio. And we got here and went to the funeral home and waited for Eric to be released from the medical examiner's office.
Now, Miss Christina, I'm going to have to show you a photo. And so I'm going to ask you to, in a moment, I'm going to ask you to look to your right. In a moment, I'm going to ask you to look to your right. Now I'm going to publish to you what has been admitted into evidence. I'll see if you can get me records. Okay.
Oh my goodness. Is this an autopsy photo?
And I have to ask you to look at that photo, okay? Can you please take a look at Stacey's event and look, please? You actually saw it.
Yeah.
Possible.
Right, defense.
Ms. Gonzalez, my name is David McLean, and I represent Robert Castillo in this case. On behalf of my client and myself, we want to extend our deepest sympathies.
Sustained.
Ms. Gonzalez, I have no questions.
Right, thank you. You may step down.
Don't take the mic. She took the mic. You knew she was.
Oh, can you take the microphone?
I don't think the state needed to do this. I don't think the state needed to identify. There was not a question about who the body was. That's something that easily could be stipulated to show a mother the autopsy photo of their slain son on the jury, in front of the jury. That's
all right. State, call your next witness.
Judge, at this time, the state rests.
All right, ladies and gentlemen, I'm going to have you all wait in the jury room for us, and I'll call you right back in, okay? Everyone, please rise.
I bet we're getting a little bit of I bet it's going to be a short day. I'm getting a vibe that the jury might be going home soon. I think. This is the time for a judgment of acquittal. Don't think that's going to happen. The light most favorable to the non-moving party.
All right.
That
Everyone, please be seated.
Evidence has to be looked at.
It's my understanding that state, you're willing to stipulate to the video.
Yes, Judge. As long as it's just made clear to the jury that we did provide the videos to the judge.
Defense.
Judge, I don't have a problem with that. There is still an issue of we do not have the contact information for these witnesses. It's not been provided to us, and so.
Well, my question is this: you said that when I asked what you were requesting, you stated that the first thing is for the state to stipulate to the video. So the state is saying they're willing to stipulate to the video. Are you not requesting that? Or are you requesting something else?
Yeah, we're requesting that, Joe. That's fine.
All right. So is there anything else that you're requesting other than that? I just want the record to be clear that that's what you're requesting.
And we are also requesting, in addition to the state stipulating the video, the witness information, their name, address, and phone numbers.
All right. So do you all have the name, address, and phone numbers?
Judge, I just want the record to be clear. I did not receive the videos from the people that took them. They were sent to a family member of the complainant and then forwarded to us. So I don't know the individuals that took the videos. I've never met with them. I don't have any contact information about them.
And I guess the question is, Judge, is they got it from those people, whoever received it at the DA's office, whoever got that, did they follow up and ask who these people are? Can we get their name, address, and phone number? We might want to talk to them. And it seems to me that just would have been the prudent thing to do. They got it from somewhere. And I guess.
So this is what I'm going to tell everybody. Here's the thing. If you all are stipulating to the video and the video is coming in, and that's what you're asking for, and the state is in agreement with that, then that's what I will give you. If y'all are not doing that, and if in addition to that, y'all want names of witnesses and want that, then I don't know if y'all are still stipulating to the video. All right, so what are we doing here?
For the forced election, Judge, I think we just have to go ahead and accept the stipulations of the video and do the best we got with what we have.
No. My thing is, if y'all want just the them stipulating to the video and the video coming in, then that's what the court will do. If y'all are requesting something else, then the record needs to be clear on what you're requesting.
And I want to make the record real clear, Judge, because we did request two things. One, we requested the admission of the video. Two, we requested the information regarding these witnesses. It's the state saying they don't have it. I don't know why they don't have it. I think it's still a Brady violation. But if the state's willing to stipulate to the video, then we'll go with that and go forward. I don't know how we have a choice at this point.
Oh no, you do have a choice. All right, this is what we're going to do. State, see if you can talk to the detective or whoever it is who has the name of these people. All right, thank you. Yes.
Now we have a break. And the judge might even kill the feed here while they go and look for names. Where do we get the video? This is pretty simple, right? This is pretty simple. A video showed up. Video of people who witnessed either with their eyes or their ears the crash. 2 people. The video was collected. It was turned over. It was never investigated further. The individuals who took the video were never interviewed about this. Brady violation. I think that's a little much. It's not. Yeah, it's not something that was failed to turn over. It was failed to investigate, which can be argued in closing. That the state, they looked at this and said, "This is what it is." Boom. Because this is a different story entirely than what the state is told. If you have 2 people who are being shot at, we have bullet holes in the car, we have witnesses that say, yes, we heard gunshots and then the crash, and the driver gets out and runs, okay? If you're thinking you're about to get shot, running from the scene of an accident seems like the prudent thing to do, especially if for some reason, we don't know, because the passenger sure says he didn't know, that anyone else was affected. The passenger says he didn't see anybody, didn't see any person. Felt a bump and hit the wall. It could change things entirely, especially if there's any sort of intent element that's involved in this. So, failure to investigate and just going with the, hey, you've got who the state said was a drunk driver on a Tesla, 88 and a 35, like joyriding, and strikes a pedestrian, then flees the scene. And yeah, there might be some holes in the back of the car that could be bullet holes. Yeah, but not call 911. That looks bad. That looks bad on the defense, the defendant, the driver specifically. But this very much is something that could be exculpatory for the defendant. And so I think the judge's hands are sort of tied here when the defense says, hey, we should be able to talk to these people. We should be able to do this. I'm pretty sure the judge said this case would be over by today to the jury. And I don't think it will be, especially if the defense now gets to subpoena a couple people who have not been talked to in years about this accident. All right, this is a tragic case for sure. And it's not made better by, choices of people involved. It was bad choices all around. Now that Thal has the background, let's see what he thinks
Call
about
from
it. Thal, welcome. Glad you're still here.
I'm calling you because it'll make them come back, because that's what happens when I call you. But no, the thing with me is that I didn't know I thought we were at the very first of the trial, and somebody said we're in mid-trial, and I'm sitting here like, the defense is pulling this in mid-trial. I'm like, dude, this smells like shenanigans.
Yeah, this is day 4.
I don't know the full story, but that's my reaction.
Yeah. You would feel the same way, especially after yesterday's testimony from the lead detective, who didn't even view the reports of some of the officers that were assigned to this.
What?
Yeah. So it's not good. It's not good.
What is going on in this trial?
Yeah. It's a crazy one, and for some reason I don't know what it is. I'm distracted by the fact the judge is distracted, and I don't know what she's working on or what's going on in the background. But she is multitasking, to say the least, and distracted, to say also the least. Barely even making eye contact. I don't know what's going on.
Probably distracted. She's probably distracted by all the shenanigans, and she's probably low on pickles.
Probably. We should send Pickles.
Usually.
A big old pickle bouquet.
There you go.
We're
because the arguments I was hearing from the defense and the prosecution when they were arguing back and forth, I was like, oh, okay, so it's before the trial. You know what I mean? Because these are usually arguments you hear before then.
Yeah.
Right? And then somebody said, oh, yeah, they're mid-trial. I'm like, the what?
Yeah. This would be like a motion in limine, or, 2 months before trial, we're covering this. But I know.
Yeah, but to be mid-trial and bring it up, I'm like, what is happening right now?
Honestly, that looks like something that the defense just dropped the ball on. How would you get this far when your best bet, okay? Your best bet, that the state is just going to say, hey, drunk driver crashed and everything, and they're not pursuing the whole. There was a shooting or a road rage incident where the defendant was the victim. They're not going to be talking about that. Why would you not have evidence to support that and say, hey, here's this video. I've had it for 3 months of people saying, this is what I heard. We heard the gunshots and then the crash. And why would you not pursue that and only just now be like, oh, judge, throw up our arms. Where's the information? Well, 3 months ago, you had this information about these people, or at least the fact that they existed.
Now, this is my conspiracy-minded brain kicking in. But maybe, could this be, in your opinion, a rigging by the defense to get a mistrial? So they sat on this little lemon, and if they thought they were going to lose the trial, they pull it out and go, oh, judge, look, we have to have a mistrial. Uh-oh.
Without having seen the pre-trial motions on this one, I couldn't say yes on that.
Okay.
I don't think there are many defenses out there that say, hey, I've got an idea. Let's go for a mistrial. Right? It's not like the strategy that they teach in law school. As a matter of fact, I can see during a trial when things are not going your way, say, hey, the best bet might be if we can get their witness to blurt something out, that maybe that, I'm not even sure if that's ethical, but but usually the mistrial option just means we just have to start over again. The fight has to be fought at some time. And
right. But the thing is that if just because we have a mistrial doesn't mean the prosecution, the state will bring it back again. I mean, I don't know why they wouldn't, but in this case especially, but maybe that was part of the I don't know.
Yeah, it's possible. I tell you, there is a strategy to our thumbnail for this particular trial. I'm not sure if you've seen this, though. Let me see if I can give you a little sneak peek to what it looks like. In this case, this was the defendant, the mugshot. And you can see on the side of the defendant, up on both sides, these are the purses the judge has brought to court that sit in front of the flowers each day. She brings a different purse each day, so these are the purses of justice. And next to each purse, there is an item of clothing that appears to look very similar to what the purse does. So today's purse has zebra stripes. I don't know what else that looks like other than, I guess the thong.
Thank God. I just gotta say this. I know you're gonna bust my chops for this, but man, what a mug shot. That is. Oof.
Oh, it's not the best look, and he sure has a different look today. Much more clean shaven or clean appearance, but
he looks like he ate a lemon and it was not to his liking. He's about to go Karen on the manager. Is what that look.
Well, he did turn himself in.
The purse lips of really. That's what I'm getting body language wise is what I'm getting on it. So.
If anyone has suggestions that differ from the clothing items that we have on here, do send them to the burner phone or to, the burner phone is probably the best way to do that. We'd like to update the pictures so that the purses of justice and the clothing of justice is properly represented.
We have it looks like we have the undergarments of justice.
Well,
one purse looks like underwear.
Justice comes in layers. So I think that's appropriate.
The granny panties of justice.
It's not
is that
just
where
a
we're
robe. There's always something under the robe.
Oh my Lord! At least it's not the thong of justice. That would be a little bit too disturbing even for me.
Top left.
Oh no! Oh no!
Yeah. That happened. So anyway, now I have to clear my Amazon search history. How do you do that? I have no clue.
Alt F4 and shuts the computer off. It's the best way to sometimes it's just better to walk away.
Yeah, I'm sitting here thinking what's going to happen right now. This is still a live shot from court. This is live, even though nothing's moving. Everybody's here. The mics are muted. It's not paused. This is live in real time. The judge has ordered the prosecution to go and see if they have the contact information, not for the people in the video, but the people who gave them the video. And this is going to start a chain of events where defense is going to scramble to try to reach those people. And they're probably not going to be able to do it, honestly. It's a futile effort, especially within the constraints of the time of court. So either they're going to have to say, Judge, we believe that this was egregious, especially if the prosecution has the information all the time and just never turned it over. They could be like, hey, that's Brady. You had the name of the person who knew who was on the videos and you didn't turn that over. That could be Brady, and that could be mistrial, and we get to do this all over, get a continuance. Obviously, when jury is seated and you get a continuance, that's a mistrial. Sort of starts over because you don't just send the jury home for 2 weeks and start again. But
yeah, but I mean, it's got to be pretty. I mean, if I'm not mistaken, and the chat, you and chat can correct me because I've been running around doing my own thing for a while. I thought Brady, you had judges didn't want to grant Brady unless you had it pretty rock solid.
Like in the Alec Baldwin.
As far as proving Brady violations, you had to be pretty rock solid on proving the Brady violation.
The Brady violation, I think there has to be an element of intentional failure to turn over or intentional hiding of evidence. You got to basically hide the ball. If you're like, oops, Judge, okay, I thought we gave you everything. I completely missed that folder. Then it's like the judge is like, okay, so that was bad, but it's not Brady, usually.
Okay. So it would have to be twirling mustache, not to the quite to the level of twirling mustache of evil, but pretty egregious in order for them for the judge to be like, all right, that's Brady.
Yeah, it's got to be pretty egregious and serious, and not really systemic, because it can be done by one person, but if there are multiple people involved that seem to be participating in hiding, that really elevates.
Well, in the reason I'm asking, Scott, and I know this is kind of a charge trial, but this is a great example of it. Was the Kyle Rittenhouse trial, when the prosecutor was trying to question Kyle Rittenhouse about taking the fifth or not incriminating himself or something, or he took the fifth with the police, and the prosecution brought that up, and that's a big no-no.
Yeah.
But even then, the judge said that's not a Brady violation when the defense was screaming their head off. It was a Brady violation.
Well,
that's why I'm asking that question, because it's
Judge Schroeder is a law unto himself.
Yeah, no, that's true. I love Schroeder. He's just oh my god.
he's a different judge and does things differently, and I think some of that had the case been decided differently might have been overturned on appeal.
Right. Well, and that's the thing, is that it's just, that's why I asked those questions, because when you hear one of the defense people talk about it, like a lawyer that actually knows their stuff, when they talk about it, it seems pretty cut and dry, but in practice, it seems to kind of take on this ambiguous, almost kind of role of when it actually applies.
Well, everything's fluid, and we have these set of law books that are like all black and white, and it clearly spells everything out. And then we have this set of facts, or an actual occurrence, or it's a case where you're trying to fit it into the law and see how it applies. There are very few situations where it's just, it's perfectly made for this. We've had a case, just Corey Richens, just the other day. We had the sentencing in Utah where the legislature made a law to prevent harm to victims, and here we have a victim who's passed away, and now the harm through the law, the children are harmed, and it's like, well, yeah, you can't. The legislature literally made the law that caused the problem, and the laws are like that. The judges sometimes have to make a ruling that then goes up to the Supreme Court, usually on appeal, to decide where things are, and then it gets kicked back to either the legislature or the other court. So anyway,
so it can be spaghetti. So it's I was just wondering about that, because I was kind of sitting there when they started calling out Brady. I'm like, okay, well, when do we actually apply this? You know what I mean? Because I know what it means, but
Brady is a word you wave. Brady's a word you wave around when you're trying to get the court riled up. Okay, it's one of those.
Yeah.
It's a flag you wave to show I'm mad as heck and I'm not going to take it anymore type thing. It doesn't always apply. In most cases where Brady's addressed, it isn't. Sometimes you get a hearing before the judge rules that this isn't a Brady violation, but rarely does it actually go all the way and say, yeah, this is Brady. And
and add on top of that, you get the defense, who are trying, and rightly so, are trying to advocate on behalf of their client in to the full limit they can, which is what they're supposed to do, absolutely. But given that it can kind of throw everything that we're told this is what this means. It throws all those things out of context sometimes, because now it's like, okay, now are you just advocating really hard, or is that a real thing now?
I like this attorney because he's been consistent on this point, and so I believe his heart is behind this argument. That
okay.
I mean, he hasn't rationalized or explained why 3 months later he's screaming, "Hey, you never told me!" when he has the video the state turned over on time to him. And it's like, no, you're complaining they didn't do the investigation. You sort of also didn't do any investigation into the evidence if you didn't look at it. And so it's like pot meat kettle. There is an obligation on the part of the investigators to thoroughly investigate the case to reach the truth. But you here as the lawyer who's cashing the big check at the end of the day and walking away free regardless of what happens to your client, maybe you should have looked at the file as well. And so you can't necessarily, throw up your hands in court and say, "Your Honor, I object," when you had 3 months of opportunity.
Yeah, we'll see. In GMR, I don't know who that is, but GMR is bringing up the point. That's what initially I thought too, was this should have been brought up at pretrial at the latest, was because that's where I'm used to hearing these kinds of arguments.
Mm-hmm. And
is
normally
like before we get going.
It's sorted out, and there's a motion in limine, or there's a stipulation, months ahead of time. The state's like, yeah, we don't know who this is, but we did get this anonymous video emailed to us, and we put it in the file, and we would just be able to go forward. But.
Yeah, and that's why when somebody said this is mid-trial, I kind of lost my cookies a little bit because I was like, this is a what? This is what? Where are we?
We're in San Antonio, Texas, baby. Remember the Alamo.
This is like one of the tires are flat, and we're halfway there. I'm like, what? When did you know the tire was flat?
Yeah, we're still driving. We're driving. We're seeing this to the end. We're not stopping for any reason. Speaking of end, I'm not sure if you knew, Judge Boyd lost her reelection this year. So it was in a primary. So I don't know exactly which judge won, but her last day is like December 31st. So January 1, she's a free agent. In case you want her on your channel or somewhere else, you can reach out. I think she's great. I like her, but she does require flowers on a regular basis.
Well, flowers and pickles. Yes. They have to get the pickles. The pickles are a given treatment to
and purses
woo the judge. Yeah. Yes. Yeah. And if they're wooed by pickles, we don't want to talk to them anyway. That's just not reasonable people right there.
It's a litmus test. It's good stuff. I'm actually enjoying this. This trial started out as a bit of a sleeper. The facts were interesting. I was wondering if the whole Tesla argument for autopilot was going to be argued. It wasn't. That was not the case at all. Autopilot never would have taken you up to 88 miles an hour in a 35 mile an hour zone. So I was interested on the Tesla side, but the only real issue that's been brought into court about it being a Tesla is briefly the weight of the vehicle as it compares to other combustion engines, and more importantly, the fact that Teslas are covered in cameras and they record all the time. As a matter of fact, they automatically, after there's a crash, upload it personally to Elon Musk's laptop if there's a crash, so he can review it himself. I don't know who it goes to, but Tesla does automatically upload all the video camera and the data when there's a crash, and the court also was able to achieve these. So the witnesses have been testifying about that, and the jury has seen every angle as we go around the car of this event from the Tesla's sort of point of view.
God, that's got to be horrifying.
Yeah.
To be on the jury and see all that from every angle, that's not something I'd want to see from every angle.
Well, think of the defendant. His car is testifying against him right now. It's like his worst enemy in this case.
Yeah, not kidding.
So.
Well, and here's my thing is, did they bring up at all Tesla's self-driving, and maybe you could have,
no.
Did they try to blame it on the AI at all or anything? Or
well, defense has not gone yet. The state just barely rested. So there's a possibility defense could raise this issue. We haven't seen any indication of that yet. And if they were going to, it would probably be through an expert that would testify. There would probably have to be something in that computer, which the state has already looked at, that would show that was happening. It's not there. So I don't think the self-driving is even going to be a factor. But
which honestly kind of makes this whole matter worse, because my brother's got a Tesla, right?
Yeah.
And it has a self-driving function on it. Well, I should say assisted driving. But the thing is that if you're drinking too much, there's the possibility you could have used that to get home, which proves even more irresponsibility, if that's even possible, if you were drinking.
Yeah.
Now, personally, I would just what I call the
driver is not a solution, folks. Don't.
Well, no, but I mean, at the very least, it would have been the least worst option.
Yeah.
And I mean, I would have personally either A, walked or B, just called an Uber.
Mm-hmm.
But I'm old and boring, so that's
yeah.
It's like default setting for me. But but no, because the AI has a lot of ambiguity around it for a lot of people still, and how it works. So I was thinking maybe the defense would use the AI. The AI interfered with the steering or something, maybe like that. You bring an expert on, relying on the ignorance of the jury to not know that much about AI, maybe. But if they're not going with that, then never mind on that theory. But it was just an idea.
Yeah. Just taking a quick peek, our guy that we were looking at briefly that was arguing the chicken case is still arguing the chicken case.
Franchise agreement. I talk about a franchisor, but this was word of mouth handshake, and that's still an okay way to do business. It just makes it tricky.
It's in Judge McBurney's court. If you want to go watch that one, the lawyer's upset in that case. We're watching this, waiting for Judge Boyd to start. You've got two people who co-own a chicken franchise, like a chicken and hookah or something. Franchise, which I didn't know.
That's the thing, chickens and hookahs?
Apparently it is, and they're the only people who do it. And the business shut down, and then the one partner went and started it up again under the same name, and now he's like, no, you can't do that because I own half the... It's a funny argument. But he's like, you're tarnishing the brand. I'm like, you guys shut down. And the judge is trying to understand exactly where this is at and who gets the money at the end of the day.
Hold on. Who's the guy that is getting a retrial for the murder thing?
What's
his name again?
Alec Murdaugh.
Murdaugh. Okay. So remember back in the Murdaugh trial, I was telling you, okay, I had a theory, right?
Mm-hmm.
It was the chickens.
Right.
Because there was chickens there. They had access to the weapons. Now we're looking at what? We're looking at chicken and hookahs.
Right here.
What's the commonality? Chickens. I'm telling you, the chickens are out to get us. My theory is being proven over time. RA, I don't know why you doubt me.
It's not a chicken, it's a guinea. Yeah. Chicken and ice is what they call it. But it sounds like he said hookah, right? They've got like I think they got hookah there.
Chicken and ice.
It's gonna be in Georgia, wherever it is. It's a Georgia thing. Somebody Google this. Tell us what's going on.
That's right, Purple Coconut. It is the chicken revenge. It is the chicken revenge. That's been my theory all this time to RA. He doesn't think it's real, but I'm going to prove it to him one of these days.
It's a hookah filled with chicken broth. I see it now.
That sounds terrible.
It's awful, I'm sure. Oh man, a little bubble, and it smells like chicken noodle soup and smoke. So.
Oh God! Yuck!
Now I'm going to get sued for stealing this guy's business idea.
Yeah, there you go. There it is. The downfall of RAs, chickens, thus proving my conspiracy correct once again.
It all circles around. Well,
that's right.
We're still waiting for the judge to come back. I think the longer this takes, the better it looks for the state. Saying, hey, we don't have this. But at the same time, the longer this takes, the worse it looks for the state, in that defense is saying, why? Why is it just now that you're looking for it? And I guess they'll probably just be able to argue that in front of the jury at closings. But, yeah.
Yeah, but I mean, it seems weird to me that as a defense attorney, my whole thing is to get that cleared up before pretrial. But if I'm bringing that up mid-trial, that changes my strategy thinking to, I'm bringing this up to try to either throw shade on the prosecution, which no jury's in there, so I don't know why you'd do that anyway, or a mistrial. Because, I mean, that's the only utility you get out of that.
Yeah, I think that the problem is, and it's not that the court can't decide this right now. They can. They have the power to do this. It's that judges don't like surprises. They don't like, at the last minute, a new set of situations thrown in their lap where they have to make a decision right now about something and everyone's waiting. They don't like that. They like to be able to reason it out and to consult, either case law or, other arguments. And sometimes they phone a friend. That is allowed. As a matter of fact, judges can phone a friend. They're just not allowed to use the friend to make the ruling. They have to make their own ruling. It's a thing. It's a thing. Some judges even admit it. But anyway, so this is something that was at the last minute thrown in her face, and I think that's why you see some of the frustration that Judge Boyd has expressed towards the defense. But at the same time, she's like, I do want a clear record. I want to know what you're asking, so the record's clear and what you want. And she can't really tell them, if you ask for this other thing, this is how I'm going to rule, especially because the state's already given away the goose when they said we'll stipulate to the video. And so they're like, we'll take that. And now we also want the names. And I think she has to allow them to at least check and see if they have it. If they don't have it, she's going to have to make a ruling, and it probably will come down along the lines of, too little, too late. 3 months ago, you had this video. But
yeah, because I mean, it's in what it sounds like to me is that it almost sounds like a defense is trying to do damage control, not necessarily not guilty verdict, but damage control of any kind. But then I think, well, then why wouldn't you take a plea deal? A plea deal would be the ultimate in damage control. I mean, I'm not a defense attorney, so I don't know. So any defense attorneys out there, feel free to tell me I'm wrong. But
it's interesting because this is obviously the main charge in this case is manslaughter. There's a pedestrian that died, and we know who the driver was. Okay, and so it seems like some key elements of the case are pretty much given to the jury up front. The only thing is the defendant feels that this wasn't me just driving recklessly. This was me, fighting for my life, and through that, an accident happened. Well, isn't that sort of what manslaughter is? Right? If you had done it on purpose, wouldn't we be charging you with murder instead? Vehicular homicide?
Because manslaughter, as far as I know, is not the you don't have an intent of anybody dying, nor are you taking a reckless action to cause that anybody's said death.
And maybe this is just a foregone outcome that everyone knows that it's going to be guilty for manslaughter because it's textbook that way. You're just getting your story out to let them know that it was because you were getting shot at and driving with your head down in the car, top speed, trying to just not get hit.
Well, do we know if they have like a manslaughter 1, 2, 3 in the state, or that they might be throwing them at? So
I haven't checked on that, or if they're lesser includeds. But usually we find out towards the end.
Because maybe that's what the defense is going for. Maybe, I guess, if there's lesser included, because some states have that, some states don't.
Yeah.
So I'm really wondering why the defense bring this up at all, because it's like if you well, yeah, and JMR, absolutely, yeah, and I'm sure the jury hates it too. But the thing is that what I'm trying to figure out is why the defense would bring this up at all, because at this point you're so far along the process, why even mention it?
They have nothing else.
I guess. I mean, if that's the case, then yikes for the defense.
This is not them saying we didn't do it. It was somebody else that hit him. We just happened to run him over next. They're not doing that. I mean, we've seen that in cases, but in this case, they're basically stipulating to the elements of manslaughter. They're just getting their story out to look for sympathy, I guess. But
yeah,
I want to hear what defense does. They waived their open, I believe. So they might give an open before their case right here, or they might.
Oh, thank you, Amanda. Amanda got us covered.
Let's see.
Texas just has manslaughter here. There's no first, second, or third degree. Okay.
In that case, let me look at the elements of that one.
Maybe it's mitigating circumstances, lessen the
sentence on the
sentencing.
It's possible. Let's use a little grok here for a second to do some deep dives.
Yeah. Sorry about this, guys. It's just I'm thinking strategically defensive wise. To me, this doesn't make any sense because you're just burning everybody's time. It's like,
oh, we're back.
Why?
Judge is back.
Oh, okay. Bye.
Okay, we'll see you. Bye. Trying to read body language on the side of the defense. It looks like they were handed a paper. Jury's coming back in. A lot of people on the defendant's side of the courtroom, not necessarily meaning they're supporting him. I mean, some of them are wearing badges that indicate court personnel. But well, now that I look at it, a lot of people, it's just two. The elements of manslaughter: the defendant caused the death of an individual. Well, we've got that in spades. The defendant acted recklessly. That's going to be the mens rea. There has to be a mens rea element. That's why they're fighting it. It's just element 2. If they can strike that, then they don't have manslaughter. If the reckless activity of him ducking down and flooring it on his Tesla to go 88 miles an hour, I don't know. I think they still got him because he approached the guy that ran the red light, pulled up next to him, then apparently had the altercation and where guns were shown, and then we've got the shots fired as him speeding. I think it's stuck. I think he's stuck with manslaughter. Thal, thank you, by the way, for the call. Sorry to push you off like that.
Yes.
All right, to the jury.
All right, everyone, please be seated. All right, defense, do you have any opening statements? All right, you may proceed.
Okay, here's the opening for the defense now. This could get fired.
As you know, my name's David Whiting. I represent Robert Castillo in this case. You've heard a lot of evidence from the state. We think that the evidence is going to show you that Robert Castillo is a family man, that he was a generous employer and boss, that he spent the evening out with his employees kind of as a reward for doing a great job at their shop. I was going to show you, it was a work event. It wasn't a night out in the town with the boys. But they went to a food truck park called Elkin and had a good time. Robert brought everybody dinner, just as a way of saying thank you. Went back to his apartment. They went to the pool, hung out for a little while. People start to leave. Mr. Lerma's there because he has this rule, as we heard, that you don't drink and drive. If he's had anything, he's not driving. He has to spend the night with Mr. Castillo's. He's an employee of his. But Mr. Castillo says, okay, no problem. Everyone's going to show you that earlier that day, Ashley Sanchez, the mother of his children, had been calling him about, hey, I need you to come pick up the van, the minivan we use for the kids, because it's March 24th.
That's my birthday.
Right in time for Fiesta. That next weekend, this all happens like on Friday. That weekend was King William Fair. And that's where Ashley lives. She lives down in the King William district of San Antonio. Very close to Alamo and Provant, where this accident happened. Hey, I need you to come get the car, so that the minivan, so that the kids can use it, so we can use it to get around this weekend. Otherwise, we're going to be stuck here with no car because they shut down all the roads. So Robert's been entertaining his employees all night, getting late. One last thing he's got to do. I'm going to take care of my kids, make sure they got a ride for the weekend, get this car out of there, and just do what I've got to do. Evan's going to show you that at the time, Ashley and Robert aren't together. They're not seeing each other. But he wants to do right by his kids. Make sure they're taken care of. So he gets in the car with Mr. Lerma. They head down to downtown from the Pearl area and exit at South Alamo. We've all seen Tussle already, right? The FJ makes a left in front of him. Mr. Castillo is tired, it's late. He went, I'm going to go. Goes behind. All of a sudden, he finds himself in a nightmare. FJ's pulling off to the side, hitting his brakes, slowing down, kind of pacing. Robert's going, okay, well, what's going on with this guy? What do I do? I'm going to check and see if this guy's all right. FJ rolls down his window. Immediately starts getting hostile and aggressive.
Is Robert going to testify?
Mr. Castillo makes a joke and just kind of says, hey, you ran the light back there. Oh, well, he ran it too. Just trying to make light of it. Just diffuse the situation a little bit. Evidence already showed you from Mr. Larmer's testimony. He wasn't yelling at him. He wasn't aggressive. His voice never changed. At that point, the vehicle stopped. The driver of the FJ opens his door like he's getting ready to come out and assault them. Robert opens his door just in case he has to get out of the car, closes it fairly shortly thereafter. If you look at those Tesla videos and time it out, you'll see that the driver of that FJ keeps his door open for like another 7 seconds. Still talking to these guys. Still getting aggressive with them. Mr. Castillo is going to testify that he never had that gun on his lap. That the gun was in the console of the vehicle. He wears it on his hip, and when he gets in the car, he takes it off because it's uncomfortable. It hurts. So he puts it in the console. This testimony about it being on his lap, I don't know where that comes from, but you guys are the triers of fact. You get to determine what that evidence shows you. Okay? The next thing that he knows, Mr. Castillo looks out his window, and the driver of that FJ, Diego Gomez, is pointing what appears to be a sawed-off shotgun at him. You're going to get a chance to look at those pictures that we've submitted. There's going to be some more evidence that comes in to show you this. But if you look at those and you blow them up, you're going to be able to see a sight, and you're going to be able to see 2 darker circles. It's very bad video. I'm going to admit it. But we've got what we've got. The defense doesn't have the burden here. Remember that. We're presenting you the evidence that we've got to work with in this case. But you'll see 2 darker circles there that look like the barrel of a sawed-off shotgun. Mr. Castillo sees that and takes off. Immediately after that, bang, 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 gunshots go out. You're going to see
it would have been boom,
evidence
boom.
That those bullets hit the Tesla. Mr. Castillo is going to tell you there were no bullet holes in the Tesla when he left the parking lot that night. There's no bullet holes. Those bullet holes came from being fired at by the driver of the FJ. So we believe the evidence is going to show you was a gentleman by the name of Diego Gomez.
With a shotgun.
Those Teslas accelerate very quickly.
This is opening, but it's...
He got up to 88 miles an hour. We already know that. He's ducked down behind the dash. He's literally using, you saw the giant screen on the Tesla, right? The pictures of that? He's using that screen because it's in GPS, it's in real time. He's using that to drive. He's been in this area of town hundreds of times. He knows that curve's coming up. And he's trying to negotiate it while ducking down, trying not to get shot. One of the things we have to look at here is whether or not the evidence is going to show you from his perspective what was going on. And one of the things you're going to learn in this trial is that Mr. Castillo's got a brother named Paul. Paul was shot in a road rage incident and is now a quadriplegic. He's bound in a wheelchair the rest of his life. And that while this is going on, that's exactly what Mr. Castillo is worried about. He's worried he's going to be just like his brother. We heard from Mr. Lerma already. He was running for his life after this thing happened because his mom had been shot and murdered. That perspective has a powerful impact when you're in that situation. And I think what you're going to find at the end of all this is that when Mr. Castillo took off and was trying to outrun this FJ that was firing at him, I don't think he did anything that any one of us wouldn't do. And your standard here is that it's got to be a gross deviation from what an ordinary person would do under those same circumstances, taken from his perspective. I think the evidence is going to show very clearly this is pretty much what anybody would do in that situation. When he's ducked down and he's trying to negotiate that curve, he's not looking at the windshield. Just like Mr. Lerman, they're both ducked down. And unfortunately, he doesn't negotiate that turn right. He hits that island. He hears a loud bang, makes him duck down even further. He thought he got hit again. They go on the sidewalk, and unfortunately, God bless him. Great news right there. It's a horrible accident, but I think the evidence is going to show you it's not a crime. The other charge that we have to deal with here is fair, stop, and render a death. And there's elements to that, and we'll go through that, and you'll see those in your jury charge. But I think that the evidence is going to show you that he stopped because the vehicle plowed into the wall. The second element says he has to come back and didn't stop, so we don't have to worry about the second. We know if he stopped and hit the wall.
Yes.
I'm just gonna object on spirit. I can't hear you, Megan. Sorry. I'm making an object as argument to the jury if we can just stick to the evidence.
All right, that objection will be sustained.
It's openings.
Okay. I think the evidence is going to show you that he stopped when he hit the wall. I think the evidence is going to show you that he got out of the vehicle and looked around to find out if anybody been hurt because he was looking for Mr. Lerman. I think the evidence is going to show you that the only other person he knew was involved in that accident was Mr. Lerman, other than himself, because he never saw Mr. Lerman. Gets out of the vehicle after all the airbags are deployed. That is going to show you the airbag curtains are down. He can't see through the vehicle. Mr. Moody is on the other side of the vehicle. It's dark. Airbags have gone off. He's disoriented because he's been injured in the accident. He gets out and he's looking for Mr. Lerman because he's the only other person he knows that's been in the car. He sees Mr. Lerma off the street and goes after it to try and find out, hey, you okay? What's going on? What are we doing? Meantime, he knows that these guys have been shooting at him. And he decides, I can't stick around here. I'm going to get shot. And he leaves after Mr. Lerma pushes him away. I'm good. Go away. You can't use my phone. All the other stuff that we've heard. That was going to show you he goes over to Ashley Sanchez's house, which is only a couple of blocks away. He knocks on the door. He's crying. He's hurt. He's very upset. She doesn't want anything to do with him because they're not together.
Defendant has to take the stand for all this evidence to come in.
The evidence is going to show you that she's going to testify he was not intoxicated, that she's very sensitive because her father was an alcoholic, that she's very sensitive to the odor of alcohol or intoxicating beverages. She's going to tell you 100% he was not intoxicated when he went to her house. Evidence is going to show you he gets into an Uber and goes to a friend's house. The next day, he's in pain, can't even get out of bed. The following day, the 27th, he turns himself in voluntarily because he sees on the news, oh man, somebody got killed. I've got to go do the right thing. I'm just going to show you that you trusted the justice system. We trust you to weed this thing out and show that after you analyze all the evidence, Mr. Castillo is not guilty of manslaughter. He did what anybody else would have done under those same circumstances. He's not guilty of failure to stop and referee because he didn't know Mr. Moody was there, and because he had a necessity defense. He had to leave or he would get shot and kill himself. We have a right in Texas to protect ourselves.
And it supersedes the right to render
I
aid.
think when you see all the evidence in its totality, and you look at everything, I think that your only verdict is going to be not guilty on both counts. I appreciate your time. I look forward to presenting our case.
All right, defense, call your first witness.
Yes, Judge. Defense calls Jared Lopez.
All right, there was the opening statement. The defense deferred until the beginning of their case, so now we're in the second half of the evidentiary portion of the trial. He was just going to leave his car there, I guess. It was pretty much totaled into that wall.
If you'll put on that square gray microphone that's up there, it's for the court reporter to hear. Okay. And if you can raise your right hand, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth to help you God?
Yes, ma'am.
All right, you can have a seat. Make sure you keep your voice up so that everyone can hear.
Okay.
And if you'll state your name for the record.
Jared Lopez.
All right, defense, you may proceed.
Thank you. Mr. Lopez, can you please introduce yourself to the jury?
Yes, my name is Jared Lopez. Yeah.
And Mr. Lopez, how do you know Mr. Castillo?
I know Robert from working at Take 5 Oil Change.
And how long have you known him?
Roughly about 7 to 8 years.
And how well do you know Mr. Castillo?
I would say I know him pretty well.
Where are you currently employed?
Work at Allied Fire Protection.
Where were you employed in March of 2023?
Take 5 Oil Change.
How long did you work there?
Roughly about 8 to 9 weeks.
And when did you leave Take 5?
In 2023.
Is there a reason that you left?
I was terminated.
Okay. And what were you terminated for?
I was terminated for one of my employees doing a vehicle inspection. That should have failed, that passed, but since I was a manager, it fell directly under me.
Now, are you familiar with the events that occurred on March 25th of 2023?
Yes, ma'am.
And what were you doing around that time?
We were at Robert's apartment. That night we had met up for a company event. Since one of the stores had won the most clean shop in the company.
And my apologies, Jared. Is this on March 25th?
Yeah, March 25th is a Saturday.
I believe it was a Saturday.
So it would be March 20. The Friday was the day we met at the apartment.
Okay. And had you guys planned to meet at the apartment?
Yeah, it was a planned event with Robert and the regional manager.
Okay. And what were you guys celebrating? I'm sorry.
We were celebrating because one of the stores at Take 5 won an award for most clean shop in the company.
And what was Robert's role in this?
He was our district manager.
But what was his role in the celebration?
He was there to take us out at a store level to help celebrate an accomplishment for having the cleanest store in the company.
What time did you get to his apartment?
I arrived at Robert's apartment at 7 o'clock.
Who was there when you got to his apartment?
It was just us two.
And did other people eventually arrive?
Yes, ma'am.
Who was at the apartment?
Myself, Robert, Antonio Lerma, and then some of other Take Five employees that I don't call their names.
Once everybody got to the apartment, where did you guys go?
We walked the river walk to go to El Camino.
And what is El Camino?
El Camino is it's an outdoor establishment that has multiple food trucks of different types of food.
Is it a bar or a club?
No, ma'am.
And once you guys got to El Camino, what did you do?
El Camino, we're just conversating, talking about shop talk, who has the best store, talking about sports, just normal conversating.
And were the same people that met at Robert's apartment all at El Camino as well?
Yes, ma'am.
Was Robert drinking at El Camino?
To my knowledge, me and Robert were drinking. Robert had one beer.
Was this considered a work event?
Yes, ma'am.
Why would you consider this a work event?
Because it was directly coordinated with bar district manager Robert and also the regional manager, which would be Robert's boss.
So this wasn't a boys' night out?
No, ma'am.
Does Take Five have any type of policy regarding alcohol at work events?
Yes, ma'am. It's a responsible amount of alcohol.
Okay. Were you drinking that evening?
Yes, ma'am.
Were you buying drinks for other people in your party?
Yes, ma'am.
Did you ever buy Robert a drink?
No, ma'am.
In your opinion, was Robert intoxicated at any point that night?
I don't know, Jack, last one for legal conclusions.
Sustained.
Did you observe
You
him showing
said
any signs
Antonio
of
Lerma
intoxication?
was with you that night?
Yes.
Right. And do you know Antonio very well?
I would say so.
And how do you know him?
Also through Take Five OJ.
Okay. And how long have you worked with Mr. Lerma?
3 or 4 years. I was his immediate supervisor.
Did you have a good working relationship with him?
Me and Antonio had a good working relationship. It was just, yeah, I would say so. Yes.
Mr. Lopez, when did you hear about the accident?
The following day, which I believe would be that Saturday morning, received a phone call from Antonio Lerma.
And did you ever hear from Robert on that Saturday, March 25th?
No.
At any point on that day, do you go to Antonio's house?
It's the following day, yes, ma'am, I went to Antonio's house.
And what happened at his house?
Antonio called me over to pretty much try to figure out what was going on with Robert because he was our immediate supervisor. So he called me over to talk about, I'm not too sure. But when I arrived to his house, there was Antonio and all of his family there.
And was Robert there?
No,
ma'am. Has anyone from San Antonio Police Department ever contacted you about this case?
No, ma'am.
Mr. Lopez, earlier you stated that Robert had one beer, correct?
Yes, ma'am.
Do you remember approximately what time that was at?
It was roughly about 9 o'clock.
And was Robert acting normal to you?
Yes, ma'am.
We'll pass the witness, Your Honor.
State.
Okay, Mr. Williams, so you testified that you all were at El Camino, is that correct?
Yes, ma'am.
All right, and you testified that it is not a bar, but a food truck park, is that correct?
Yes, ma'am.
Okay. And even though it's not considered a bar, they still do sell alcoholic beverages there, is that correct?
Yes, ma'am.
And in fact, they have, I guess, for a lack of a better word, a specific trailer that sells nothing but alcoholic beverages, correct?
To my knowledge.
Okay. And so just regarding that night, you stated that you were consuming alcohol, is that correct?
Oh, yes, ma'am.
Okay, and how did you get home that night?
My wife.
Permission to approach the witness.
Yes, you may approach.
Do you recall what alcoholic beverages you were drinking that night?
I don't recall, ma'am.
Do you remember if you paid with card or cash?
That's usually card.
So I'm going to show you what has been marked as State's Exhibits number 48 and 49. Can you take a look at the name that is contained on this document, as well as the name? Yes, and the drinks that are contained on this document?
Just to confirm, yes, ma'am.
Okay. And so does that appear to be an accurate representation of what you purchased on that day?
It looks correct, yes, ma'am.
Okay. And so can you tell me how many drinks that you purchased yourself that night?
I don't recall, but based off this, it shows.
I'm guessing a lot.
Is that 5?
Okay. And what were those alcoholic beverages?
It shows here Tito's and orange juice.
Okay. Is that, to your knowledge, also known as a screwdriver?
I'm not too sure. I don't recall.
All right. And did you consume these 5 drinks yourself?
No, no.
Okay. Who did you provide them to?
Myself and then whoever else was there at the establishment at El Camino.
Okay. So how many drinks did you consume that night?
I don't recall.
Okay. And so it's fair to say that if you were consuming alcohol, although you can't remember exactly what you consumed, you had at least purchased 5 alcoholic beverages. Is that correct?
That's correct.
And so alcohol can sometimes have an effect on your memory. Is that right?
Not too sure.
Have you ever been intoxicated before?
I'm pretty sure.
Okay. And so sometimes when you are under the influence of alcohol, you don't have an accurate recollection of what occurred. Is that correct?
Speculation.
That will be sustained if you want to rephrase.
Okay.
You can get this answer differently.
So during times that you've consumed alcoholic beverages in excess, can you recall a time that that's occurred?
Where I consumed alcohol and I can remember the time frame.
So can you remember a time frame where you were intoxicated?
Objection, Your Honor, relevance.
That'll be overruled.
Can you ask the question one more time, please?
Yes. Can you recall a time that you've been intoxicated by consumption of alcohol?
I don't recall.
Okay. But I guess my question is to you that it's fair to say that had you been consuming alcohol that night, your memory might not be the best. Is that fair to say?
That's fair to say.
It's possible, right?
It's a possibility, yes, ma'am.
He chose his battles wisely.
And so
looking silly.
Were you ever the defendant's boss, or was he your boss?
He was our supervisor.
Okay. And so he held a supervisory role over you, is that correct?
Correct. He was a district manager.
What was your position?
A store manager.
At this time, we'll pass the ones.
Defense.
No other questions, Your Honor.
All right. Is this witness excused or subject for recall?
Excused from the defense.
Excused from.
All right. The rule has been invoked. You're not allowed to discuss your testimony with anyone while this trial is pending. If you'll remove the microphone, please, and you're excused. Thank you. Defense, call your next witness.
Yes, Judge. Defense calls Ashley Sanchez.
Ashley Sanchez next up. Yeah, interesting. He doesn't recall ever being intoxicated. That could either be confirmation that being intoxicated affects your memory, or it could be a fib. But he bought 5 screwdrivers that night. He just didn't drink them all.
All right, if you'll take a seat here, please. All right, there's a gray microphone up there. If you'll just put that somewhere on the shirt, it's for the court reporter to hear. And you can put it on your collar too if you want to. All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you keep your voice up so that everyone can hear. All right, state your name for the record, please.
I'm Ashley Sanchez.
All right, you may proceed.
Actually, I can already tell it's going to be an issue. If you can bring that microphone a little bit closer to you.
Can you hear me now?
Yeah. Can you please introduce yourself to the jury?
I am Ashley Sanchez. I am the mother of all 3 kids of Robert Castillo and Stockford.
And Ms. Sanchez, how long have you known Mr. Castillo?
I've known him for 15 years.
And how well do you know Mr. Castillo?
I know him very well. I can say I know him better than his own mother.
Whoa, there's a bold assertion.
Now,
better than his own mother.
You've been in trouble with the law before, is that correct?
Yes, correct.
Can you please explain to the jury what happened?
I've been in trouble for assault and family violence. Currently on deferred adjudication probation.
And do you know
in this court
what deferred adjudication means?
I am under supervision from my probation officer. As of right now, I have no convicted felony on my background.
And in relation to your case, are you receiving any kind of benefit to testify here today?
No.
From the state or from Robert?
No.
Or from us as his attorneys?
No.
Now, I want to take you to March 24th of 2022.
Mm-hmm.
Were you in contact with Robert that day?
Yes.
Why?
We agreed that he's going to come pick up my vehicle from my apartment so that it can repair. It was broken down. I'm not able to drive it. I just really need to get my vehicle fixed for our kids.
And were you and Robert together at the time?
No.
What happened around 1:30 in the morning on March 25th?
Robert came to my apartment. He was knocking on my door. I wouldn't open it until I finally did. He asked me for a ride. I kept denying him. I didn't want him at my place.
Let's break it up a little bit, okay? So you said he came to your apartment and he was knocking at the door?
Yes, correct.
How was he acting?
He looked a mess. He was missing his shoes. It looked like his shirt was torn up. His hair was everywhere. He was crying. He was crying to me, begging me to come in, just to come in. He looked a mess. He looked very scared.
Have you ever seen him like that?
No.
How is this helping him?
You stated that he was asking you to come in. Did you let him into your apartment?
No, I didn't. I offered him a ride just so we can get out. I didn't want him there. I was very ugly and mean to him. I didn't care what he had to say.
Why didn't you let him into your apartment?
I had a guy that I was dating at that time over in my apartment. And I just didn't want him to come in.
There was another guy here at the time. Okay. So ex-girlfriend, right?
Where did you continue your conversation with him?
I closed the door, left my plate inside the apartment. I walked out. We were just on my staircase. We were talking. I just kept telling him to leave. I didn't care what he had to say. I just had to leave.
Right. You asked, or earlier you stated that he okay, so you guys are outside of your apartment.
Correct.
And you want him to leave, correct?
Correct.
Does he eventually leave?
Yes, I get him a ride through a lift, and I make him stay in front of the house that I was renting.
Did he ever ask to use your phone?
No.
When you were talking with him, Did he show any signs of intoxication?
No, 100% no.
When
100% no.
did you find out that he was involved in an accident?
His mom, I would say more like around 10:30 in the morning. His mom gave me a call because I had called her that same night. Because if it wasn't Lyft that was going to give him a ride, I wanted his mom to give him a ride. So I didn't find out. She called me. She received a text that his car was in an accident. So she called me trying to figure out what happened, if I knew anything. I didn't know anything until she mentioned it that morning.
Judge will pass the witness.
State.
Wow, not
Okay, Sanchez.
not entirely
So
friendly.
on the night that the crash occurred, your address was 326.
We'll mute that.
Historic district.
Yes,
Right? Correct. Okay. So how long did you live in that district? I just moved that month. I had moved at the beginning of March. Okay, so you had just moved to that. Was it an apartment or a house? It's a townhome that was split up into, I believe, 8 apartments. Okay. So you had been living there for roughly a month, is that correct? Correct. And then after the crash, how much longer did you live there? I believe just 1 more month. Okay. They sold the house. Okay. I'm going to ask you to look at State's Exhibit number 49. Can you take a look at that and see, does that appear to be a fair and accurate like map of Madison Street right here and then South Alamo, including Proband? Yes. It does. It doesn't, that appears to be a fair and accurate. Yes. Depiction. Okay. So at this time, I'm tendering State's Exhibit number 49 to defense for inspection and offering the same. Megan, I thought you already walked to 49.
Yes. There is a
Got a little sidebar, huddle. We've got documents. Sometimes the judge turns off this camera. When she does, it causes problems with the live feed. Grouchy faces at the sidebar. Looks like that's decision. Oh, more information comes in from the back row. State now offers to go get something. What's that document? Oh, that one's ours. You get your own. Like that tie, the red power tie. Okay, good. We're back. Hopefully with audio. Judge, please give us audio.
Yes. So I'm just going to show you the same map that I showed you. It's now marked State's Exhibit number 59. Can you just take a look at that and tell me if it's a fair and accurate representation of the area that you lived during the time of the crash? Yes, okay. That is correct. Thank you. Now at this time, I'm tendering State's Exhibit 59 to defense and offering the same.
No objection, Judge.
State's Exhibit number 59 is admitted without objection.
Permission to publish.
Granted.
Sandra, can you see that up there on the screen to your right?
Yes.
So we're looking at State's Exhibit 59. Madison Street is running right here. Is that correct?
Correct.
Okay. And so South Alamo and Provan is at this intersection right here. Is that correct?
Correct.
Okay. And so you testified that the defendant arrived at your residence at about what time was that?
One
Around
1:30.
Okay. So sometime between 1 and 1:30 a.m. Is that correct?
Yes.
Okay. And so can you kind of explain to me the stair area that you all were talking in?
It is in the back of the house. It's the only stairs at that house. It goes straight up to the second floor. It's right at the right side of the fence to the other house.
Okay. So the stairs are located in the outside area of the home before you enter the front door. Is that correct?
Yes, it's in the back.
Okay. And about how long were you all outside talking?
10 minutes.
Okay. And so at any point during this interaction that you had with the defendant, did you all hear fire sirens or police sirens?
No.
Okay. Even though there were some in the area attending to the victim at a crash site, you didn't hear any sirens?
I did not hear anything.
Okay. And so you testified the defendant went from the crash to your residence, is that correct?
Correct.
Okay, and then you got him, what did you say, lift to a separate location?
Yes.
What location?
That was his apartment.
Okay. And then you go with the defendant to turn himself in on March 27th, 2023. Is that correct?
Correct.
Okay. And at this time, your phone number was 210-84.
That was close. 867-5309.
And so you had access to a phone at the time the defendant showed up to your residence. However, he did not ask you to use that phone at all. Was that correct?
Correct. He didn't ask for the phone.
Okay. And at the time that you go with the defendant, do you recall which substation you went to? Was it the central? It was a central substation located on Frio. Is that correct?
Yes.
And it's not really far from your residence on Madison Street, right? It's just straight up South Alamo onto Frio, correct?
Yes.
Would you say it's between like a 4 to 6 minute drive from your place?
I would say about a little bit more, 7-10 minutes.
Okay, so less than 10 minutes, fair to say.
Yes.
And the defendant's mom also accompanied you all to this tournament, is that correct?
Yes.
And you all were very sad at the time, right? You're hugging him and crying before you leave him at the substation, correct?
Yes.
Okay. And at this time, you're aware that he's killed somebody with another vehicle, correct?
Yes.
And that Mr. Moody's parents didn't have an opportunity to give him one last hug.
Objection, Your Honor. Speculation.
All right, that'll be sustained.
And so after you leave him there at the substation, you talk with him on a recorded line multiple times between March 29th of 2023 and March 31st of 2023. Do you recall that?
Yes.
Okay. And so, well, let me back up a little bit. Because you said that your phone number was 210-847.
Go easy on that, ma'am.
May I see the defense exhibit of the self group?
It's your exhibit. You should have it.
So I'm going to show you what has been marked as Defense Exhibit A. And I guess before I do that, prior to the defendant turning himself in, you communicated with Antonio Lerma on March 25th and March 26th.
Correct.
Okay. And so if we look at Defense Exhibit A, which is Antonio Lerma's phone records, I'm going to turn to page 9 and start at line 145 to 149. you can refresh your memory with the phone numbers, but does it appear that on March 25th of 2023, you called Antonio Lerma's phone 5 times?
Yes, correct.
Okay. And then on the following day, on lines 163 through 165, you called Mr. Lerma's phone 4 times. Is that correct?
Correct.
Okay. Yeah, so there's been, prior testimony that Antonio Lerma was, I guess, pretty good friends with the defendant. Did you have personal knowledge of that at the time?
Yes, my kids refer to him as Theo Lerma, Theo Antonio.
Okay. So you all were pretty close. Is that fair to say?
I wouldn't say close, more Robert and them. I stayed with kids.
Okay. So you really didn't hang out with Antonio Lerma?
I would be around.
So now I want to talk to you about some of the things that were said about, well, let me back up to when the defendant arrived at your residence, did you have knowledge that, that he had that motor vehicle, that Tesla, that it belonged to him?
Can you repeat that question?
Yeah, so I guess you knew that the defendant owned the white Tesla, correct? That was the correct. Okay, and so did you know that he was on his way to pick up your van?
I kept telling him I had him a certain time, so yes, I did, and he was supposed to be on his way.
Okay, so you were expecting him that night, is that correct? Okay, and then he shows up at your doorstep, and you don't ask him where his motor vehicle is?
No, because in the back of the house, it's only enough parking for one vehicle per apartment.
Okay, so then if he was originally there to pick up your van, did he leave with the van?
No, the way I saw him crying and frantic, I felt disgusted, and I didn't want him. I thought he was there to rekindle our relationship.
I don't want you crying in my van.
And so then you didn't ask him, any questions about why he was in the state that he was in?
No, like I mentioned, I was just very disgusted with his opinions and everything. We were broken up.
Okay. Did he tell you anything about the crash before he turned himself in?
No, we just went over the same thing. I asked him, well, yes, he did. I asked him what exactly happened. And he told me that he crashed. He was afraid for his life.
Yeah. So then now we're going to get to the point of after he turns himself in. You speak with him on his recorded line between the dates March 29th of 2023 and March 31st of 2023. So on March 29th of 2023, you were already aware that news articles were circulating about the defendant being involved in the crash. Is that correct?
Correct.
Okay. And you state to the defendant that Antonio Lerma threw him under the bus big time. Correct?
Correct.
And then in one phone call, you tell the defendant that you all are searching for somebody to sort of vouch for the defendant's character. Do you recall that?
Yes.
Okay. And he suggested Jared Lopez that just testified before you. You remember that?
Yes.
Okay. And you told them
Jared?
to not call him, or he told you not to call Jared, correct?
Yes.
Okay. And in the same phone call, you tell the defendant that you would do anything for him. You remember saying that? Okay. Now, you mentioned earlier that at the time the defendant arrived at your apartment, you had another romantic interest there. Is that fair to say?
Yes.
Okay. And that person was a male by the name of Andreas, correct?
Yes.
Okay. And you were in a dating relationship with him, correct? And this made the defendant jealous, correct?
No.
No? Okay. So, Andreas' father is the person who ended up fixing your motor vehicle, isn't that correct?
Yes, and this was for another thing. Ended up being fixed before and after my I had a ban on the Odyssey. It's really messed up. It's really messed up. So there's multiple things, multiple people fixing on it.
And the phone calls that you have with the defendant, he's telling you that he's worried about the state of his relationship with you, right? Because he knows that Andreas is really interested in you and wants to be committed to you. Do you remember that?
Objection, Your Honor. Relevance?
The relevancy.
It goes to her incentive and biased test.
All right, that'll be overruled.
You can answer the question. Can you repeat the question? Yes, and the communications that you had with the defendant on this recorded line, he's telling you that he's very concerned about his relationship with you because he knows that Andreas wants to be in a serious relationship and committed to you. You recall that?
Yes.
Okay. And so at this time, you're sort of in a love triangle between the defendant because on this recorded line, you're telling him, you know, that you love him a lot and you do anything for him, right?
Yes.
But at this time, you're conflicted because you also feel bad and don't want to hurt Andreas, correct?
I'm not conflicted. I stayed with Andreas for a whole year after.
Okay. And at the time that you were telling the defendant, I love you, then you stated that Andreas' father is the one that fixed your motor vehicle, correct?
Correct.
And at this time, the defendant wanted you to stop talking to Andreas, and when you informed him that Andreas' father is the person that fixed your vehicle, you're apologizing to him because you know that the defendant doesn't want you to have any contact with Andreas. Isn't that right?
Not correct. Robert never told me to stop talking to him. I was in an actual relationship with Andreas.
So at the time that you're in a relationship with Andreas, but you're still actively communicating with the defendant and considering getting back with him, depending on how things shook out in this case. Isn't that correct?
That's correct.
Okay. And in another call, you discussed with the defendant that you were praying for bad shit to happen to Antonio Lerma, correct?
Correct.
Okay. And when the defendant is speaking with you on this recorded line, he's not worried about the individual that he killed. He's worried about you and Andreas. Isn't that correct?
I wouldn't say me on this, more me and Spence.
Okay. Judge, can I have a second to get the headphones?
So prosecution's trying to paint this witness as having incentive to lie for the defendant, but she really said some stuff that didn't help the defendant too. She has not been entirely kind to him, even saying at one point she was disgusted by him. It's a little bit, it's gone off the rails a bit. Prosecution's gathering up some documents, possibly to impeach this witness. Let's see what happens here.
Okay, Ms. Sanchez, so I guess it's fair to say 2023, it's been a while. Is that correct?
A very long one.
Okay. So would it help you refresh your memory if I played you the phone call that I'm referring to help you recall what exactly was said?
Yes.
Okay. So I'm going to set these right here, and I'm just going to get set up, and then I'll ask you to put them on in just a second.
So she's going to wear headphones and listen to the call to herself? Because I don't think the call's been admitted. I don't just wear other people's headphones, ma'am. And earbuds are out of the question. This is a manslaughter case. The state really hasn't fully proved DUI, although they insinuated it and said they could, but then...
Okay, and so what I'm going to be playing is going to be labeled for identification purposes as State Exhibit number 60.
Okay, so I'm gonna ask you to place the headphones on, please.
Witness is now listening to a recorded phone call. Don't know how long this call is, but I'm guessing it's probably not a few seconds. Yeah, the airplane variety. Yeah, dirt cheap. The quality is terrible, though. There's absolutely no low end. All sorts of drops in the frequency or the frequency sweeps. The witness really doesn't have any giveaway tells on her facial expression as to what she's listening to. It's possible that she will now have to admit there's a nod. That's probably something she heard that was different than what she testified to. Yeah. The court isn't worried about the audiophile's feelings. She's not listening to verdict music. That's correct. Okay, call's over.
Okay, so were you able to refresh your memory with the part I'm referring to where he stated that he was worried about you and Andreas specifically?
Yes.
Okay.
And
so then moving on from that, in that phone call, you further state that you want everything to go good for him. Is that correct?
Yes.
Okay. And you're here today because you want things to go good for him, correct?
Yes. For his.
For, what was that?
For our kids.
And how many kids do you have?
We have 3.
3. And so when you're further talking with the defendant on this recorded line, do you recall you asking him for his Facebook password because you told him that you were going to deactivate his Facebook?
Yes.
Okay. And you told him that you wanted to deactivate it because all his shit was on there, correct?
Yes, correct.
All right. And he informed you that he tried logging in to his Facebook on the night of the offense, but he was unable to because he left his phone at the scene and didn't recall the password. Correct?
Correct.
Okay. And so you asked him for different ways for you to gain access to his Facebook, which was to see if he was signed in and on an iPad or computer or laptop so that you could go and deactivate the Facebook.
Correct.
Okay. And you even went a step further and looked up Eric Moody's Facebook, correct?
Yes.
And in another phone call, you state for him again that you're going to do anything for him and you're going to do everything to protect him. You recall that?
Yes.
Now, then there comes a point where the defendant is terminated from Take 5 Oil. You recall that, right?
Yes.
And you're the one that has to call him and inform him that he's been terminated, correct?
Correct.
Okay. And you had a great issue with the fact that Antonio Lerma was still employed by Take 5 Oil. Is that correct?
Yes. There was 2 in the car.
Okay. And the defendant replied to you that he shouldn't have fucking told Antonio Lerma anything.
I don't recall that.
I'm going to play it again for you. Or play it for all of us.
If you'll go ahead and put them on, please.
Give it a listen.
Your Honor, yes, I can hear that from here, and that means the jury can probably hear it too. Can we sort of turn that down maybe just a hair?
Sure. And jurors, are you all able to hear that?
I can.
Okay.
It's muffled.
All right, if you'll turn it down just a little. Okay, thank you.
I've got a spoiler for you. It's in there. It's in there. You're going to hear it. It's a long call. I wish we could hear it.
Okay. Do you now recall that the defendant told you that he shouldn't have fucking told Antonio Lerma anything?
Yes.
Okay. And in the same phone call, you stated to the defendant that friends go down with you and die with you, and that Antonio Lerma wasn't a friend to him.
Correct.
Okay. Judge, may I approach with counsel?
Judge accidentally turns on her camera, turns it back off. So which is it? Is this woman, this witness, doing anything she possibly can to help the defendant and lying, or is she over him and just telling the truth? I know, Amber. It's been a long day. We haven't taken a break yet, have we? No, we're 6 hours, 22 minutes into the live stream. No breaks. Some fancy frame glasses there, ma'am. Witness seems uncomfortable with the conversation going on right next to her. Yet I think she's trying to listen as well. Josh has been here all day. Josh, you've been amazing. Thank you. I've been sort of following. I apologize because this has a slight political edge to it. But I've been following a couple TikTokers on TikTok. A couple young women who, young ladies who have been doing some digging into the backroom deals behind a huge data center being approved and going in up in a very rural part of Utah, basically old dry lake bed, desert. And they've found some incredible stuff, and their digging has made one of the funders of the data center, who happens to be on Shark Tank, made him make some statements to suggest that they were like Chinese operatives thwarting his business ventures or something like that. And these two girls just found out. Oh, she's leaving. Leave the microphone, ma'am. Chairs are hard. They're hard. These two girls just found out that the Speaker of the House in that state bought 640 acres of land right next to where the data center is. A couple months before the data center got approved. So let's see. I think it's Elevate_Utah is the TikTok, and I'm positive it's a political arm. Okay, but there's no way these girls figured it out on their own. But just because it takes a ton of not that the girls can't. Don't get me wrong. I'm not saying these girls couldn't have figured it out. I'm just saying that this level of activism and research takes a team to put together. Maybe the two of them did, but let's see. Mean women, young women. I'm 50, so anyone younger than me is a young woman. So, Kelsey, that's a younger woman. And I use girls and females interchangeably, so I apologize if I offended anybody with that, but it wasn't intent. Women can find anything. I imagine they could. I think we're in break right now. Gals. We'll use the term gals. We find everything. Okay, boy, I'll accept that. Where did the witness go? I think to a break, because that's the prosecutor right there, right? And I think she's up there handling the phone call, just queuing it up to the right point for what she wants to play. Attempting to impeach this witness. I think we've gone to break. Judge Boyd usually calls a 15 to a 20-minute break. Let's see here. It's been a long day. I understand. You've got to go. Got to go. 55, I could care less if you call me a girl or not. Awesome. Well, I call Karen Reed Karen Richens and Corey Richens Karen Reed. So I've never been good at calling things what they were. Chair must be uncomfy. No one likes sitting there. I think it's that it doesn't move very well. Like it's sort of like anchored in place. Probably for good reason, but then it doesn't work well when you have to lean into the microphone and you have a quiet voice. Travis Richens, we got that one as well. I think they're just going to impeach her further. That's it. We're just going to impeach her further after the break. I got the tweet that Nate Ayden interviewed one of the owners of the diner. He actually just interviewed somebody else. Hang on just one second. Just got a notification a little bit ago. See, Nate Ayden did a one-on-one with Sky Lazaro. Just about an hour ago, he posted that. I know Corey Richards' brother DJ gave the press a letter the other day. That's up. So at what point do we need to start looking for an Airbnb near the courthouse in Colleton County, South Carolina? Yes, Lori, I threw you under the bus. I'm sorry, not sorry.
I object.
That's the wrong button.
I'm not a camel.
That's also the wrong button. Sorry. I can't see these words. They're too far away.
Is that correct?
That's the one. Where's it going to be? What county is it going to be in? Booked the Airbnb yesterday. They don't even have the trial date yet. I know they want it by the end of the year, but should probably just buy a house there. Why wasn't Corey charged with first-degree premeditated murder? Cindy Stovall. Probably because of the difficulty in proving that. It was sort of circumstantial, the case. There was a lot of circumstantial evidence, but it would be much more difficult to prove, the intent. They couldn't even put the drugs in her hand in the house, really, to, how did he get them? I don't know. So I think it was just the difficulty. They sort of settled with what they knew they could get. And honestly, if you could get life without parole on the charge they did, why try for something higher? I'm pretty sure the jury would not have voted for death penalty for Corey. Juries save that for people they find despicable. She attempted it once and succeeded a second time. It was one of those if at first you don't succeed moments. Witness is back. That's a short break. Put the microphone back on, ma'am. Is Moselle available for sale? I thought it was already sold. Wasn't it sold before the first trial even went to jury view? Sorry, I'm fighting with my chair and a cord on the floor. Renting out Moselle would be a boss move. I don't know. I don't think, first of all, I don't think that the people who would be interested in going there for the true crime aspect of seeing the scene for themselves, I don't think they could afford the fee to rent it out. The payoff's not there, right? It's not. If you owned like a mansion where murders took place, you might be able to sell tickets and tours or something like that. It's strange people do that, but some of us would go. But this being such a big property, it's almost like, you can hunt on it, right? It's larger. It's going to be expensive to rent that out. staying away. That place is haunted. The witness is all mic'd up, ready to go, but we have no audio. So let's give him a minute here. Oh, stand for the jury. Or not. That was for the judge, maybe. I think we have at least one more round of this witness listening to headphones, listening to a phone call. Red, I would love to have that yurt dream become a reality. That would just be amazing. But I think I'd need somebody else to build them for me. I'm just not a builder of yurts. I realize they're probably the simplest semi-permanent structure to ever build. But that'd be a fun live. Ari spends the night alone in the haunted house. It would just be me snoring all night. The neighbors would get scared, but who is this girl? The witness right now. This is Ashley Sanchez, ex-girlfriend of the defendant. Something's happened in the courtroom that she's watching. It's over on the prosecutor's table area. Maybe a huddle of some sort over there. Has anyone else been to the Bexar County Courthouse? The bathrooms are in weird places and it takes forever to get back to the courtroom. I've heard parking is not ideal either. So you have a haunted house, living ghost? I guess if you're a living ghost, you do. The trial is wild. It should be wrapping up here today. Although I do expect the defendant to take the stand. That might take some time. The parking stalls and the bathroom stalls are all poorly designed, apparently. As we have heard by Judge Boyd herself, describing the bathrooms and how they're terrible. They actually had a plumbing issue once in this building where it like backed up for the lower floors, and people were like, well, it's still working on the upper floors. No. That just means that the upper floors are flushing into the lower floors. That's how that works. You remember that day? I think they had to cancel court eventually because the sewage backup issue, and the place smelled terribly. Oh yeah. The Flushing Flashback Friday. Yep. There's a video out on Twitter right now that's going around of a water. Let's put it this way: a tanker truck, one of those short tanker trucks, being struck by a train. I didn't reshare it because the outcome of the driver, the driver, whether or not he survived with serious injuries, was not certain. I don't want to share a video where somebody gets killed in an accident. But that video, the tweet said it was a water truck that got obliterated by this train, and it did, a freight train. But I don't think it was water. That's all I'll say. I don't think it was water. Looking at that, that was not, no. Nope. Let's see. I am Super T says, currently watching Blue Jays, Cardinals, Orchard Oriole, Baltimore Oriole, a cowbird, and other species of feathered friends eating seed and bathing right outside my window, and I love it. Do you have a live stream camera? I love those bird live streams. Yeah, it was dark water, gray water, or green or brown. It was not clean. It was not clean. Those Baltimore Orioles are beautiful. Here we go. We're back. She's like, do I stand up? Do I stand up? Yeah, you can stand up if you want. Of course, that chair is a bit of a bear to wrestle with, so. More people in court today on both sides now.
We're off record this briefly. So, Teresa Conley's funeral, did you all get the information for that? Yeah, it's going to be on May 21st at 10 a.m. And it's going to be at the Lady of Grace Catholic Church. And that's at 223 East Summit. And then there's a rosary. I don't understand this. It says rosary will commence at 10 a.m. on the Thursday. And then the funeral service will follow the rosary at 10:30. So they're doing it all in one day.
I knew Trish had been sick. I'd just done an appeal on one of her last cases.
Oh, a judge passed away. Or maybe an attorney.
He was huge. And we won it on the search issue, but she did a great job preserving that. And I told her to let her know that, and she was saying, "Yeah, I'm really practicing." I was sitting, but she's sick. I didn't know she was that sick though.
But we've lost a lot of good attorneys.
Yeah,
an attorney.
Yeah, I'm sorry. One last thing I forgot to mention that I was.
Apparently, an attorney passed away in the area that was prominent. As everyone who was there, who was a member of the bar, wrote down the details for the funeral services that the judge shared.
Let's bring the church.
All right, to the jury.
Apparently she was sick. I'm not sure if it was like a cancer type situation or just an illness that took her.
All right, everyone, please be seated. And state, I believe you still have the witness on cross.
Thank you. Okay, Ms. Sanchez. And so in that same phone call where the defendant stated to you, I shouldn't have fucking told Antonio Lerma anything. The defendant later tells you that he hopes that he receives probation for the crash. Is that correct?
Correct.
Okay. And then your response to him was that Antonio Lerma just makes everything look really bad.
Correct.
Okay. And then you all kind of start discussing how speed was a factor in the crash, correct?
I don't recall. Put on the headset. Listen again.
Please place the headset on.
Yeah, jail calls being recorded. Maybe the defendant didn't know that, but those might get you. We've updated the thumbnail. It's not bikinis. We went with boxers now. Went with boxers. So I'll show you the new one. I say that right as red is just barely completed, I think. Show you the new thumbnail here. Just one second.
Okay, so do you recall discussing with the defendant that speed was a factor in the crash? Okay, and then after that's brought up, then you all discussed how y'all could just blame the speed on the bullet or gunshots. Is that correct?
There we go.
Correct.
Okay.
And then later on in speaking with him, another great deal of concern for him after the crash, aside from his concern about your relationship with Andres, was whether his car was totaled. Do you recall that?
Yes.
Okay. And so then he told you he believed that it was most likely totaled because the airbags deployed, correct?
Yes.
Okay. And then later on in that phone call, while discussing the crash, you tell the defendant, that's why I keep telling you you need to stop over drinking. Do you recall that?
Yes, correct.
But is your testimony to this jury today that the defendant was not intoxicated on the night of the crash?
He was not intoxicated then.
Okay. And it's your testimony that even though you spoke with Antonio Lerma a great deal of times between March 25th and March 25th of 2023, that you did not have knowledge of the crash.
Yes.
We pass the witness turn.
Defense, any redirect?
Yes, Judge.
You may proceed.
Ashley, why were you so mad at Antonio Lerma?
All the news articles, there were certain ones on the news, Facebook, everything was saying something different. Everything was making it seem like Antonio was trying to save himself, like if he wasn't in the car, like if he wasn't a part of that night. And I was mad. I mean, my kids call him Theo. Your family, why didn't we speak? Why didn't we find out the truth first? What really happened?
At the time of these phone calls, did you know what had happened?
Do I know?
Just with the case in its entirety.
No, I didn't know. That's why I was calling him. I was trying to figure out. I read one article after the other. It was all before I even got in contact with Robert.
The state brought up multiple times that you would do anything for Robert.
Correct.
Why would you do anything for Robert?
Because he's the father of my kids. We should all be honest, and I just believe going and doing the right thing. And I wanted to be there for him to do the right thing.
Anything would imply the wrong thing as well, though.
Would you ever lie for Robert Castillo?
No.
Do you know at the time that Robert told you with some vulgarity in it that he shouldn't have told Mr. Lerma anything? Do you know what that anything he's referring to is?
Well, once we finally got in contact, when I finally got in contact with Robert, I let him know the conversation of what was happening, what Antonio had told me over the phone, and Robert just wanted to really get Antonio help. We found y'all, and that was the thing. That was Robert's main thing. Was Antonio was in the car with me. I was the driver. We need to help him, not just me, not just us. We need to help.
I didn't touch it off actually.
Oh, yeah.
When he made the statement about he just hopes he gets probation, had he consulted with an attorney at that point?
Yes.
Okay. And when he is making that statement to you, just a second.
It's going to be a little louder here. She's hard to understand.
Sorry. Do you know how much he had consulted with an attorney on that?
All right, could I have parties approach?
Do you know how much he had consulted with an attorney? The statement, I hope I just get probation for this. What is that? Oh, it's a truck. Truck and trailer. I'm like, there's a bunch of orange right outside my window. Road crew, I guess. It looks bad because you've got a victim who is deceased. And you're like, oh, I hope I just get probation, meaning I hope I just get a little slap on the wrist. I think it's very much being taken out of context here, though.
All right, the objection will be overruled, and defense, you may ask your question.
Do you know how much she has consulted with an attorney?
How much had he been able to speak with his attorney at that point?
He let him know what he remembered.
No, actually, just answer this question. I'm not asking about what was discussed or anything like that. I'm asking you, had he spent a little bit of time with his attorney? Had he spent a lot of time with his attorney?
Oh, it was a lot of time.
It was a lot?
It was a long.
Okay.
That was the wrong answer.
This phone call that they are referring
answer.
to, do you know where Mr. Castillo was at that time?
I'm gonna drive us to
Relevance.
Defense. He was in custody, obviously. It's a recorded phone call.
Judge, can I just rephrase my question and maybe it'll fix the issue?
Sure.
Was Mr. Castillo in jail when you had that conversation?
I'm sorry, can you rephrase that? I don't know what question or what we're speaking about right now.
Megan, can I see the call that you had? It has the date.
Let me rephrase the question with the answer in it, as she still sort of bungled the answer. Apparently, I think the defense was hoping that they said he had only talked with a lawyer for a little while when he said that. Because she said a long time. They're like, really? Are you sure?
Okay, so the phone call that the state played for you, it was placed on March 29th of 2023. Is this a phone call that was between you and Robert while he was in jail?
Yes.
Okay. Is this March 29th, is 2 days after he had turned himself in?
Yes.
Okay. Had he met with his attorney a little bit at that point or a lot?
I'm gonna jump to Al and answer.
All right, that'll be overruled.
You can answer.
While he was in jail?
Yes.
A lot. Again.
It was a lot?
Yes.
Okay.
She doubles down and got it wrong again. They tried to correct it. Oh. This looks bad.
The state said you had communicated with Mr. Lerma a great deal of times. How many times did you guys speak on the phone?
We had 2 conversations.
We'll pass the witness.
All right, any recross?
Just briefly. So Ms. Sanchez, when you speak about doing the right thing, okay, in your opinion, the right thing would have been for Antonio Lerma to consult you and the defendant before he went and notified SAPD of who was involved in the killing of Mr. Moody.
Right, correct. I want to find out what was going on.
Okay. And so we know that both Mr. Lerma and the defendant left Mr. Moody dead and bleeding out on the side of that Tesla, and in your opinion, doing the right thing would have been to consult the defendant and you
Objection.
before notifying SVP.
This is asked and answered.
All right, that'll be overruled.
You can answer the question.
Can you read that motion?
Yes. After you learn
This is funny.
that the defendant and Antonio Lerma fled the scene and left Mr. Moody there on the corner of South Alamo and Provan, bleeding out, concussing, and hemorrhaging in his brain, that the right thing to do when police were searching for the driver of that motor vehicle, which was the defendant, the right thing to do in your mind would have been for Antonio Lerma to go to the defendant and you before notifying FAPD of who was driving that night.
Correct, this was after.
Okay, so that's the right thing to do, to consult and get your story straight before you go and speak with the police.
It wasn't for their solicitation, it was for me to find out what was going on.
Well, we already know that you don't like the version that Antonio Lerma told, correct?
It was the versions of the news that was popping up, articles from Kent's 5, from KBB, from other people who like to cover,
Right.
these cases.
And that's why you were so mad at Antonio Lerma for going and stepping up and letting SAPD know who is behind that driver's seat of that motor vehicle, correct?
On March 28th, there was an article that said Robert Castillo was the driver and he drove away. That was inaccurate. So
it was inaccurate because he couldn't drive away, so he walked away to your residence on Madison Street, correct?
And this is everything I found out before I finally got in contact with Robert, which was same day later in the evening.
We passed one, so.
All right.
There's like a level of understanding that she's
All right.
missing.
Is this witness excused or subject to recall?
Excuse my defense.
All right. The rule has been invoked. You're not allowed to discuss your testimony with anyone until this trial has been concluded. Make sure you're available if either party decides to recall you. If you'll remove the microphone, please. Defense, call your next witness.
Principal Paul Castillo.
Okay.
Judge, can we approach on that?
Yes.
One more sidebar. This is going to be brother of the defendant. Red, thanks for these pins, by the way. Appreciate it. I don't think the witness understood the impact of the answers she was giving.
Counsel wanted to see me at sidebar.
And instead, in several instances, gave the answer she felt was right, like the right thing to say, without understanding that it's the wrong thing to say and possibly also not the truth. That's the impression I got.
I was kicked back, taking it easy.
Oh yeah, it's Friday after all. We're winding down on a Friday. Not me. I've been sitting here since it's before 10 o'clock, since 9 o'clock. Right? It was 10 o'clock Eastern. Yeah, we've been live for 7 hours now. To another place. I think I'm not sure if it was a language barrier issue with the witness, but she, in some cases, she answered questions with the wrong answer, and even an answer that that was not helpful to the defense. It was just like a little bit of a disconnect, like something was off, either intellectually or on an understanding basis. Yep. No bathroom break. That's because today of all days is brought to you by Depends. It's a great time to mention our sponsor. No, just kidding. That's not. But we don't have any sponsors. But that would be a great one. It's No Pants Friday. Oh, man. I just haven't been drinking very much water. A great bicycle salesman. I'll sell you my bike. I'll tell you that. Do you know what I don't like about... Since I'm now a brand ambassador, or what was it? An affiliate for Pucky Puppy brand of electronic bikes. I can tell you what I don't like. Oh, the judge came back.
All right, ladies and gentlemen, the defense is going to call their next witness. I know they announced another person that they're calling, but they're going to take their witnesses out of order. And no one has any objections to that. Is that correct?
No.
All right. All right, so call your witness.
Thank you, Your Honor. The defense calls Carrie Kearns.
Okay.
Okay. Not sure why. What I don't like about Pucky Puppy bikes is that the you sort of have to pedal a half a turn before the motor engages and detects that you're pedaling. There are different systems that as soon as you apply pressure on the crankshaft.
All right, and I'm so sorry. Parties
It'll
approach
assist.
briefly.
Judge says, wait. This is, what is that? Is that a mini leopard print? What would you call the print of shirt? I'm thinking mini leopard. We need to change the pin now. Yeah. We'll save this pin for later. Hopefully you've got it already because I'm going to unpin it just right now.
Would you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth so help you God? Yes. All right. Yeah, is it bring microphone up swear? Yes. Yes. If you put it somewhere in your shirt, it's good for it to get. All right, if you'll state your name for the record.
My name is Carrie Kern, Kerri, Kern, Kern.
All right, you may proceed.
Thank you, Your Honor.
Red pen's favorite witness.
Ms. Kern, my name is David McLean. We've met before, correct?
Correct.
Okay, and you are a court-appointed investigator in this case, correct?
Correct.
Okay. Can you tell the jury a little bit about yourself? How long have you been an investigator?
So I've been doing private investigations, specifically criminal defense work, for almost 20 years now.
Okay, and your area that you do these investigations is primarily in criminal defense?
Correct.
Okay. Were you contacted by my firm to assist in this case?
Yes.
Okay. And when we asked you to help us, how do we ask you to help us?
You asked me to go and take photographs of a vehicle at the San Antonio Police Department impound lot, commonly known as ground impound.
Okay. Your Honor, can I approach your witness?
Yes.
Ms. Curran, I'm going to hand you what has been previously marked as defense exhibits 8 through 26 and ask you to review those.
Eight through 26. It's better than 1 through 300 that we got earlier in the trial. It is sort of a petri dish print, but more pattern-like instead of random.
What are these pictures that you took at the scene?
Correct. At
ground and pound?
Yes.
Okay. And do these fairly and accurately depict what you saw at ground and pound that day?
Yes.
Okay. There's also, and let me back that up a little bit. So the pictures you took in exhibits 8 through 19, these are pictures that you took initially when you first went out to investigate, correct?
Correct.
Okay. And pictures 20 through 26, are these pictures that you took while you were assisting Greg Pratt, our expert in this case?
Correct.
Okay. And those pictures were taken at a later date?
Correct.
Okay. Do you remember the date on these?
I believe that was March 25th.
Okay.
I think so.
Of 2025?
Yes, correct.
Okay. And do you recall when the exhibits 8 through 19 were taken?
I want to say this was July 24.
July of 2024.
Correct.
Okay. All right. Your Honor, at this time, defense would move to admit defense exhibits 8 through 26 and are tendering to opposing counsel for inspection.
And defense, you said state's exhibits or?
Defense exhibits.
Okay.
I may have said state. I'm sorry.
No problem. I just wanted to be
No
on the
objection,
record.
Judge.
All right. Defense exhibits 8 through 26 are admitted without objection.
Hand this back to you. I'm going to ask a question. Ms. Kearns, the photographs that are numbered defense exhibits 8 through 19, what do those pictures depict?
They depict the vehicle, a white Tesla, and apparent defects, some being bullet holes, apparent bullet holes.
Okay. And that white Tesla is the same white Tesla that was involved in the case that is being currently charged against Mr. Castillo, correct?
That's correct.
Okay. And then the pictures that you have for Mr. Pratt when he was doing his inspection of the vehicle, and those are defense exhibits number 20 through 26. What are they showing?
They are showing, again, Mr. Pratt doing an inspection of the vehicle. They show apparent bullet holes, and then he removed a portion of the bumper.
Okay. Your Honor, permission to publish those to the jury?
Granted.
And Your Honor, for housekeeping purposes, is it possible to hand these so the jury can look at them, or do I need to put them on the overhead?
Oh, you can proceed however you wish to proceed.
Thank you, Your Honor.
You're welcome.
Ms. Kern, is there anything else that you discovered while you were taking pictures of that Tesla?
Can you be more specific?
Sure. So we've got pictures of defects and bullet holes in the bumper of the Tesla. Was there anything else you took pictures of that day?
Just the vehicle.
Okay. Thank you very much, Ms. Kern. Pass the witness, Judge.
State.
Just a brief cross-check. So before I begin, what is your proper title now? Is it investigator, detective?
I just go by Miss Kern.
Ms. Kern? Okay, can I call you Miss Kern?
Yes.
Okay, so I wanted to ask you, so these photos were taken of the defense vehicle on 2 separate occasions, right?
Correct.
Okay. And you said apparent bullet holes. I kind of got hung up on the word apparent. What do you mean by that?
So I'm not a firearms expert, so that's why I would say apparent.
Mm-hmm. Okay. So there's no way you don't have the expertise to say if these are bullet holes or not.
Not in an expert capacity, but with my experience, they are obviously bullet holes.
Okay. So would the technical term be more defect until we can ascertain if they're bullet holes or not?
I'm not sure I understand.
I'm sorry. So since you said they were apparent bullet holes, is the better term right now is that these are pictures of defects in the bumper and the vehicle?
So being not an expert in firearms, yes, I would feel comfortable with defect.
Okay. I'm actually going to show you a few.
Obviously bullet holes.
See if you beat me to it. I have a few photos myself. We may have just a moment, Judge.
Yes.
May I approach the witness, Judge?
Yes.
May I approach the witness, Judge?
Yes.
So, Ms. Kearns, I'm going to show you what's been labeled State Exhibit 60 through 68. Do those look a whole lot like the pictures that were in Defense Exhibit 8 through 20 something?
Judge, just so we have a clear record, I already have a State Exhibit 60.
Yes.
Okay. Do I need to do 61 instead?
Yes.
Okay. If I may have those back real quick.
Get it figured out, guys. Come on. We don't have all day.
That's good. Very good. Very good. Wow. This sounds stupid, right?
Defect is a more broad classification. Whereas if it appears to be a bullet hole, I think you should be say apparent bullet hole instead of defect. Where defect could be like, oh, there's a paint smear there. That's a defect. Or there's a scratch. That's a defect.
Now we got the number and all straight.
Okay.
So can you take a look at State Exhibit 61 through 69 and tell me if that corresponds with picture that you took or evidence or things that you saw?
That's true.
Good. Okay. Judge, this time we'd like to admit State Exhibit 61 through 69 into evidence, pending any objection.
All right, States Exhibit 61 through 69 is admitted without objection.
Okay.
So defense is
Now,
admitting
Ms. Kearns.
more of her pictures than defense did.
So, Ms. Kearns, besides taking pictures, did you do anything else with the vehicle?
No.
Okay. Thank you so much. We'll pass the witness, Judge.
No further questions, Judge.
All right, is this witness excused or subject to recall?
Excuse on our part.
She's excused by the state, Judge.
All right, thank you. You may step down. The rule has been invoked. You're not allowed to discuss your testimony with anyone until this trial has concluded.
Yes.
All right, and if you'll leave, if there are exhibits with you, if you'll just leave them with the court reporter. All right, thank you.
Next, are we going back to the other one? Castillo? She says, I'll send you a bill.
All right, defense, call your next witness.
Your Honor, if we're not going to do Paul Castillo, I'm ready to call Greg Pratt, but we may need a few minutes just to get some pictures and things labeled up.
Sure. All right, ladies and gentlemen, I'm going to give you a 10-minute break while exhibits are marked, okay? Please remember my previous instructions.
All right.
We might be here all night, guys. Ten-minute break. have nothing better to do. It's Friday night. I've got this overwhelming urge to research the cost of yurts now, Red Pen. I had all these numbers and paperwork and even the building plans all figured out before, but now I've sort of let that lapse. I'm sure the cost has skyrocketed. Even though there's not a lot of metal involved, it's mostly wood and canvas. I also need to find the right property. For those of you that are curious, the kind of property I'm looking for to build yurts on is adjacent to a preferably very high-traveled ATV trail. So you can drive from my yurt property to the ATV trail on your yurts or on your ATVs and explore the trail and come back and camp in the yurts. And it would also help if it was also like bordered entirely by federal land. So what is the yurt? A yurt is a semi-permanent tent, wood-framed, canvas-wrapped tent. But nowadays, the ones I'm talking about, specifically the ones from Pacific Yurt, which is the brand I was looking at, you can get them with lofts, with electricity, with plumbing, heat, air conditioning, everything. So they're extremely comfortable little tents out in the wilderness that also sort of make you feel like it's a fancy tent. It's glamping is what it is. Appreciate the judge leaving the courtroom view on for us here. Easier than just staring at the Alamo and wondering if we're ever coming back. Yeah, the yurts I was looking at would not have a central heater or chimney. They would be more, usually there's a skylight, a domed skylight in the center. Tonight's Dateline is about Murdaugh overturned. They're also built on a platform of a wooden deck, a level wooden deck that's elevated. So they're off the ground, so there's no risk of flooding or anything like that. I had the whole idea we were going to have literally a car wash station for ATVs, so you could rinse off your ATV from the mud from wherever you rode through earlier in the day. Had perfect little 72-acre property. I think it was in Mullins, West Virginia, if I remember correctly. Went under contract like the day we called to do the same. Hello, ma'am. I see you taking a microphone. Fixing all the audio. Glad somebody has the audio in their best in our interest. Our best audio interests at heart. What's with all the 3x5 cards that people are handing around? Oh, they're probably photos, actually. I think they're photos. What is that guy carrying? A big old folder. Holy smokes. Looks like a device, like a scanner or... a mobile copy and print center. I have no idea what he has. maybe pictures blown up. Doesn't canvas easily rip? No, it's really thick and quite durable. I mean, like a bear could get through it, but don't put food in your yurt. You'll be all right. Don't store, a quarter of a deer in your yurt. You'll be all right. I spent way too much time, but it may be a sheen beige blouse with a black speckled leopard print. That's the design the witness had. Okay. Love it. Right, you don't want to let it mildew. I believe they also have plastic. There's a liner inside, a vapor barrier of some sort. Oh, those military tents were amazing. Was it like the circus tent style that had the big center wood pole, like the circus pole in the middle? Those were pretty good. I would have done the mammoth skin one, but it's really hard to get a hold of mammoth nowadays. It's the little bit of mammoth skin that is available, museums are fighting over. But maybe with a little bit of DNA creativity and some Jurassic Park technology, we could get some more mammoth skin. So it's a teepee. Am I going to have to show you a picture of a yurt? The teepees have poles that go up the sides of the tent and cross at the middle, and are wrapped in like buffalo hide or something. And they're very tall, easy to stand up in. A yurt has a vertical sidewall that is standing height and then has a peaked top up to a dome on top, with no supports in the middle. It's all the beams from the ceiling rest on the sidewalls, because those sidewalls have lattice work in them. They're bringing them back. We're getting our mammoths. Who gets the first mammoth? And will it be at a zoo? We have yurts for rent in state parks. Yes. Basically the same thing that they offer, because I've stayed in some yurts at state parks. The same as that, but think luxury instead of just economies class. Nice LED lighting, bathrooms inside, plumbing, kitchen, walls, a loft, stairways. You could do like a spiral staircase in the center or something like that. There's just lots of options. What would an elephant think of a mammoth? Hey, cuz. I think that's what he'd say. Hey, cuz, what's up? Cuz as in cousin. So this lady has been fixing all the tech during this break, possibly changing out batteries, plugging things in, changing the settings, to which I'm very grateful. How much for a night to stay at a yurt? Oh, it's dirt cheap. If it's the state park ones, they're smaller because they're like, 20-foot, 15 or 20-foot yurts? I forget their diameter. I was going to do a 30-foot diameter yurt. But I think we paid $15 per yurt when we'd rent them. Mine would probably be more than that. Like closer to 100. Like 75 to 100, depending on the amenities. High-speed internet, car wash outside, all that. No offense, but ATV ride and luxury don't really go together in my mind. Look up the Hatfield-McCoy Trail System. It's in West Virginia, Kentucky area. What is it? I think it's like almost 3,000 miles of trails, and from beginner all the way up to to expert and beyond. There are the numbers of people that are going and riding on those trails on ATVs. First of all, they pay like $75 per person because you have to put a sticker on your helmet that gives you access to ride on the trail for 1 year. They pay that. They have loads of money to spend on ATVs, side by sides, and things like that. So lots of expendables, and they just need amenities to stay at. They need restaurants to eat in. They need places to stay, and that's what the big shortage is right now. Whoa! This would be news. Holy cow. Let me look at this. AG says there's potential death penalty as all legal options are on the table. That's going to be something. So yes, you won your appeal, but it's out of the frying pan into the fire. Missy Russell talking about Alec Murdaugh. South Carolina has the firing squad. Oh, that means they could even carry it out. It might just be bluffing, right? This might just be, I don't know, maybe trying to see if they can get him to take a plea deal, because that would save a ton of money. This is expensive to run that case over again. We're talking millions of dollars. I guess they don't need to do all the investigation again, but it's going to cost a pretty penny. And with bluffing, saying we might consider the death penalty, Alec might elect to not go that route. Yeah, death penalty trial would be even more expensive. They just have to be so careful. There are just more hearings. There are more precautions that need to be taken to make sure everything was done right. And then, of course, all the appeals that happen afterwards. Waiting for the judge to come back from break. You're doing it pro bono. The defense or CDJ? Are you talking about? Would it still be Putin and Harputin? What was his name? I can't remember his name. Would be his same friends, the lawyers? Not Putin. That's the Russia guy. Harputlian, or that's it. Harputlian. I don't think he's a death penalty certified lawyer. I think he's more of like a financial lawyer who's a friend with. EDB calls him Poot. So. Yes, them. The same cast? That would be funny. Defense looks to be doing some strategizing right now during the break. And he's a state congressman. Yes, and he's dropped that influence quite a bit. They're not getting paid. They're just friends. Doing it out of friendship.
Mr. Castillo, do you know my client, Robert Castillo? Yes. How do you know him?
Is he on Zoom?
No. He's your brother. Okay.
We're
and
back.
You're here in the courtroom today, and you're in a wheelchair, correct? That's correct. Okay.
Oh, there he is. I see him.
Can you explain to the jury how you got into the wheelchair?
You got in school and got shot. Road rage incident.
Okay. When did that happen?
1st, 2015.
Okay. And how old were you at the time that happened?
I was 18.
How old was Robert?
10.
So you guys are just about a year apart.
11 months.
Okay.
He's just off to the right of the witness chair.
Since that time, has Robert been involved in your care?
Yes, he takes care of me.
And Paul, how often do you see Robert?
Daily. Everything I do. Me.
Was he there with you right after you got shot?
Yes, I woke up.
Okay. And he saw what you went through after you got shot in this road rage incident, correct?
That's correct.
And he knows all about everything that you've gone through medically, physically, mentally, right?
That's correct.
Okay. Paul, I think that's all the questions I have for you.
State, any questions?
Mr. Castillo, is your brother, Robert Castillo, is he compensated for caring for you? No. Who arranged him to be your caretaker?
Me.
You. Did your mom help in your care at all in 2023?
I do.
Okay. And in 2023, were you living with your mother? No. You were living with him at his apartment?
Yes.
Okay. When he was in the Bear County Jail, did you have to stay with your mom in that case?
Yes.
Okay. And then when he was released from Bear County Jail, your mom had to make arrangements for you to go to Josh because Robert didn't want to take care of you at that time. Is that correct?
Josh.
Yes. Well, when the defendant was released from Bear County Jail, you had to leave your mother's home and go with somebody else because Robert didn't want to take care of you at that time, correct?
I understand.
Okay. You recall when your brother was arrested?
Yes.
Are you having trouble hearing me?
No, I just have trouble breathing.
Okay.
No, I just have trouble breathing.
I'm gonna try to be quick with this. So when Robert was released from the Bear County Jail, do you recall that?
Yes.
Okay. While he was in jail, you were staying with your mom, correct?
Yes.
Okay. And when Robert was released from jail, your mom had to make arrangements for you to go somewhere else, correct?
Temporarily, yes.
Because Robert was only to be released to your mother's residence, correct?
Yeah.
And Robert didn't want to take care of you at that time, correct?
Correct.
We have to witness term.
Paul, that was a temporary situation, right?
Yes.
Because Robert, when he got released, he had to go live with his mom, right?
Correct.
How long? Well, let me ask you this. Does Robert take care of you now?
No, that's irrelevant.
She opened the door, Judge.
All right, that'll be overruled. He can answer.
Does Robert take care of you now?
Yes.
For how long did Robert not take care of you? A few weeks? Months? How long?
At time when he was down.
Okay. And so after he got out and had to live at mom's, you went and lived where?
Yeah.
Okay. And how long were you there?
Yeah. I'm not sure how long I was there.
Okay. And how long after you went there did Robert start taking care of you again?
Came back instantly.
Thanks, Paul. I'll pass with.
No further questions, Judge.
All right, is the witness excused?
Yes.
Excuse from the defense. Thank you, Judge.
Thank you.
All right. It's going to take a minute to get the mic off of him, and then he'll be wheeled out of court. There's the mic, karaoke style. You see, we're still using the COVID covers on the mics. That helps mute the audio effectively. Defense has done pretty well in this case.
All right, defense, call your next witness.
Let's call Greg Pratt.
Greg Pratt.
Yes, if you'll take a seat here, please.
Is he an expert?
You raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, have a seat. There should be a square microphone, gray microphone. If you'll put that somewhere on your lapel, it's for the court reporter to hear.
Is there a clip or?
Yes, it's a clip.
I don't see it.
Not that one.
Oh.
No.
Test. You hear me?
All right, yes, it's for the court reporter.
Oh, okay.
Thank you.
It's not for the general.
Yeah.
Courtroom. Okay.
All right. If you'll state your name for the record, please.
My name is Gregory Pratt.
All right.
And Judge, may we approach real quick?
Yes.
This portion of the trial sponsored by Lipton iced tea, apparently, because just got a front and center positioning. Looks like an expert. Missed all of his testimony. No, there wasn't much. Basically, just his brother cares for him. So the defendant cares for his brother who was shot and paralyzed while he was driving to school. And it was, what, 2015 or something?
All right, defense, you may proceed.
Thank you, Your Honor. Mr. Pratt, could you state your name for the record?
Gregory Pratt.
Mr. Pratt, where do you currently live?
I currently live in Boerne, Texas.
Okay. What is your educational background?
I have a bachelor degree, a business degree.
Okay. Where'd you graduate from?
UT Arlington.
Okay. And when did you graduate?
1987.
After you graduated from UT Arlington, where did you go?
As far as work is concerned, I was commissioned as an officer in the Navy. I was a naval flight officer for 6 years.
And where were you stationed as a naval flight officer?
Pensacola, Florida for flight training, and then Jacksonville, Florida.
And what kind of planes did you fly?
The S-3 Viking aircraft.
What kind of plane is that?
Anti-submarine aircraft is what it was originally designed for. So.
And you said you did that for 6 years.
Yes, I did.
And what did you do when you came out of the Navy?
Well, I wasn't sure what I wanted to do. I wanted to do something kind of fun, adventurous, and challenging without being at sea for 6 months. So contemplated what I wanted to do, and the idea of the FBI popped in my head. And so I applied to the FBI and was selected to be a special agent.
When did you go into the FBI?
I went to the academy on February 1st of 1998.
And just for the record, FBI, we're talking about the Federal Bureau of Investigation, right?
That's correct, yes.
Okay. Can you talk to the jury a little bit about what your training entailed when you first went into the FBI?
So in spite of what you see on the TV shows, it's not quite exactly like that. There's an emphasis on firearms qualification, communication, because we do a lot of interviewing of people and documenting things. So communication is stressed, and then defensive tactics, so that we can effectively arrest people and that sort of thing. So that was kind of the emphasis of the FBI Academy, and then just, how to work cases and stuff like that, and how to process crime scenes. But as I'm sure you'll get to, I was later part of our evidence response team, which requires additional training.
And where was the FBI Academy located?
Quantico, Virginia.
And so when you got done with your initial training at Quantico,
yes,
where did you get assigned?
I got assigned to San Antonio division of the FBI, which I spent my entire career at. Initially, our office was downtown across the street from the Alamo in the post office courthouse building. And then we moved to our new office, which is located near De Zavala and I-10.
How many years did you spend with the FBI?
22 years, started on February 1st, 1998, and retired December 31st, 2019. In federal law enforcement, there's mandatory retirement at 57. I was close to that age, 56 and a half, so I retired.
When you came to San Antonio,
yes,
what did you initially do with the FBI?
So initially, they kind of look at the needs of the FBI and your background, I guess. And at the time, healthcare fraud was a big thing. Still is, I guess. So that's what they initially assigned me to work.
Okay. At some point,
would you like to hear what I worked after that?
Yes. Please.
Okay. So then I went to work working public corruption cases, which is cases that the FBI works when there's allegations of impropriety by elected officials or contracting officers or law enforcement that are acting beyond the scope of their employment. I did that for approximately 10 years. And then I finished up my career working on the Joint Terrorism Task Force, working domestic terrorism cases. And I had a lot of collateral duties. I was a part-time pilot. I was a negotiator. And then a big thing was the evidence response team, which I think we'll probably get more into.
And so you said you were a pilot with the FBI as well?
Yes.
Talk about that.
So I got my pilot's license before I went in the Navy. I was a naval flight officer like Goose in Top Gun, if you've seen that movie. But I didn't have 2020, but I did have my pilot's license. So when the FBI conducts investigations, sometimes they conduct surveillance on subjects just to see maybe who they're meeting with or what they're up to. So that includes both people, agents in cars, and aerial assets. So. And that was a part-time collateral duty that I had.
When did you become part of the evidence response team?
I don't remember the exact date, but I spent about 16 years on the evidence response team.
Can you talk with the jury about some of the crime scenes that you helped the FBI with as part of that evidence response team?
Yes, I worked some big crime scenes. The first Fort Hood shooting, in which Major Nadal Hassan murdered 13 people. There was another active shooter event at Fort Hood, in which 4 people were killed. We worked that as well. I worked the Sutherland Springs Baptist Church mass shooting, in which is it. So Fort Hood was the deadliest active shooter event in U.S. history at a military base. Sutherland Springs was the deadliest active shooter event in U.S. history at a church or place of worship. The processed a vehicle in which 2 ICE agents were murdered in Mexico. Processed a vehicle in which a Bexar County deputy was murdered or assassinated basically at a stoplight here in San Antonio. We had a memorandum of understanding with the National Transportation Safety Bureau, in which the FBI's evidence response team would help them process crashes like plane crashes and train crashes and all that. And we assisted them in processing the deadliest hot air balloon accident in U.S. history, in which 16 people perished when a hot air balloon hit a power line. So there was another case where a guy in Austin was shooting up the downtown in the middle of the night. He shot up the Mexican consulate, the federal courthouse, and finished by shooting at the Austin Police Department headquarters before he was killed by an Austin PD officer. But we processed that scene as well. So those are some examples of the crime scenes that I've worked.
Thanks. I went back and found that as well. He was sworn in.
Quite a few shooting scenes.
Yeah, yes.
Are you familiar with what bullet holes look like when they penetrate different types of materials?
I am.
Okay. When you're going through the FBI's evidence response team, is there like a series of steps that you take along the way?
Yes, there is a 12-step process. I think I shared that with you. Honestly, I don't have it memorized. I've been retired for 6 years, but I did provide that information to you, I believe. There is a methodical process that we do go through. Yes.
So I don't know exactly what the term is for an FBI agent, but is there something akin to a lead detective that the FBI assigns?
Yes, that would be a case agent. That's the agent that is assigned a case and has primary responsibility for investigating that case.
Have you ever been a case agent before?
I was a case agent my whole career, yes.
Okay. So when you're the case agent, you're responsible for gathering all the evidence, making sure the investigation is complete, and
Correct.
doing what you need to do.
Correct.
Okay. And so with the Fort Hood shooting. Were you the case agent on that?
I was, so my job is on the evidence response team was what's known as a collateral duty, a part-time duty. So it wasn't a full-time thing. It just, when something happened, we would have a call out and then we would respond. So that was a collateral duty. And we were working on behalf of the case agents. Okay. So if a case agent is assigned, like the Fort Hood case, but we're just a supporting element to help him. We're like a tool to help him, solve the case and bring it to a successful prosecution with the evidence that we collect. Does that make sense?
Makes sense. The evidence response on the evidence response team, how approximately, I don't need an exact number, but approximately, how many case scenes have you been a part of?
Casings or case?
Case scenes, like
case scenes. I thought you meant like bullet casings. Okay, I got you. I'm tracking with you now. Like shooting scenes, or just in general type scenes, violent crime scenes.
Let's start with in general.
In general, we would also do stuff like white collar crime searches, where we're looking through documents. Not the most glamorous thing. If you include those, I mean, probably hundreds. But then like violent crime scene, dozens. We did a lot of body recoveries of gang members here in San Antonio, Mexican Mafia and others, just body recoveries of those type of cases and other innocent victims. There was a case where we recovered the body of a child that was murdered by its parents. So a whole slew of different types of cases that we were called out on.
You want me to reproach?
Yes.
By approach, they mean sidebar. What's the defense attorney have under his jacket? What's the strap across his chest and over his tie? Wrong answers only. What is he wearing under that merce? A weapon holder? Just a fanny pack. Oh, it looks like a lanyard. He gave it away. Sorry, this is the right answer. It's a lanyard, and the lanyard is put in his pocket inside the suit. I thought it was just a over-the-shoulder strap. Etch-a-sketch holder. Yes. The always useful legal etch-a-sketch for when you get in a pinch and just need to illustrate something really quickly. That's a great product idea. Market an etch-a-sketch for lawyers. It would be a prank gift, but a good one. It's 5:41, Judge. What's the plan?
All right, State, you may proceed. Everyone, please be seated.
Thank you. All right. Sir, what's your title?
What's my title?
Is it still special agent?
Special agent retired.
Special agent
FBI special agent retired.
Can I just call you Mr. Brett?
Yeah. Okay. Or Greg, whatever you want to call me.
Do you mind Greg?
I don't mind Greg. Yeah.
Perfect. Let me ask you,
listen, Greg.
What were your duties on the evidence response team?
Basically, our duties are to document the crime scene as we find it. We do that photographically.
Our duties?
We
your duties?
Do a sketch of the crime scene and sometimes use technology. No, I'm talking when I was in, right, which is 6 years ago. Use technology like survey equipment and stuff like that to sketch the crime scene to exact specifications.
Etch-a-sketch.
So we document the crime scene, how we found it. And then we do basically a survey. We do a walkthrough of the crime scene and just kind of identify potential items of evidence. And then after we do that, we do an actual search of the scene. And then if evidence is identified, then photographs are taken. We will take a long range, medium range, and close up photo of the evidence, item of evidence, and a close up with scale item of evidence. The idea is to show context, like before we do anything, we take a picture of the scene. Like if it's a house, we'll take a picture of the house on the outside. And if there's like a street sign there, we'll try to include that to give context as to where it's located. But with regard to the specific evidence, we will take photos of the evidence, again, long range, medium range, close up and close up with scale. And then we'll place during that process, we'll have a evidence number located near the piece of evidence. And then we will photograph it, do the photos that I just mentioned. And then we will package the evidence and seal it. And that's pretty much it. And we'll continue that process until the search is completed. Once the search is completed, then we take what are known as exit photos to show what the property looked like when we departed the location. We will fill out a receipt for property, which shows what property was seized or taken during the search. And we also leave, the searches are done either through consent or through a warrant. So if it's a search warrant, then we'll leave a copy of the warrant with the individual that's in charge of the property. And that's pretty much it in a nutshell.
Okay. It kind of sounds like, so we're outside the president of the jury. I used to be BCSO myself at the sheriff's office, and we had like crime scene analysis.
Object.
Judge, I'm going to object. That's a sidebar. It's improper.
So I'll move on, Judge.
All right, the objection will be sustained.
So basically, it sounds like you were in charge of going to the scene. I'm so sorry, Cindy. So Greg, it sounds like you were in charge of going out to the scene, cataloging all the evidence that was there,
correct,
making sure it was properly stored, and then returned back to the evidence room or the property room. Is that about right?
Yes.
Okay. Did you do anything after that?
Well, complete any logs that were needing to be completed, and then, be available for testimony.
So basically, go to the scene, collect the evidence, catalog the evidence, transport it away, and make sure it's properly inventoried.
Yeah.
Okay. And after that, that was it with the evidence, right?
Pretty much, yeah.
Okay. Did you do any forensic analysis of any evidence?
Most of the forensics analysis was done at the laboratory.
Okay. Did you do any time at the laboratory?
I did not, no.
Okay. Did you receive any training in forensic sciences?
Yeah, I went through 2 weeks of evidence response team training. Yes.
Okay. But you didn't actually, as part of the evidence response team, you didn't act in a forensic analysis capacity.
Well, we did on certain things like presumptive blood tests and that type of stuff. Yes. And, latent fingerprint photography and lifting prints and stuff like that.
So you did blood analysis?
We would do presumptive blood tests. I presume that you know what that is if you worked at Bear County Sheriff's Office. Basically, if you see a stain here, there's a method through which you can do a swap a sample and determine if that's blood or not. So we would do that on scene.
Okay. What about the confirmatory analysis?
No, I did not do. If you're asking me, was I able to confirm if that's a particular person's human blood? No, that was not done by the evidence response team.
So basically, all of your work was on the scene.
Yes.
It wasn't in the laboratory later on?
No.
Okay. Did you receive any training in ballistics?
Yeah, that was all part of, that's all part of the evidence response team 80-hour course that we go to.
Okay. What was your training in ballistics?
Well, just primarily like trajectory analysis and stuff like that.
Okay. So nothing like striations left by the rifling?
No.
What about, you said trajectory analysis. Can you go into detail on that?
Well, just determining the trajectory, of a projectile, a bullet, which requires, you to have an entry and exit point. that type of training. Pretty basic stuff.
So no kind of like mathematics or anything there to determine the trajectory. The forces of gravity on a bullet, the forces that would change a bullet's trajectory inside of, let's say, human body, because a bullet can hit bone, it can hit organs, and a bullet may go in one part of the body and then exit on the other side.
No.
Nothing like that?
No.
Okay. What about, did you receive any training in tool marks?
In what?
Tool marks or forensics like that?
Yeah, that was part of our training, yeah.
Okay. What was the extent of your training on that?
Well, just recognizing them and documenting the presence of them.
So just basically that they're there, not one kind of tool mark may have left that, a sharp object, a blunt object?
No. Well, no. I mean, we were shown examples of what, these types of things look like, but we were not the folks that made, that did the actual microscopic analysis, if that's what you're asking.
Okay. Thank you.
Mm-hmm.
So basically, your time with the evidence response team was, as we said, evidence collection, inventorying, and processing.
Yeah, and documenting the scene, yes.
It wasn't in regards to analyzing evidence in order to form an opinion based on that evidence.
Well, I mean, obviously we have to do some analysis on scene to determine whether it's worthy of being collected as evidence. But as far as like detailed microscopic analysis, no, we did not do that.
So nothing confirmatory.
I guess it depends on your definition of confirmatory.
And in regard to trajectory analysis, you said that you received training on, basically training on like how an entry wound or an entry point and an exit point.
Yeah, I mean, that's trajectory analysis at its basic level, yes.
Okay. But you are not able to form a scientific opinion because you have no scientific training based on that.
I mean, I can see what direction I can tell what direction a bullet is headed by just looking, at the entry and exit point.
Are you able to tell how a bullet would react in regards to hitting different kind of materials like bone, plastic, different kind of metals? Would you be able to form a scientific opinion based on scientific analysis and evidence on how a bullet would travel or deflect or have its trajectory change based on what material it was impacting?
No, but in this case, I believe that common sense, by viewing the entry and exit points of these holes, would dictate to the common person what the route of the bullet was.
So,
or projectile, the presumed projectile.
Okay. So I'm not trying to be rude or anything, but you're saying that's based on common sense?
Well, it's based on common sense and me working all the scenes that I previously outlined for the court. It's not like I just walked off the street as some knucklehead. I've worked a lot of crime scenes and have seen the trajectory of rounds, and it's through a lot of experience that I've gained this knowledge, experience, and training.
In regards to, so you said you're not able to form a scientific opinion on how bullets would react to different kinds of materials. Would you be able to make a scientific opinion on how different materials react to bullet impacts?
How different materials? I mean, again, I don't have that.
Bullet hits bone, hits metal, hits plastic, hits soil, anything like that. Would you be able to?
I have not done any scientific studies on that myself, nor have I received extensive training on that specific topic.
Just your common sense?
Well, I mean, it depends on the case, right? In this particular case that this trial is about, I believe that the average person and the average trained person, the average professional, would agree with my conclusions on this.
Thank you so much, Greg.
You're welcome.
We'll pass the witness, Judge.
All right, so here's the court's question. Number one, what are you offering him as an expert in?
Crime scene analysis.
Evidence recovery, crime scene or crime scene analysis and in bullet hole identification.
I think he gets that, Judge.
We're not doing any scientific analysis. We're not
And I'm
doing
sorry, you said bullet hole what?
identification.
All right, state. Do you have any objection to him being offered as an expert in evidence recovery?
We do, Judge.
All right, what's your objection? And everyone can remain seated.
Okay, thank you, Mr. Bad habit.
No problem.
So, Judge, this is not lay witness testimony based on someone's observations and experience under 701. This is expert testimony under 703. And there are very specific parts of 703 that require scientific knowledge in order to testify and make an opinion to that. I'm a former BCSO officer. I've done DWI stops. I have taken blood. I've done breath tests. I cannot then testify later on, because I collected the evidence, as to this is what the breath is or this is what the blood is.
My understanding, and I could be wrong, he's just going to be testifying as to what he's done with evidence recovery. And I'm assuming whether or not evidence recovery was done in this case. So let's start there. We're going to take it one step at a time. So is there any objection to him as an expert in recovering of evidence, not doing an analysis of the evidence, just specifically recovering of evidence?
I guess my response is, as designated as an expert in front of the jury, then I do have an objection to that. I think his training and experience speaks for itself. I mean, he's testified that he worked many crime scenes, right? So I think he's able to testify about, you know, what he specifically collected in this case.
All right. So this witness is going to be able to testify about evidence recovery, not analysis, but evidence recovery. Now, the next is crime scene. You said crime scene analysis?
Yes, Your Honor. And basically what I'm talking about here is the inspection of that Tesla. Because that's all he did here.
All right. Is there going to be any objections to him testifying about what he viewed in regards to the Tesla?
Judge, there will be in regards to it being analysis. Like, did he collect and catalog the evidence that he was able to from the scene?
When I'm talking about crime scene analysis and from his testimony, I'm talking about him. If he went to the Grout and Pound, what did he see? What did he do? And if he went to the location of this alleged incident, what did he do when he went to the location?
And what about photos?
Correct? Is that what he's testifying to?
Correct.
Are you all going to have any objection to him testifying to what he did at the location of the alleged incident and what he did at the Grout and Pound? Because that's what the defense is asking that he testify to. Now, mind you, we're not even at the bullet hole or alleged bullet hole yet. We're just doing one thing at a time. So defense is stating that they want him to testify to, I'm assuming, what he did at the alleged location of the incident and what he did at the location at Grout and Pound. Is that correct?
It is solely Grout and Pound, Judge, just so the court knows.
So
I think
Objection to that. I think, so the only objection that I have to the witness is him forming an opinion as an expert that he can definitively say that those are bullet hole defects. That can only be done by forensic analysis. If she's not trained in and not qualified to do and didn't do it.
all right. So then, wait, time out. So no problem with him testing about the recovery. No problem him testifying about the alleged crime scene and about Grout and Pound. But you said he's just going to talk about what he viewed at Grout and Pound. Now, let's get to the bullet issue, or whether or not they're alleged defects or alleged bullet holes. So if everybody can question this witness on that, what is his experience? I know you got into some of it. What is his experience with viewing a bullet hole? Has he ever done any analysis of it being a bullet hole? In this case, that he performed an analysis. So let's question the witness on that, and then the court will make a ruling.
Okay.
Oh, I'm sorry, defense.
Thank you, Judge. All right, Mr. Pratt, you've heard what the court is looking for as far as what's your analysis. So what I'm looking for is, what is your knowledge with regard to bullet holes? What have you gotten through your career as on the evidence response team with the FBI in regard to your ability to determine what a bullet hole is?
Well, as I mentioned, I've worked some of the deadliest mass shootings in U.S. history. There were hundreds of rounds fired at Fort Hood. And
Right, I'm sorry.
Judge has to take a quick phone call. There's conversation still going on. I think it's a phone call. Oh, man. It's 6 o'clock. The judge is mad because we're still here. It's 5 o'clock down there. We might be working. I told you guys we might be working late tonight. Of course, we haven't had a break yet. We need a break, Judge. So do they have? You've got lunch breaks. Do you have dinner breaks? I don't think this is classified. I don't think he's answering questions right now.
All right. Back on the record?
Yes.
All right. Thank you. Mr. Pratt, we went off the record for just a minute there, and we were talking about trying to narrow this down to what the court needs to find out. So, do you have personal knowledge from your experience working with evidence response team for the FBI of seeing bullet holes in vehicles?
yes, I mentioned two of the cases that I worked in that regard. One was the case of the Bexar County Sheriff's deputy. You probably know who I'm talking about. That was assassinated at the stoplight. That vehicle was towed to the San Antonio FBI office, and we spent days processing that vehicle. And the other probably big case that we worked on was unfortunately, I don't remember their names. There was 2 ICE agents killed in Mexico. That vehicle was processed initially by the Mexican authorities where the event occurred, and then it was brought up to our office, and we spent probably close to a week processing that vehicle for bullets. Basically, we found probably a dozen bullets that were previously not found by the Mexican authorities. Again, we spent about a week processing that vehicle. We cut the tires apart. We tore that vehicle apart looking at the bullet holes that were shot into that vehicle by the thugs there in Mexico.
And how were you able to determine that those were bullet holes? I think that's the key question for the court.
I mean, well, part of it is based on, our understanding of what happened in the case. But again, it goes back somewhat to common sense. I mean, what else is going to put a hole like that or a dozen or 50 holes in a vehicle other than a bullet, right? I mean, are you going to go through and just stab it 50 times? That's not likely. It's just the most likely scenario.
Okay, and so your training and experience have aided you in being able to identify bullet holes, correct?
Yes.
Okay.
And in this case, hopefully I'm not getting ahead of myself, but part of the evidence that we had lawfully took from the impound lot, one piece was I cut off a piece of the Tesla bumper, and I took it to a private ranch, a friend of mine, and I shot holes through that bumper for comparison purposes, just to see what this looks like compared to what the San Antonio Police Department CSI folks did, and they looked very, very similar.
And you reviewed videos and all the other evidence that we talked about and we're going to get to. But you've reviewed other evidence in this case.
Yes.
In order to make your opinion.
Right. And part of it is, you don't operate in a vacuum in any of this stuff. Part of it is context. And obviously you don't want to be influenced by certain things that happened or what you're told, but there's always a certain context in each case, a certain set of facts that will logically lead a person to make, a finding, I guess.
As part of the evidence response team, did you obtain technical and specialized knowledge?
Yes. The basic ERT course is 2 weeks up in Quantico, just doing, you receive some forensics or crime scene type training at the academy itself. And then once you join the evidence response team, it's a volunteer thing. Then you are sent to Quantico, or actually Fredericksburg, Virginia, to receive the 80-hour training to be a member of the ERT.
And did you have continuing education throughout your career?
Yes, we would have periodic trainings here in the San Antonio office, usually about once a month or so.
Did you have specific trainings regarding bullet holes?
Yes, we had trajectory training. We had blood spatter analysis training, just general crime scene documentation training. We tried to vary the topics that we trained on.
Did you have continuing education with regard to bullet holes in vehicles?
Yeah. Yes, we did.
Okay.
That was part of it.
So that technical and specialized knowledge is something you can provide to this jury to help them understand what was going on with this bumper and what was happening with regard to this.
Yeah, I think if the jury sees the photographs and videos that I took, they can come to their own conclusions as well. I mean.
All right, thank you. Anything else?
I think he's good. Let
Sure.
him in.
You said it was based, first of all, I was working the night that Sergeant Vance got killed.
Okay, I'm sorry you had to deal with that.
Sorry.
Oh,
so you said that when you're working on the car, it was based on context.
Well, that's part of
that. The firearm was used, and you were able to identify.
Well, I'm just saying that I think my statement was that we don't work in a vacuum. You're aware of certain facts that are surrounding the case, but I think I also said that you don't want that to dictate what your conclusions are.
So you're not able to independently say that those were bullet holes, except that you had information that a firearm was used.
Well, again, it goes back to common sense. I mean, I've seen a lot of bullet holes, and those look like bullet holes to me.
Greg, let me ask you, this pin right here.
Yeah.
This is about the cylindrical object?
Yes, but
hold on. Are most bullets cylindrical in nature?
Yes.
So if I took this pin and I stabbed it into a car bumper about 2-3 times, and then shot into the bumper 2 or 3 times, would you be able to tell which is which?
Maybe, maybe not, but I don't think that's relevant to this case.
It goes toward, you said you have no training in tool marks, right?
No, I did not say that.
He said he did have some training.
Did you find any live rounds, or did you find any rounds of projectiles in the vehicle?
I found, I think one of the items of evidence is a potential piece of a bullet, but.
So you found a potential bullet fragment?
Yes, potential.
Why can't you confirm it?
Because I don't work in the lab.
So you don't have scientific, technical, or specialized expertise to tell whether it's a projectile or not?
I can't tell if that's a projectile, no.
Because you're not able to analyze it.
I'm not what?
You're not able to analyze the projectile, or the alleged projectile.
My job, as I see it, is to collect and present the evidence to the court and let the court decide. I have obviously some experience, and I share my experience and my thoughts, and it's up to the court to decide if what I am telling them sounds reasonable.
Right. So this is what the court is going to decide. Number one, this witness can testify about evidence recovery, crime scene analysis. Am I understanding he's just going to testify to what he did at the ground pound?
May I interject? Also,
No.
what I did at the ranch.
No.
Okay.
And then The court is not finding him as a ballistics expert, but again, he can testify to what he saw in his capacity in his previous capacity in law enforcement. And then states you can cross him however you choose to cross. And defense, I'll allow him to testify, but I'm not having him declared as an expert
In ballistics.
in ballistics.
So just so I'm clear as to what that means,
Can
because I
he
don't
say
want
it's
to
a
cross
bullet
up
hole?
the court here.
Oh, what it means is I'm not finding that he's an expert, but he can testify in his capacity as other officers have about what he's seen.
I just, one caveat with that is what really I'm objecting to is him forming an opinion as to saying that is for sure a bullet or gunshot defect. Like, so I think he's able to say it's an apparent one in his training and experience. Yes. Yeah. But
Yes, he's allowed to say that it's an apparent.
So
bullet
Judge,
hole.
he'll be testifying as a lay witness?
He's testifying not as an expert.
Okay.
All right. Okay.
Judge, if that's the case, then
He is going to be allowed to testify evidence recovery. He's going to be allowed to testify. The defense, my understanding, they're offering him to testify as to what he did at the ground pound. He's allowed to testify to that. He's allowed to testify if he believed this is an apparent bullet hole. He's allowed to testify that it's an apparent bullet hole.
The key word. Okay. Key word, apparent.
Okay. Thank you. All right, let's bring the jurors in.
Got a little spicy there. Got a little spicy. She's like, may I add something, Judge? No. I think the state's going to object to how close he gets to saying they're bullet holes. We'll see. We'll see. It sounds like he's worked in a lot of cases where he's seen bullet holes in vehicles, period, and can tell that there's a bullet hole in a vehicle. Now, can he say that it is definitively a bullet hole? No. It takes a lab to do that, and they'd have to take the car bumper apart and look at the underside, look at the burned edges under a microscope, or test for gunshot residue or lead fouling in the edges of the hole. Look for the stress patterns in the plastic if it's plastic. There's a lot to it, but they should be able to say, I've seen a lot of bullet holes in cars, and they look just like this. But he should write a book, too. It's now 5:11 in Houston, San Antonio, all of Texas. I think all of Texas is in the same time zone, isn't it? Here we go. Defense, lead us through this minefield. It could have been before, for sure. He can't say when it happened.
Judge, here first real quick.
Yes.
Looks like they want to get some guidance from the judge really quickly on what they can and can't do. What would be helpful is if defense is able to get those witnesses that made the video. I guess the video is coming in, and the video is going to say, hey, we were standing here and we heard gunshots and this car crashed into the wall. That's going to help. Now we have bullet holes You have gunshots. We've got a couple people who've said this. Even the state's lead investigator sort of insinuated that they could be bullet holes. They may be. The CSI agent as
Can I
well.
approach?
Yes.
Mr. Pratt, I'm going to hand you what has been previously marked as defense exhibits number 70 through 133. I'm going to ask you to take a look at those.
Okay. I'm going to look at every single one.
Just brief.
70 through 133. Good crap.
Okay.
Okay. Are those photographs that you took?
That was quick.
Out at Ground Pound when you went out to investigate the defects in the Tesla motor vehicle?
They are. I took the majority of the photos. A few of them were taken by Carrie, who testified previously.
Okay. Do they accurately depict what you saw and what was being done out there at Ground Pound?
They do.
Have they been altered in any way?
No.
Okay. Your Honor, defense moves to admit defense exhibits 70 through 133. I'm going to tender those to the opposing counsel. Great.
Now the state gets to look at some pictures and flip through, make any objections they might have. State's taking a little bit longer to go through it than the witness did.
No good.
All right. Any objections?
No from the state, Judge.
All right. Then defense exhibit 70 through 133 is admitted without objection.
Thank you, Your Honor. Permission to publish?
Yes.
Okay.
So it's not ground and pound like in the octagon. It's ground and pound.
Apologize for whatever states there was. Sorry. I'm going to show you a picture of the vehicle. This is a picture of the Tesla motor vehicle that was involved in this accident, correct?
That is correct.
Okay. And is this how you viewed the vehicle when you arrived that day?
Yes. Before we started, so we had a court order to inspect the car and cut away pieces of it as necessary to conduct our investigation. And the first thing that we do, as I mentioned earlier, is we photograph the scene, in this case, the vehicle as we found it, to show what it looked like when we found it before we do any processing of the vehicle.
And as you stated before, we'll leave that there for a second. As you stated before, your training experience, you do a wide shot, a medium shot, and then maybe a close-up shot.
Yeah, and I think the first picture there in that exhibit shows where we were at the impound lot. Just again for context, yeah. For vehicle photos, we don't necessarily take the long range, medium range, close up, and close up with scale is more for evidence. These are what we would call entry photos, or pre-search photos, and we don't do that for that. But we do take it. Photos of the vehicle from, the front, back, sides, and like the corners. And then, so yes.
Okay. During your investigation, where did you find the apparent bullet holes?
In the rear bumper of the vehicle. At least one of which penetrated through the trunk space of the vehicle.
I'll show you a picture here. Can you see? That is a horrible picture. I don't know why it's not coming up better. So on this picture, can you see what appears to be a bullet hole going through that lower part of the bumper?
Yes, there's an apparent bullet hole going through the lower part of that bumper.
Thanks, Selena, for the gifted membership.
Tell us what you're seeing in this picture.
Can you go back to the last picture, please?
Sure.
It's the apparent bullet hole.
And is this picture another angle of that?
Yes. Closer up.
Okay. Now, in this picture, can you tell us what's happening?
So when we discovered that apparent bullet hole, we wanted to kind of see where it went. And rather than crawl under the car, we had the folks at the impound lot lift it up on a rack so that we could more easily view the undercarriage of the vehicle. And I took a picture of it just to show that that was part of the process.
Loves True Crimes, just gifted 5 memberships as well. Thank you very much.
Is this a picture of that vehicle up on that rack?
Yes.
It has been a long day. 8.5 hours so far.
Can you tell the jury what we see here?
So that's what appeared to me based on my training and experience working these scenes. It appeared to me to be an apparent bullet hole exit.
So this is the exit hole from the bullet.
Correct. And that's what you're seeing as part of the trunk.
Excuse me, when there is an objection that's raised, you need to stop speaking.
I didn't hear her start.
Okay. Okay. And if you all speak up so the court reporter can hear. And what's your objection?
Objecting to the witness forming an opinion as to what it was.
All right, that objection will be sustained.
What? He said apparent.
In your training experience, is that an apparent bullet hole?
It is.
What are we seeing here?
A closer up photo of the same apparent bullet hole.
Can you tell us what we're seeing here?
That's an apparent bullet hole with a scale.
Okay, and tell, if you can, explain both to me and to the jury what the significance of this scale is. How does this work?
Well, we always measure items of evidence with scale for further analysis and comparison.
What are we seeing here?
We're seeing what we previously saw as the apparent bullet hole in the bottom of the trunk with the scale.
And so, exactly where is this located on the Tesla? It says the bottom of the trunk. Give us like some relation of where this.
Well, we have the evidence right here. I could show the jury if that's helpful.
Maybe help.
We brought the
we cut away certain parts of the vehicle.
Ooh. We brought the car. Or at least parts of it.
Are you asking me?
Yeah. You recall
what is it labeled? Yeah. Pretty sure that's it, yeah.
I'm pretty sure that's it. You should know if it's the bumper you brought in. I mean, what other items are you going to confuse it with? That's either my lunch or the bumper off the Tesla.
And it's been previously marked as Defense Exhibit 134.
Okay.
I want to ask you what that is.
Yeah.
This is defense questioning.
It's the bottom of the trunk of the Tesla.
Okay. is that piece of evidence, did you recover that at the scene?
I did. Yep.
Did you wrap that?
Yes,
Has that been in your custody and control since you recovered that?
it has. It has. Yeah.
Look at the state looking at each other.
Defense moves to admit the defense exhibit 134.
They want to approach.
No objection.
All right, Defense Exhibit 134 is admitted without objection.
Yes, it was.
Do you have some gloves?
Just because I got to get one. Hopefully I don't.
So we have 3 gloves here and 2 people. We're going to have to fight over them.
Hopefully they're actually large.
Just my size, he says.
Yeah, I get one of them now. It's gonna work.
What size are these? I wear extra large.
The only ones are good.
I don't know if this is gonna work.
Prosecutor says they're the only ones you'll get.
You do it. Don't worry about it. All right. You can't.
Okay. No fingerprint.
Okay. So if we can we unwrap State's Exhibit 134?
Yes. Yes.
Thank you. Thank you.
Okay, we're missing the sideshow. Which
You want me to unwrap it?
Yeah. Okay.
The witness has one glove he's basically got all his fingers barely into the finger holes, so they're all floppy on the end. So he's sort of handcuffed like this in the glove, and the other one he has no glove on. The prosecutor has put on 2 pairs of gloves, or the 2 other gloves. The defense lawyers put on the other gloves, or at least has them, and the prosecution refuses to give him anything else because that size works for me. It should work for you. All right. You must acquit. The gloves don't fit.
Defense Exhibit 134, is this the section of the trunk we saw in that picture?
Yes.
Okay. And you've got a card inside that exhibit that says item number 5.
No.
Okay. And item number 5, is that going to correspond with some pictures that you took at the scene when you were recovering the evidence?
Yes.
Okay. All right. All right. From here.
What do you need?
Good point. I don't need to. Judge, I need bigger gloves.
I'm sorry, what?
Need bigger gloves. It's all.
Oh, those are the only gloves that are available.
Oh boy. Trouble. Okay.
It was collected for the hole in the bumper, not for DNA or fingerprint evidence. That makes a difference.
So, interjection may handle in this?
No.
Anybody? Okay. All right.
So now he's just grabbing it.
Yeah.
Forget the gloves. Just grab it.
So this hole that we're seeing at the bottom of this trunk, is that the hole that we saw the picture of?
It is, yeah.
Okay. All right. So as this piece was laid in the vehicle before it was cut out, would this be the front right corner, the back left corner? Where's this hole located?
Well, I think you can see in some of the pictures. It's the front left.
Front left corner. Yeah. Okay. Thank you.
Actually, is that right?
Can you tell us what we're looking at in this?
So what we're looking at here is where if you can see where my finger's at, That's
Actually,
where
if you would, could you do it on the big screen, just so the jury can see more accurately?
I had surgery yesterday, so I'm
I
moving a
know,
little slower.
sorry, Greg.
So this is where the apparent bullet exited out of the trunk. And this is another area here where there appears to be an apparent strike by a projectile on that part of the car.
Can you tell us what this is?
That's the piece that I cut out for later comparison. The plan was, again, this is pursuant to a court order. The plan was for me to take a piece of the bumper that was not, didn't have any holes in it, and take it out to a range and
Sustained.
Okay. Cool. Tell us what we're looking at.
that previous photo with the scale, that's the other end of the impact. It went apparent bullet trajectory. That's the other part where the end of the scale was at. You can go back to that other photo. Yeah, well, that would be this right here.
Yes. Can you tell us what we're looking at here?
That's the same thing we were looking at in the previous two pictures.
Yeah.
That little cutout there is the presumed path of the apparent bullet.
And then this a close up of the same.
Correct.
Right, and that's with the scale, right?
That's right here.
Can you tell us what we're looking at here?
That's part of the liner in the trunk that has what appears to be an apparent bullet path through it.
Or hand you what has been previously marked as defendant's exhibit 135. Can you take a look at that and tell me what that is from your markings on the front of it?
Yeah. Carpet pad from Tesla trunk.
Okay, is that item number 3?
It is.
And that's the same as you see in that picture right there, right?
It is, yeah.
Okay, can you open that for us? Well, first off, let me move to admit defense exhibit number 135.
Any objection?
Sure.
This is the closest we've come to being able to see the bullet hole.
For the record, you haven't made any kind of alterations or changes to item number 3. This is exactly how you found it when you got it.
I photographed it before I collected it. In addition to that, the lead detective on this case was present during this entire time and viewed everything that we did.
That was Detective Pavelic?
It was.
Okay. And he was present the entire time that we were doing this?
Yep.
You're in favor. Cindy's going to kill us. We keep talking over each other.
Oh, sorry.
Let me finish my question and then answer. Okay. If you could move to admit 135, Judge.
Any objection? All right, Defense Exhibit 135 is admitted without objection.
Could you please open that?
Yes.
To save Cindy's ears, is there a pair of scissors that the gentleman can borrow?
It's like Christmas for me.
He's just tearing it open.
Scissors there.
I'd be happy to open it with scissors.
Okay, it's amateur hour now on the witness stand.
Think about that. So on Defense Exhibit 135, can you tell us or tell the jury what we're looking at here?
We're looking at the pad from the trunk and what appears to be an apparent bullet trajectory through the padding.
Can you describe that apparent bullet trajectory? Is that a straight line, crooked line? What are we looking at?
Straight line.
Okay. And can you tell the jury where that was lined up with regard to Defense Exhibit 134, which was item number 5 in your collection?
It lined up perfectly with that apparent bullet hole.
Okay. And so if we took 135 and laid it inside of 134, it matches up perfectly with that hole.
Correct. Yes.
Straight line.
Yes.
Thank you. Can you tell us what this is?
It would be helpful, item 4, it would be helpful if I had my evidence log with me. To refresh my recollection, can I look at item 4?
Sure. Look, record reflecting you was we previously marked Defense Exhibit 136. Can you tell us what that is?
It's a partial piece of the Tesla trunk.
Is that what's reflected in this picture?
Yes.
Can you tell us what we see here?
Apparent bullet hole.
Okay. And this is in item number 4, correct?
Correct. So what we were looking at earlier was basically kind of an insulating layer, maybe a soundproof layer, and this is part of the trunk. Also, kind of a trunk liner. I would consider this the trunk, and this is the padding, and then this is kind of another plastic liner, basically.
So 134, just for the record here, Defense Exhibit 134 is the trunk, which is the metal part, correct?
I would consider this a trunk, yes.
And then Defense Exhibit 135 is the pad.
Correct.
And then Defense 136 is the trunk, kind of a liner.
Correct.
And Defense Exhibit 136, that hasn't been altered or changed in any way, correct?
It has not.
Not since you collected and wrapped it, right?
I collected it, was witnessed by the other private investigator, Carrie Kearns, and also witnessed by the detective who was out there.
Okay, that was the Detective Pavelli.
Correct. Yeah.
Lead detective on this case.
Lead detective.
Okay. Move to admit Defense Exhibit 136.
Okay.
Defense Exhibit 136 is admitted without objection.
I don't know how we're going to do this. It's now 5:38. I really do think the defendant has to take the stand.
Okay. So as we hold that up, do you see anything in Defense Exhibit 136?
I do.
What is that?
It's the path of an apparent bullet traveling through the trunk.
Okay. And as you saw this in the trunk when you were inspecting it,
yes,
was this on top of Defense Exhibit 135?
Yes.
And Defense 135 was on top of Defense Exhibit 134, correct?
Yes.
And so if we lay this inside, how does this match it? So as you found this,
yeah, there's pictures to demonstrate.
Okay. It just lays on top of it, right?
Yeah.
Okay. All right. And this was item 5. This was the card that was inside the piece of the trunk that you had with the
Yes.
134, correct?
Correct.
Can you tell us what we're looking at here?
That's the hole in the trunk. Yeah.
Can you tell us what we're looking at here?
So I was taking pictures as we were processing the vehicle to show that we were cutting away the trunk at this point in time, just kind of telling the story. That seemed important and relevant to this case. So, and again, we had a court order that allowed us to do that.
Defense Exhibit 107, can you tell us what this is?
Yeah, just a different angle of where we're doing the cutaway. This would be from, I believe, from the driver's side view.
Can you tell the jury what that is right there?
I'm not sure what I'm looking at there.
Okay.
Just a piece of the metal hanging there.
Looks like you're on.
Mm-hmm.
That's what we're looking at there.
That's the pad with the apparent bullet hole.
Okay. And does that have the trunk liner on top of it, or is that just the pad?
That's the pad and the trunk liner.
Okay. Can you tell what this is?
That's the pad or the trunk liner being lifted up from the pad.
And did you take this picture as you were?
Yes, the whole process. I took pictures at each step of the process.
So what were you doing in this particular?
Again, this is when we were cutting away the trunk from the car. So we were just showing that the whole process and the fact that the hole was present in the trunk, the pad, and the liner.
Here, same thing here.
Correct.
Okay. This is item 2 on Defense Exhibit 114. Can you tell the jury what that is?
That appears to be a piece of metal that came loose as a result of an apparent bullet being fired through the trunk.
Is that a close-up view of that?
Yes.
hand you what's been previously marked Defense Exhibit 137 and ask you if you recognize that.
I do.
What is that?
It's evidence item 2 marked as a metal fragment recovered from Tesla located at Groudon Vehicle Storage.
Has that been altered in any way since you collected it?
It has not.
It's been in your custody and control the whole time.
It has.
Move to admit Defense Exhibit 137.
No objection.
All right, Defense Exhibit 137 is admitted without objection.
So we have either
I can.
2 or 3 pieces of the Tesla with apparent bullet holes in them. The jury's going to be able to look at this, and even though the prosecution is like, oh, you don't know it's a bullet hole, right? Putting all this together, it's pretty obvious.
And can you show that to the
This
jury?
car got shot.
Yes. So you can see permission for all judge himself.
Granted.
When is the issue? But it's not as much of an issue because we have testimony of people saying they heard gunshots just prior to the accident. So I think a reasonable person could conclude that there were gunshots, even if they didn't strike the car. I don't think it has to hit the car for him to be able to say a reasonable person would have acted the way I did, and that's all they're going for.
Yes.
I will say that saying it's a shotgun, that was probably the worst thing I've ever heard. A shotgun typically fires like a little, it's not a pouch, but it's a collection of very small pellets up to maybe a buckshot, which is smaller than a marble by about half. And that might fire up to between like 100 of those little pellets, little tiny pellets, or just 3 or 4 if it's in buckshot. Those fly in a pattern, or they move out, like they call it a spread pattern. So it starts small when it leaves the barrel, and the further it goes, the more spread out the pellets are. So a close shot would be, very, very close together. A sawed-off shotgun, like what he described, it would have a wider spread, but still, you would expect multiple pellets to hit if they were that close, or they're right next to each other when he shoots. You would expect, a big hole with multiple pellets if it were bird shot or dove shot or something like that.
Permission to publish the photographs, Defense Exhibit 70 to 133.
Waiting. How much time have we spent waiting in this trial? Loves True Crimes. Maybe it wasn't a shotgun. You know what I'm actually thinking? Maybe it was a paintball gun. Size-wise, it could look similar to a sawed-off shotgun, with the two. They said two vertical, like figure eight. There were two barrels, right? There was the top and the bottom. In a shotgun, the bottom barrel is usually the bottom tube is where the unspent rounds are stacked in a spring and then loaded semi-automatic style into the shotgun where they're fired out the top. In a paintball barrel, there's air canisters and springs and action, things like that, and it could look very similar depending on the type of gun. It would sound very different. Oh, good. Jury's out. I like his tie, actually, now that I look at that. I like the faded checker tie stripes. That's pretty good. The paintball gun would not have made the bullet holes, period. Even at like competition level FPS settings on a paintball gun, you're not going to punch a hole in a bumper. It's going to splat that paintball gun in a second. I don't think they found any paint. We are talking about downtown San Antonio, so it does mean it's probably a real gun, not a fake one, or not a paintball gun. And also, if the two of them were both displaying guns, the odds that the guy with the paintball gun would draw his and shoot at the guy who has a gun he doesn't know if it's real or not, no. They can make an estimate on the caliber size. Like you can know that a bullet hole is not a 357, which is a larger diameter. If it's a tiny little hole, a 357 didn't go through that. But just because it's a big hole doesn't mean it was necessarily a big bullet, because the bullet can tumble when it goes through, and it can make a hole larger than the diameter of its narrowest diameter. Just took off the microphone, so they must be letting out. I live in Greater Atlanta. I know if I heard shots, I would immediately call 911 if someone was chasing me. Why are things blurry? I don't know. Try blinking a couple times, see if it helps. What's he going to do? Is he going to keep that with him? He's taking the evidence home? Well, we're 9 hours here. Let's see. Someone just unplugged the HDMI cable, or plugged it in, it looks like. It says activate Windows. Is this? And she's done. She killed the live stream. I think we might be done for the day. I think we're coming back on Monday. Alrighty then. I'm not opposed to that. We've been here forever. My mods are exhausted. It's time. Tell you what. If she comes back tonight, we're going to watch it on Monday. I'm making an executive decision. Any objections? All in favor, say aye. Aye. Any opposed? No, nothing heard. So we're going to go ahead and wrap it up for tonight. No one can say we didn't put in the effort today, right? It's an interesting case. I want to see the outcome. I hope they get around to it. Oh my goodness. I hope you have some great plans for Friday. I mean, for Friday night. What's left of Friday night? Have some great plans for the weekend. Do something awesome. Make some memories. Take some pictures. If you're going to make pizza, make the one that Thomas made. Make the pickle pizza. And let me know what you think. You only live once, okay? If you don't like it, What's the worst you can say? I once tried the most disgusting pizza of my life, right? You now have something on the bucket list. You can tell a story to the kids, the grandkids. If you do like it, you'll be like, how am I this old and I've never had this before? I was this age. I was today years old before I had. I'm not saying that you're old, but it could be the best pizza you've ever had, and it's worth it. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again Monday morning, most likely, with Judge Boyd. One more time, trying to wrap up this case. I just gave up my Friday night fishing for you, Josh. No. It's. I know you like catfish. They bite at night. You're great. The sun's still up. You're good. You're good. Go out. Hit the dock. Hit the dock. Here's my recommendation. Raw shrimp. It's better than chicken hearts, chicken liver, hot dogs, anything. You're going to catch a million. Take some pictures. You guys have a great night. We'll see you on Monday. Bye-bye.